Hello. Where'd she go? Oh, hi. Lucy was just in her seat, and then I looked, and she's gone. Hold on here. There she is on her little rug. For whatever reason, she's gotten to where she does this. She'll lay on her little rug instead of on her bed for some reason. She's got to be difficult. She's a little diva. She's got to be difficult. Hello, welcome. I'm putting on the court screen, but it looks like right now we're just staring at popcorn ceiling. Let me unmute it in case we get a hot mic moment. You know I love those. Good morning, everybody. Hello. I am a couple minutes late because, honestly, I just don't have my life together this morning. That's the honest reason as to why I am late this morning. I just don't have my life together. I am, why are we, like, we're just all kinds of struggling, aren't we? Here we go. We're going to make this work. I am functioning on very, very little sleep right now, which is fine. It's all for good reason, but I will tell you that even with medicine today, it's going to be a journey. We're going to see how it goes. I am so tired. I am so tired. So we're going to give it our best shot and see if y'all see me snoring, mind your business. I will try to mute my microphone if I'm about to fall asleep. It'll be good. It's going to be a good day. It's Monday. It's like the 7th best day of the week. So it's great. I see we have a new member. Kathy L, new member. What happened to my sounds? It didn't come on. Do we just become best friends? Yep. Why isn't it on? Why aren't they on? What is happening to my sounds? What is happening to it? I restarted everything before I did it too. I don't know. Oh, this is trying to connect to my thing. That's why. Let's see if I do it manually.
What? Did we become best friends? Yep.
There we go. Okay. So we're best friends. Hello. Good morning. Welcome. I hope everyone had a great weekend. I think it just went by so fast. It went by so fast, y'all. Yesterday I did, I worked on the podcast all day long. And by all day, I mean until about 3:30 o'clock. I was about to say 3:30 o'clock. That's not how talking works. Okay, but till about 3:30 a.m. and then went to bed. I got about 2.5 hours of sleep and then was back up getting ready for the day. So it is going to be, y'all, I am so excited about the second episode though. It took so much time, but it's going to be such a good episode and it's such an important episode. If you haven't checked it out, Conspiracy in Canton, it's a labor of love. I've spent so much time going over it and it's just, I really am super excited about it. Episode 2 is going to be, it's a fresh new week, Erica 843. It's a fresh new week. You can say that until they get here. And then y'all are all going to be in timeout for saying it. Once the jury's here, you're not allowed to say anything. But I am, the first episode was like an introduction as, into the case and like, kind of the overview of it and the original questions that, I had and like the kind of talking about the controversy that everybody has over it. The second episode is nuts because it's, I went through and pulled all of the original statements and interviews and all of that stuff that's supposedly from all the people involved in the very beginning. And I go through the timeline and I point out all of the inconsistencies and all of the things that literally changed as those first few months were happening. And it is wild, y'all. I'm so excited. It's going to be a very important episode, and it's worth the sleep deprivation to make it right. Tag new member. Oh wait, I have to do it manually again. Hold on. Let me pull. You were already a member, weren't you?
What? Did we just become best friends? Yep.
Yeah. Best friends forever. I am glad you are here. We are glad to have you. I feel like you were already a member, but we are glad that you are back anyway. Brandi, you need to stop staying up so late. I know. Ugh, I know. But there is time to sleep when there's time to sleep at some point. Out of the shower, fresh as a daisy. Get it out now while y'all can. As soon as that jury gets there, you're not allowed to say these things. Can't say fresh, can't say perimeter, and can't say trial. Now that's a new one. That one's added in. So the Candace Off, the new episode will be tomorrow. I decided that Mondays are not a good day to put out new episodes because that puts too much pressure on me on the weekend. So I like to have that extra day on Monday to finish up doing whatever I need to do and then record and then drop it on Tuesday. So you also can't say, you can't say that either, Polly Frazier fan. You cannot. I get tired of that one too. I know that we tried to, kind of catch just the very end of, I followed the updates on that hearing and stuff, but oh man, I did not miss streaming that. That one was a tough one. It's such a trial to not say we need to set a fresh perimeter. Yeah, you just 3 strikes, you're out. Somebody put her in timeout, Lady in Gray. I'm just joking. Just joking. All right, I'm so excited. Y'all are here to watch paint dry. And ironically, it was ceiling paint, and here we are staring at the ceiling. So it's all good. I have gotten this question a lot. The podcast is available anywhere you get podcasts, like Apple Podcasts, Spotify, any of that stuff. I do have the episodes on YouTube as well. JT Brother Brewmeister is he's the best. He uploaded it on YouTube as well. So there's a section on the channel for the podcast. So it doesn't have the pictures on the podcast. It's just the album cover, but you can listen to it there if you can't listen to it in the other avenues. Let's see. Oh, the Canton Select meeting that the juror was talking about the other day. Nothing about Karen Reed. Yeah, they had that. What was it, Tuesday or something? I don't know. All my days run together. Did you see him when they the lady was trying to talk and they just cut her off? All right, y'all ready to get up out of here? Yep. Motion to adjourn. Yep. A second. Yep. And they're they just cut her off and we're done. And people got rowdy. They got mad. They're over it a lot. With that, they're over it. It's such a wild case. It's so wild. I'm excited to be able to put my own spin on it, the way that I like to deep dive into things, because I'm not and I even said in the first episode, I'm not the first to the scene. I'm not the first person to report on this. there's not a lot of local coverage on it, and the local coverage that there is very surface level, from what I've been able to find and from what the locals have told me. So, there are, there are people covering it, but I cover things in such a different way. The way that I organize the information is just, I try to put it all together instead of in pieces, like some, like we hear on news stuff or whatever, and then, present it that way as like an entire picture. So I'm excited. And I have, as far as all of the investigation stuff for the, looking at all the court documents and putting all that stuff together, I did all of that like separate from anybody else's coverage, because I didn't want, before I listened to anybody else's stuff on it, I didn't want to be swayed. So before I listened to or watched anybody else, I went through hours and hours and hours, went through the court documents and kind of put it all together, and found inconsistencies and found things that didn't add up and found things that didn't make sense. And then started kind of questioning things, and then, and then started kind of paying a little bit more attention to each side and what they were thinking. So it's wild. It's wild. And there are things that, I see on both sides as, holes that, things that don't make sense. And there are things that I see on both sides that are, well, I mean, there's a whole bunch of holes. There's so many holes, so many things that don't make sense. Let's see. Had to go to DMV to renew my license. Good until 2032. 2032. That's actually not as far away as we think. When we, like, that's really not as far away as we think. That's crazy, isn't it? That's crazy. Making sure that I am still alive here. Coffin Daffer decided today that Chloe has been found. Here's my thing. With Coffin Daffer, I have the utmost respect for her career and the things that she has done. That is something that deserves respect. I disagree with her analysis of the phone data. And I know that she said that she has been a cell phone expert, but they specifically said that this is a new version of software that is brand new and wasn't even available at the beginning of the trial. And you can't be an expert on that. You can't be an expert on something that's brand new if you aren't it's like, look, my daddy, he could fix any car you put in front of him. He like built old muscle cars. He taught me to build old muscle cars. I built a 1970 Chevelle Super Sport, put a 454 crate motor in it, built it from the ground up. Like that was, that was his thing. But if you put a Tesla in front of him with all the new gadgets and gizmos, he ain't gonna know what to do with that. It's something totally different. It's I would never take anything away from my dad's, career. God rest his soul. Like he worked, he was an amazing man and did amazing work on cars, but I would not go to him if he were still here with, Tesla problems and ask him to, fix it because he knows cars. Things change, technology changes. So you can't be an expert on brand new stuff because you are an expert on the old stuff. So while I have the utmost respect for her career and what she's done and, think she's a smart lady, I also disagree with her analysis because to me, there's no way that if you open your phone at 2:37 and Google how long to die in the cold, you can explain that away by saying, oh, she did it later on. And it skipped all these other searches in between and all these other things in between and just happened to jump right back to 2:37. To me, that's not logical. So I just don't. I just don't agree. Just like reasonable doubt has to be reasonable explanations have to be reasonable too. So, but, and, I know, FBI is, retired FBI is great. Proctor's father-in-law is retired FBI. So I'll just leave that right there. All right, here we go. We're going to watch paint dry today. We're going to watch paint dry today. Oh, well, nope. They faked us out. Like, you know what? I don't think this paint's dry yet. It hadn't lost its pink hue yet. Let's look up there. Oh, goodness gracious. I think it's actually kind of ironic that we have white paint in here today, too. I mean, not just today. White paint is one of us, but there's so much talk about white paint. Yes, 70 Chevelle Super Sport is my dream car. You want to see it? Hold on. I'll pull up pictures. I think I have it on my Facebook. Painted it pearl white with pink SS stripes. Let me see if I can find it. This is it. This is the before. It was like mustard yellow when I got it, but the floor pans on it were solid, and it's so hard to find solid floor pans on like with no rust. They had like, you can see like I was grinding out like some rust areas right here, and I had to do like a couple little patch panels, but overall it was not bad at all. And you can see that was that. It was like it was something else. I loved that car. And then that was a different one. Oh, that was the interior. So I ordered new interior for it. Oh my gosh, that was my little baby when he was just a little bitty baby. Let me see. I don't know what else is on here. Let me not just flip around. There we go. So I painted it pearl white with pink SS stripes. It was actually called Magenta Pearl was the name of the color. And I painted it myself. Did all the body work myself. I loved that picture. I mean, I loved that car. But that picture shows from the best angle. Beautiful car. Beautiful car.
Hampshire County Superior Court is now in session. May be seated. Wendy Colton, please.
Good morning. Now before the court is Hampshire County Indictment 1180 CR 0128 Commonwealth versus Cara Rintala. The matter currently on trial.
Morning.
Good morning.
So, where should we start?
Yes, the Commonwealth represents they're going to call Alan Weishart first. And so we do have this motion in limine filed at the beginning about Lieutenant Weishart. And I think we're agreed that the first part, the Commonwealth, we moved to exclude the booking video. I think everybody agrees that will be out, so we don't have to argue that, I think. The second part is, as we lay out, Lieutenant Weishart's characterization of Ms. Rintala's behavior, or change in her behavior, really, at the moment he tells her that he's going to arrest her. It's essentially, he characterizes it as her demeanor flipped pretty quickly. I'm reading from prior testimony in a prior trial. Her demeanor flipped pretty quickly toward me. She went from calm and collected to, I could say, calm and cooperative to more of an aggressive, very angry, demanding, and basically told me I was not going to arrest her for that. That's a quote from the first trial. And it's our view that that should be excluded. Any characterization of her demeanor by Lieutenant Weishart should be excluded. And to set the stage very briefly, that happened prior to the video starting. That was in the lobby of the Granby Police Station. He then immediately took her to the booking area of the Granby Police Station where the video taping begins. And when we received this video,
Hold on. I'm going to see if I can do it on this one so I can do the better.
we discovered that her demeanor there from the very beginning is not any of the things he's describing. To the contrary, she looks emotional, scared, and upset. And so our perspective is those are incongruous. They suggest something that we should be investigated. They suggest the possibility that Lieutenant Weishart has a bias. He's mischaracterizing her demeanor, and that's something really because of the discovery delay here. That's something we would have investigated, but didn't have a chance to investigate. So the remedy didn't have a chance to investigate. In other words, why is he biased? If he's biased, if he's mischaracterizing her demeanor, why is he doing that? So we think that's important. Obviously, bias is a big part of this case. In other words, to flesh it out a bit more, he's a senior police officer in the Granby Police Station. Cara is a first responder from Granby. They know each other. They have they know each other from the first responder community in Granby. So there's a history there. And I don't think it's unreasonable to speculate, or it's not speculation, it's unreasonable to suggest that he might have a preconceived idea about Ms. Rintala, either because of her relationship with her wife or something else that causes him to have a bias. I'm not suggesting I know any of that. What I have is this one new fact. He says that in the prior testimony that she flipped like a switch. She became angry at him for charging her. And then we now have this new video that shows right after that, immediately after that, she's not angry. She's upset and emotional. And so the question arises, is this consistent? What's going on? Is he making up this characterization of her as angry? And that's obviously prejudicial, her being angry. So that's the basic idea, that as a discovery sanction, we don't have a chance to investigate this issue. And so we submit that testimony should be stricken or precluded.
Okay. Commonwealth?
Yeah, just to make sure you understand what Chief Wishart would testify to. He testified in all three trials before anyone knew there was a booking video in regards to Ann and Cara arriving at the police station on September 27, 2008. He testified, and he is expected to testify today, that Ann arrived first. He had a conversation with Ann, after which Cara arrived, and Cara was in the lobby at that point in time. He then had a conversation with Cara, the defendant, in the lobby at that point in time. He has testified and is expected to testify when she originally arrived at the police station. She was calm and cooperative. He had a conversation with her, during which he asked if what had happened at the house, which had compelled him to come to the police station, if there was anything physical that had happened. She denied that. She said it was verbal only. Chief Wishart then went back to Ann, who was not in the lobby area, but in the interior of the police station at that point, to confirm the content of what she had indicated to him, and the content would not be coming before the jury. After which, receiving that confirmation, he then made a determination to place the defendant under arrest. He then went back to the lobby area where the defendant remained at that point in time, and then told her that he was placing her under arrest for assault and battery on Ann. He testified that it was in that moment when he said, "I'm putting you under arrest for assault and battery," that she flipped and she switched, that her demeanor changed from calm and cooperative to aggressive to angry, demanding, and that her body language toward him changed, and that she then made a statement to him, "You are not arresting me." He then said that again while they're still in the lobby. He said, "I am arresting you," and moved forward towards the arrest. And he's testified consistently that after that happened, she immediately went back to being calm and cooperative. In other words, it was a brief moment in time where she had this change of demeanor. He made clear she was being arrested, and she did not physically resist and did not continue to fight that arrest after that period of time. They then walked from the lobby, which is not recorded. Those interactions are not recorded. They walked to the lobby to the booking area. And in the booking area, Chief Wishart has consistently testified she remained calm and cooperative throughout that process. The booking video that we recently received corroborates everything that Chief Wishart testified to. And what I mean by that is that moment in time of the booking that is on video, which he has testified to about previously in the booking room what happened, and he would be asked to do it again. It corroborates not only her demeanor that he said at that point she was calm and cooperative, but all of the events that happened as well. So there's nothing contrary or inconsistent with anything he's testified to previously. The interaction about the change in demeanor is not on the booking video. He's always indicated it was a short moment in time in the lobby before they went to booking when she became calm and cooperative again. So in terms of the bias that could potentially be explored from Chief Wishart, excuse me, as Attorney Wood just indicated, if they know each other and such, that can be explored on cross-examination. Nothing about this booking video changes the ability for counsel to potentially explore that if they want. It doesn't create any additional evidence that didn't already exist in that regard that they could potentially try to ask. So for those reasons, and again, we're not trying to put the booking into evidence. I understand the defense will not be asking about the booking video with this witness, but you should be allowed to testify about what he observed that is not on the booking video. And her demeanor when she arrived, the change, and then back at booking.
Okay, thank you.
Could I just add one very brief point? Very briefly, it was suggested that the booking video was just suddenly discovered. Relevance to the late disclosure. In the video itself, Chief Wishart, who's the head of the booking department, makes reference to the video. He several times to make sure the video is on. So it's always been odd to us when we learned about this that our point is we're skeptical that he just learned about this because he's clearly referencing the fact that there's a booking video system when he's doing that booking, and so it's odd to us that this was suddenly produced. That's the last point. Thank you.
Okay, so the video was produced late. I think the Commonwealth agrees that an appropriate sanction for that is that they not be allowed to use it as part of their case in chief. But the defendant has always had an incentive to investigate bias as to any of the Commonwealth's witnesses. What I'm hearing is that the video may not even be inconsistent with the testimony of the officer, and if it is, the defense is free to use it. So the first part of the motion is allowed by agreement, but the second request is denied.
No objection. Thank you. I guess one other issue, I guess the Commonwealth is requesting, I haven't seen anything in writing. They did? Okay. An instruction, the standard, a model instruction on defendants' other bad acts, I guess pertaining to this arrest. And I just want to note, I'm looking at Appendix 4Y, the Massachusetts Jury Trial Bench Book, 5th edition. It has what I guess is a model instruction on this issue, the cautionary instruction on prior bad acts. And I want to our only issue is with the first, given the unusual circumstances here, and to set the stage very quickly,
What's that
there will
noise?
be no testimony about the nature of the alleged crime here. It will just be Lieutenant Weishart, Chief Weishart, testifying, I placed Ms. Rintala under arrest for assault and battery. Everybody agrees that what then happened after she was arraigned, the charges were dismissed. So there's no dispute that that happened. So the language is, you are about to hear testimony about certain acts allegedly committed by the defendant. And our problem with this is certain acts allegedly committed by the defendant. Our problem is everybody agrees that those charges were dismissed. So what we would propose is an alteration to that model language in these unusual circumstances. You're about to hear testimony about certain acts that the defendant was charged with, and were later dismissed. Period. That would be our only modification to the model cautionary instruction.
So I received some proposed instructions from the Commonwealth this morning. I have two. I don't think I have one that relates to
It ain't
the
me.
subtitles,
Yep.
and then another concerning the prior proceedings. I don't have.
I don't either. So I'm being told that they did file something, but I haven't seen it.
We did not file
Happy
anything,
Monday.
Your Honor. I spoke to counsel
Okay,
this
sorry.
morning
Sorry.
about whether or not we wanted to jointly propose any language for Your Honor. Counsel indicated to me that they assumed Your Honor would give the instruction that's being referenced in Appendix 4Y. So we did not move forward with filing something and trying to agree on language. To the extent Your Honor is giving a prior bad act instruction, I certainly obviously believe that is appropriate on a number of issues that will come into evidence today about the prior history between the defendant and Annamarie Rintala. We would ask that in terms of your indication about what purposes they can consider it for, there was recently some case law that it's important to identify the specific things that's in that long string, as opposed to reading all of them. So we would ask that Your Honor include that they may consider the act solely on the limited issue of motive, state of mind,
It's like a jackhammer.
and the nature of the relationship of Cara Rintala and Annamarie Rintala, which we believe are the purposes for which it's being admitted. As
Mandy,
indicated
welcome.
in our-
What? Did we just become best friends? Yep.
We would ask that those be a list of limited purposes for which they would consider this
Okay.
evidence.
So I have an instruction prepared in the way so it's similar, but I indicate issues of motive, state of mind, and intent, and as to whether there was a hostile relationship between the defendant and the alleged victim, which I think is more specific than the nature of their relationship.
That's fine, Your Honor, the Commonwealth is content with that language.
But in terms of talking about certain acts allegedly committed by the defendant, did you agree with defense that all this witness is going to testify about
Morning.
is an arrest? That so none of the facts none of the underlying facts are coming into evidence through this witness?
Correct. And would not be expected to come in through any witness. In other words, what Annamarie alleged to cause the police to file an application for a criminal complaint and for that criminal complaint to issue. The purpose of the assault and battery, the fact that she was charged with that,
It's
her
crazy.
actions being charged with that, the outcome of those proceedings is relevant to all of the issues of intent, motive, and state of mind, and the hostile nature of the relationship between them. But we would not be seeking to admit the underlying facts as alleged by Ann that caused the police to make that decision.
Okay. And so rather than you were about to hear testimony about certain acts allegedly committed by the defendant, what would you propose?
I would be fine with the language proposed by Attorney Rich, which I understand is you're about to hear information that the defendant was charged with a crime of assault and battery on Annamarie Rintala, and that those charges were later dismissed. I think that's factually accurate as to what they would hear. I also want to alert Your Honor that through this first witness, they would also hear testimony that a restraining order issued, that Annamarie applied for a restraining order at the time of this, that a restraining order issued against the defendant. They would be seeking to admit that physical restraining order that issued in the terms of that restraining order, which would also indicate that it was.
Sorry.
Y'all.
I'm speaking close to the
Sure.
microphone because it's picking up my jackhammer.
It is a jackhammer.
Our chief is.
You're right.
Check on it.
The terms of the restraining order that included to give custody of Brianna to Annamarie. And then the restraining order did not continue after those couple of days when it went back to court. So the Commonwealth would be seeking to admit the restraining order itself, the fact of the restraining order issued, and also through this witness that he filed a mandated report to the Department of Children and Families. So just to make sure Your Honor understands the full scope of the issues that he would testify about.
Okay, so this instruction though,
Oh my God.
would the instruction cover that as well? So this is all coming in through this one witness?
This is all coming into this one witness specifically about the date of September 27, 2008. Yes,
Okay, all flowing from that charge.
yes.
Your Honor, I don't want to jump in. I have one narrow issue with this proposed instruction. The nature of the hostile relationship between the defendant and the decedent. We would not, our problem with that is just that there's an assumption that there is a hostile relationship.
That's not the wording.
Okay,
The wording is whether there was a hostile
oh, okay,
relationship.
that's fine. Yes, that's fine.
I don't use the word, the nature,
Okay, that's fine.
that term nature of the relationship.
I misunderstood. Thank you, Your Honor.
That's another word not to use, nature.
So do you want me to make reference to that, or I guess it all flows from the charge itself?
It does. And I will say in the prior trial, Judge Brook made a broader instruction because she wanted to include that the jurors should not improperly infer from the fact that a restraining order issued anything about that fact. In other words, that they should not speculate about what information Annamarie indicated to the police or the judge to issue the restraining order, or the fact that a restraining order issued is no proof that there was abuse occurring in the relationship, but that they would be able to consider the fact that
Oh
she
my
applied and the restraining order issued on the issues of state of mind, intent, motive, and whether there was a hostile relationship between the parties. So again, I don't know if the defendant is requesting this.
We would join, I don't know if that's a request. We would request that language as well.
Okay. So do you want me to give that? I don't recall from the transcript, and it could be different this time, whether this is all going to come out at the same time, and whether I should group this together, or whether I should address the restraining order separately. I also don't want to confuse the jury, so they should understand that the defendant was charged with assault and battery, but that charge was later dismissed. But a restraining order did issue, so my instruction there is that they shouldn't infer anything from that, but they can still use that as evidence, or they can still consider that as it relates to the defendant's state of mind, intent, motive, and whether there was a hostile relationship between her and the alleged victim.
Which I think what happened in the last trial, and I think it makes sense to do it this way, is that the witness testified on direct to all of these facts. And then in a single limiting instruction, Judge Brook was able to address the various issues about how they could consider that evidence.
Okay.
Which was done before cross. So it's helpful, I think, if they hear the evidence and then it's limited.
All right, so it's not that they're about to hear this, they've heard it. And I will address I'll give the instruction, and then at the end of that, I will just make those additional comments about the restraining order, because there's a distinction there.
Your Honor, we would request that you give these cautionary or limiting instructions before Chief Weishart testifies.
Okay, I think they might, so if we were just talking about one thing, like the arrest, I think that would make sense. I'm just a little concerned I'm going to give them too much information about something that they haven't heard about. I think it might be easier for them to understand if I give it immediately after. Contemporaneous, it just comes right after that. So, and that's why I wondered whether it would make sense to sort of maybe start with the basic instruction, and I can make the point about the arrest, and then afterwards, because they've heard the arrest, but they've also heard these other things that sort of flowed from that arrest and charge, including a restraining order that did issue, I can add that. If there's an agreement, I'll go along with it. You know the case better than I do, but if there's not an agreement, that's sort of how I'm feeling it would work best.
Your Honor, I agree with 95% of what you're saying. Just we've stated our position that we think that on balance, the entire cautionary instruction before Chief Weishart testifies would be better. We've made our position. You've heard us on it, and I don't want to defer. I'm not saying I'm going to defer to you. What I'm saying is, to the extent you don't follow our request, I object. But I also want to make clear I agree with the substance of what you're suggesting.
95%. And just for the future, it's always better if you can give me something in writing, because
Absolutely.
I'm looking at my scribbling and
I agree as an appellate lawyer. I completely agree. I was given this assignment this morning at 9:20. I apologize, Your Honor.
okay. So
Judge is like,
you want me to
okay.
take it up with your supervisor.
I do, Your Honor.
I don't think I'm a supervisor. I don't think that is.
All right. So, anything else on that?
No,
Not on the limiting instruction, Your Honor. I do think we wanted to try to discuss the proposed exhibits that the Commonwealth will be offering to the next 4 witnesses, which would be Alan Wishart, Lynn Menard, Barb Fenn, all from the Granby Police Department, and then Nancy Kaufman, Ann's aunt, which is essentially the bulk of the Commonwealth's evidence regarding the alleged prior bad acts and the nature of the hostile relationship between them. We have a number of exhibits that we sent yesterday to the defense counsel indicating what we wanted to admit today. And I understand that there are some objections to certain of those. We were hoping to argue those objections so Your Honor can rule on them so that we can pre-mark anything that will be coming into evidence. So we'll move more smoothly with the witnesses as opposed to going exhibit by exhibit.
It's so loud. Imagine how loud it is in the courtroom.
Sure.
We got the exhibits, we sent back our response to the Commonwealth in terms of, first of all, I can't agree because we objected to any of this evidence coming in and need to preserve that objection. So I'm going to ask the court for a continuing objection for all of the prior bad acts evidence, the restraining order evidence, the 2008 to 2009. Pretty much every witness today except for the phone records that's going to talk about prior bad acts. So we said that specifically made
Nurse for God gets 5 memberships.
Other exhibits, and I don't think we have to deal with the phone records now. So I think we're going to try to deal with the phone records before the jurors go back to lunch. But as to these other exhibits, there were specific objections that we made. I think you have a
Thank you, Nurse for God.
I just put my phone back on. That's it. It was an email last night. So first of all, we can't have a continuing objection to all of the testimony of all the witnesses. So I think make sure the record is clear on that.
That has to be so loud. If we hear it like that,
Then Judge, the other issue that
So I'm sorry. I don't, so are we going to take up these
yeah,
objections
I'm
now?
just going to get my notes on my phone.
Oh, okay.
That was my point, Judge. Just the
Okay.
Notes on the phone. I didn't make that clear, and I apologize. That's the text that went back and forth last night.
No need.
So.
I think the cameraman has the sniffles too, because I'm hearing sniffles when I'm not sniffling. Like I feel like I'm going to sneeze, but I'm not like sniffing. I think he has the sniffles too. Sniffles, jackhammers,
The other thing was the
ceiling paint.
We don't have to deal with right now. Okay, so that's not going to get any first one. So then, Judge, I would agree. If I could have a standing objection to all of the exhibits regarding any prior bad acts, restraining orders, and assault and battery, I think that will cover the objections that I had. And to the extent that the court's going to overrule that objection, then I guess they could pre-mark the exhibits. But I just want to make sure I'm not agreeing. I'm not giving up that argument, Judge.
I understand. So
Argument.
The record will be clear that you are objecting to all these exhibits for reasons that you already stated in a written motion and argued previously. I am overruling those objections. So the Commonwealth, if you can pre-mark those, that I agree that will make things run more smoothly this morning.
That's fine, Judge. I just want to indicate that I believe, in addition to the overall objection regarding prior bad act evidence, counsel had indicated that they had another specific objection to two of the exhibits in this bundle. One is related to a 911 call made by the defendant on May 26, 2009, of which there's an audio recording. And the second being the portions of the restraining order hearing on that same date at the Eastern Hampshire District Court that were provided to Your Honor indicated would be allowed into evidence, the recording of that hearing. My understanding of the objection is not, again, beyond the objection to the general bad acts, but the two exhibits that the Commonwealth has prepared and which were admitted previously have subtitles and running language that correlates with the audio recording. So it's played essentially as a video with a transcript being viewed on the TV while the audio is occurring. The words that are on the screen are all from official court transcripts that were transcribed. In this case, we have all of the transcripts, and they were provided in discovery to the defendant back in 2016. These were introduced as exhibits in trial 3. They were provided to Attorney Wood in 2017 as part of post-conviction discovery. And obviously they've been in the clerk's file since the last trial of 2016 until recently. So the Commonwealth's concern is this is very untimely. This is a electronic exhibit that we would have to try to modify, and we wouldn't be able to play today, which is sort of deja vu of what happened on Friday. But I think the Commonwealth is certainly entitled to have a transcript, an official court transcript that was transcribed to go along with the audio. And I would direct Your Honor to Commonwealth versus Portillo, which is a SJC case from 2012, 462 Mass 324. Where at page 327, the SJC indicates that when the statement is in English, and this was a case where there was English and Spanish, when the statement is in English, the prosecution may offer the recording and evidence without a transcript and rely on the fact finder's understanding of the recorded words, or the prosecution may, if they wish, provide the judge and jury with a written transcript of the recording and offer into evidence as an aid for the finder of fact, with the prosecutor first providing defense counsel with a copy of it adequately in advance of its proposed use, which I indicate we have. The defendant under Portillo would have an opportunity, if they wish, to provide their own transcript if they had a disagreement, and there would be an instruction to the jury to decide. But I would suggest, Your Honor, that Portillo supports the Commonwealth using the transcripts in this way. It will significantly aid the jury in being able to hear and understand the words in the audio recording themselves. And we propose to alleviate any potential prejudice, a limiting instruction that we filed a request regarding subtitles, so that the jury is specifically instructed that it's for them to decide what's in the audio recording. If it differs from what's on the screen, then they use their own memory. So I would suggest, given all of that, Your Honor, I would ask that we be allowed to admit these exhibits again.
Okay.
So our position, very simply, is that they should be permitted to play the audio without subtitles. And I understand the case law that they're free to give the jury a transcript as an aid if they want to do that. The problem, from our point of view, the prejudicial problem, is that it's impossible for the jury to act as a fact finder, fulfill its role as a fact finder in listening to the audio to determine for themselves if the transcript, which I guess they're going to give, accurately reflects what they're hearing. If they're in addition to that, getting this audio, this subtitle on the screen, that's too much. There's too many inputs for any juror to be able to exercise their own independent obligation as a fact finder. So very simply, we submit they should play the audio, just the audio, and they can give, if they want, give them the transcript so that they can follow along and a cautionary instruction that it's up to you, ladies and gentlemen, to decide whether this transcript comports with what you're hearing on the screen. That's what we want.
Is there some point where you think the transcript is not accurate?
I am.
You weren't ready for that
standing before you
question.
right now, I have not reviewed this recently, and so I don't even have a position on this. I could defer to my co-counsel about this. I'm just trying to be as honest and transparent as I can. I'm not sure. Yeah, yeah.
So Judge, in terms of so my suggestion would be, Judge, that they can play the audio without using the TV. In other words, play the audio. That's what you can do. If to the extent they want the jury to have the transcript, they can have the transcript. My concern is this implicit bias that comes with the determination of what a court reporter hears in terms of what the conversation on the voicemail is that the defendant is leaving. Do I have a specific example for you, Judge? I do not, and I won't say that I do because I do not. My concern is that implicit bias is almost impossible to undo if they're listening and looking at the same time. And that was my concern, Judge.
Okay, so I don't know that I see much of a difference between allowing the Commonwealth to play the video and then also give them the transcript so they can read along as they're watching the video, as opposed to having the transcript sort of be part of the video. I will give this limiting instruction so that they understand that the transcript is there to perhaps assist them so that they understand what it is, but ultimately it's what they discern from the audio itself that determines what was said and by whom. I understand your argument, but I'm not persuaded.
I understand, Judge, and just know my objection that the issue that I have is they don't have the audio separately to listen to. All they have is the audio that also has the transcript. I guess that's the concern that I have.
Sure, I understand that, but the jury can look at it, they can listen, and if what they're reading doesn't match up to what they're hearing, I think they're capable of making that distinction. So again, I understand your argument, but I'm overruling the objection.
So my objection, thanks, Judge.
And ADA Sewell made reference to a prior motion to eliminate we filed. I think she was suggesting we should resolve this now. We moved to eliminate the victim's audio recorded statements and statements contained in the restraining order application. I can't remember honestly if there's been a ruling on this, but I think what we're referring to is the. I think we're going to be playing the Commonwealth is going to be playing the decedent's audio recorded statements and statements in restraining and perhaps submitting a restraining order application with an affidavit. Maybe it would be a clarification. I don't want to argue something that they're not going to deal with.
Yeah, so in terms of what statements of Annamarie that the Commonwealth would be offering pursuant to the restraining order hearing, we would be offering the 2-page application filled out by Annamarie, which indicates what she's seeking and biographical information and such. We are not seeking admission of the affidavit that she would have submitted with that application. Also, we are seeking to admit the audio, as Your Honor knows, of the restraining order hearing, or a portion, I should say, of the audio recording. during a portion, some of those portions include statements of Annamarie, as they also include statements of the defendant, and they also include statements of the judge. So to the extent there is some information that comes from the mouth of Annamarie during the audio recording, the Commonwealth is seeking to admit that into the hearing. Yesterday, counsel indicated a particular concern about a statement that Annamarie makes in that restraining order hearing, during which she alleges that the defendant threatened to kill her on the date of the restraining order hearing. That is not part of this recording. It was previously excluded by Judge Rubin. We are not seeking admission of it. And I would note that this pleading that was filed, which I believe is 383, specifically was previously denied by Your Honor. But just to be clear about what we're seeking to admit.
Yes. I recall that as being part of the evidence that we discussed in connection with this prior bad act evidence, and that the defendant moved to exclude it. I denied that motion. So I think your objection is preserved.
Thank you.
Your Honor, based on that, may I push the clerk to be able to pre-mark the exhibits that we have today?
Yes, go ahead.
Jack Cameron stopped. Maybe they were like, look, it's too early on a Monday for this. Y'all gonna have to come back after we've had more coffee. Shereen, I just saw that. That was what a difference now from that first stream. It's crazy, isn't it? They have look, I'm not trying to criticize, but their decor could use a little updating. So maybe the jackhammer stuff is maybe they're like one by one, go into the different courtrooms in here and updating them some, maybe.
So, So are we're just waiting for you to pre-mark the exhibits?
I believe so, Your Honor, and I believe we're prepared to move forward with the first witness today.
Okay, so I thought this morning was going to be devoted to the motion concerning the videotape statement.
Yes, Your Honor.
It's fine that we don't, and it's already almost 10 o'clock. But I thought the point was to give the Commonwealth enough time to edit the video if that became necessary. And I just want to make sure that I don't do anything to create further delay here. So
They just need a fresh coat of paint.
Anticipate arguing the motions to redact the video.
I believe we're requesting to argue it after lunch, Your Honor. The reason for that is the Commonwealth yesterday and this morning filed a notice to redact on our own end certain portions that council needs time to be able to review, to be able to respond to those. My understanding is their expectation is they would be prepared to do so this afternoon. And so the parties would be requesting that Your Honor hear all of the objections from both sides, or the requested redactions from both sides simultaneous to one another. I do believe that will still give us plenty of time this afternoon or this evening to make those edits, so we would be able to play the interview tomorrow.
Agreed, Your Honor.
So are we thinking 2 o'clock? Are we thinking, are we going to let the jury go for the afternoon?
I don't think we need to let the jury go. I don't expect that it would take the afternoon to litigate the motions. We're hoping to be able to use some of their time this afternoon. But again, this is in terms of the amount of time that's needed. I think defense counsel wanted until 2 o'clock, so if we do it at 2, perhaps we could just give them a longer lunch.
Just give them a longer lunch break.
And I agree with that. The parties actually have agreed to at least 2 of our proposed redactions narrowing the issues in dispute. So
Okay,
I
so,
think we can get it done.
so tell me. how long do you
Massachusetts.
think this is gonna take?
I'd say no more than 30 minutes.
Half hour, sure, half hour.
Okay. Okay, so there's also an instruction concerning prior proceedings. I don't know if you want me to give that right away. I don't know if that's agreed to.
It's not agreed to, Your Honor. Yet.
Okay, so I will hold off on that. Perhaps we can address that at 2 as well.
Yes, that's fine, that's fine.
Okay, so I have prior bad acts and the subtitles that I will give, and so I'm gonna give at least a portion of the prior bad act instruction just prior to that testimony. So if you can just give me an indication as to when that's about to begin,
Yes, Your Honor.
and pause for that. And then perhaps right after there's testimony about the restraining order, I can just add that piece of it.
Certainly. I'll indicate to Your Honor. Thank you.
The jackhammers didn't wake you up?
Okay, so let's bring in the jury.
Bring the jury. After all that fussing. Yeah, this one's definitely like a hurry up and wait. Because remember, we actually ended up catching up on Friday because they had that whole huge long break where they had to get stuff together. So we're back in real time on this one after all of our millions of hearings.
We'll be in session. Be seated.
Did it start? It started back up.
I'll let you get settled. Good morning. You had a nice weekend. As always, I must ask if anyone had any difficulty following the instructions that I have been giving you throughout, and that I gave you again before we broke on Friday. Those being not to discuss this case with anyone, including each other, to avoid any contact with any of the participants in this matter, to refrain from any outside research or investigation concerning this case or any aspect of this case, and to avoid any media account concerning this case. If anyone had any difficulty following those instructions, please raise your hand. I see no response.
Thank you, Your Honor. The Commonwealth call witness.
You may.
Thank you. Your Honor, the Commonwealth will call Chief Alan Wishart.
All right, so we're finally, after the first hour of fussing, finally got a witness. Chief Alan something.
Do you solemnly swear or affirm that the evidence which you shall give to the court and jury in the case now and herein shall be the truth, the whole truth, and nothing but the truth, so help you God, and do you so affirm?
Yeah, the judge is a cutie.
Good morning.
Good morning.
Could you please state your name and spell your first and last name for the jury, please?
Alan Wishart, ALANWISHART.
And are you the former chief of police of the Granby Police Department?
Ma'am.
They are
How long
what?
did you work for the Granby Police?
I worked for the Granby Police Department since about 1997 until July of 2021.
And July of 2021 is when you retired as chief?
I did.
Could you give us a sense of what positions you held over that period of time with Brandi?
So I worked in just about every capacity at the police department. I started off as an auxiliary police officer, which was basically a volunteer. I worked as a part-time dispatcher. I was a part-time patrolman, full-time patrolman. I worked in the schools as a school resource officer. I taught there. Over the years, I was promoted to sergeant. I was an acting lieutenant, and then the end of my career was the last 10 years of my career was the chief of police.
What were your duties whenever you were the chief of police in Brandi?
Basically, the responsibility of the entire department. Anything that happens, really my responsibility, from policies to anything that happened in the police department. So,
How many officers, at the time you retired, targeting that time frame, approximately how many officers were employed by the Brandi Police Department?
when I retired, I believe we had about 10 full-time police officers, 4 full-time dispatchers, and a handful of part-time officers.
And in terms of the various positions or ranks of the 10 or so police officers, could you describe that, please?
At the time, I believe there was about 7 or 8 full-time police officers, 3 sergeants, but there was 1 lieutenant and chief, and then 4 dispatchers.
Okay. Does Brandi have their own patrol 24/7 around the town of Brandi?
We do.
And typically, how many police officers were on staff at any given time on patrol?
Usually the minimum was 2, but sometimes during day shifts during the week with some administrative personnel on, like a court officer, that could swell to 4, maybe 5.
I know I've asked you about the time frame when you retired in 2021. Going back to 2008, was it a similar setup at that point in time in Brandi, or was it different?
It was similar in terms of the makeup of our department. I don't believe at the time we had a lieutenant, though, so structurally that was a little bit different.
Okay. And I think you indicated that part of the positions that you had was a single detective within Brandi Police?
At one point, I was an acting detective for the police department. Yes.
Okay. The 4 dispatchers you indicated Brandi Police have, what role did they have?
Dispatchers we man the station, or we remember this is past. We man the police department with dispatchers. So somebody sitting in the dispatch area in the police department 24 hours a day, 7 days a week. Their responsibility was to answer 911 calls or business lines that came in, dispatch police officers, dispatch fire services, EMS services. They're basically kind of the first call front lines of the police department, or emergency services in general, I should say.
Okay. You indicated that someone could call the police station through a 911 call, correct?
That's correct.
So, and anyone in the town of Brandi that called 911, would that go to your dispatch center?
It would. The only exception, and I don't remember time frame wise, is if it was at the time, if it was a cell phone caller, I believe at the time that would have still gone to the state police and then been routed to us.
Okay, because it's not able to be determined where it is initially until.
At the time, that's changed now. Now that all of the phone calls that come in within that geographic area go to the police department in Brandi. At the time, I don't believe they did. They would have been routed to us through the state police.
What about landline calls from homes and residences within the town of Brandi?
Those would all come directly into the police department.
Okay. Are all 911 calls that came into the Brandi police recorded, audio recorded?
Yes.
What about the business lines that you indicated that your police station had? If someone called in or if someone called out, would those be recorded?
At that time, no, they were not.
Okay, when you say at that time, specifically you're referring around 2008?
2008, correct.
I want to direct your attention specifically to the date of September 27th, 2008. Do you remember what rank you were at that point in time?
I was a sergeant.
And what were your duties as a sergeant?
At that time, I had a lot of administrative responsibilities, grants, things like that, some personnel-related stuff, and I also still had responsibilities of responding to calls with other officers on shifts.
Okay. Would you typically wear a uniform when you were working?
Typically, yes.
Would you be operating a marked police cruiser if you were around town?
Usually, yes.
Okay. On that date of September 27, 2008, do you remember an individual by the name of Annamarie Rintala coming into the police station?
I do.
Prior to her coming into the police station on that date, did you know her?
I knew that she was an employee of the fire department, and that we had been involved in some of the same types of events. So I knew that she was an employee of the fire department. That's how I knew her.
Okay. Do you remember if you had ever been on any calls with her or anything?
I don't recall if I had been or not.
Okay, but you were aware of her
Yes.
as a paramedic firefighter?
Correct.
Okay. At the time that she came into the station, do you remember whether or not you were physically located within the station?
No, I don't believe I was. I believe I was out on the road in a cruiser somewhere.
Okay, did you go to the station at some point?
Yeah, at some point they called me back to the station.
Okay. And was that in part to be able to meet with Annamarie Rintala?
Correct.
Okay. When you arrived at the police station, do you remember having contact with Annamarie?
I do.
And where in the police station, if you remember?
In the
that
police
occurred?
station, I met with her and another officer in the basement of the police department at the time.
Do you remember what type of room it was?
It was basically an open room. We used it kind of as a conference room. I would say the building itself is like a ranch house almost, and the room that we were in, I'm going to say, was just an open room with some desks in it, and I would say it was probably maybe 20 by 20. Relatively small.
At the time that you met with Annamarie, did she have anyone with her?
She did.
Who was that?
She had her daughter with her,
Okay. Do you know her daughter's name?
Brianna.
And do you know approximately the age she was at that time?
At the time, I believe she was about 16 months old. 16 months.
Prior to seeing and meeting Brianna on that date, do you remember knowing that Annamarie had a child before?
No, I don't believe I knew that.
Okay. When you first came into contact with Annamarie in the basement of the police station, how would you describe her demeanor?
She was upset. She was crying.
Did you have a conversation with her?
I did.
And without getting into the content of that conversation, approximately how long would you estimate that conversation took place?
Maybe 5 minutes.
Okay. At the time, did you ask her to do anything?
I did. At one point, we asked her to fill out a written statement.
Did she do so?
She did.
Okay. While you were meeting with Annamarie, was your attention drawn to a different area, I should say, of the Brandi police station?
Yes, it was.
And where was that?
Yeah, it was back up into in the lobby.
And why was your attention directed there?
I was told, and I don't remember if it was through the phone system or if the dispatcher yelled down, that there was another party in the lobby waiting to speak with us.
Okay. And when you say with us, was anyone else with you? To your knowledge?
Well, there was another police officer downstairs with Annamarie, and that was Officer Fulmer. And so he was down there with her. I went upstairs.
Okay. And did you come to learn who that other party was?
I did.
Who was that?
It was Cara Rintala.
And prior to seeing her that day, did you know her prior to that day?
I did.
How so?
Same as Ann and Marie. They both worked for the EMS service or the ambulance service in town. We had been involved in, we had a staff softball game, things like that. That's how I knew them.
Okay. And has she arrived, to your knowledge, separately at the police station from Annamarie?
She did.
Are you able to estimate approximately how much time passed between the time you were alerted that Annamarie arrived and the time you were alerted that the defendant arrived?
I don't know specifically exactly the amount of time. If I had to estimate it through the best of my recollection, I would say it was within 15 minutes.
Okay. Do you see the person that you identified as Cara Rintala here in the courtroom?
I do.
Can you please indicate where she is an article of clothing she's wearing for the record?
She's sitting at the table. She has what looks to me from here to be like a green collared shirt.
Your Honor, may the record reflect that he's identified as the defendant?
It will.
Thank you. Where was it that you were interacting with the defendant in the station?
Initially, it was in the lobby of the police department.
Okay, can you just describe the lobby of the PD?
Sure, the lobby of that police department was a very small room. I'm going to estimate it was maybe 7 feet by 8 feet by 8 feet. It was relatively small, just outside of our dispatch area.
Is this the same station that exists currently in Brandi?
It is not.
Okay, it was an older station?
It was an old, old building that was basically like a ranch house, a raised ranch home that was was lent to the town by the state.
Okay. When you came into contact with the defendant, was anyone with her?
No.
Okay. When you got to her in the lobby area, what's the first thing that you did?
Because I had already spoken with Ann, I went up to, and I didn't know what Cara Rintala was going to say. I told her that I was going to read her rights.
And what do you mean by that?
I was going to inform her of a Miranda warning from a pre-printed card because I didn't know what she was going to say. So I wanted to make sure that I had that out there.
Okay, and did you read her Miranda rights from a pre-printed card?
I did.
And just generally speaking, what are Miranda rights, Miranda warnings?
The right to remain silent, the right to an attorney, the right to have an attorney present while they're being questioned, and the right to remain silent. Basically.
Did you, after you gave her rights, did you ask whether or not she understood her rights?
I did.
Did she respond?
She did.
And how did she respond?
She said that she understood.
After that, did you have a conversation with her?
I did.
And can you describe for the jury that conversation, please?
Yes, I asked her, what happened between her and Annamarie. She said that they were just in a verbal argument. I asked if there was any, I asked specifically if there was any physical violence. She said absolutely not. It was just a verbal argument.
How would you describe the defendant's demeanor during the time that you had this conversation with her?
She was relatively calm. She was cooperative.
Was she making any indications to you about wanting to see other people that were in the station?
She did. She wanted to see Annamarie. She definitely wanted to see their daughter, Brianna.
Okay. Did you indicate if she could do that at that time?
I said that she could not.
Okay. After that conversation with the defendant, did you go back to where Annamarie was in the basement?
I did.
And what was your purpose of doing that?
My purpose was just to make sure that I had that my conversation with Annamarie and Officer Ulmer, that I knew exactly what she was saying. I went back downstairs. She said she corroborated what she said the first time, or reiterated what she had said the first time.
Sustained as to the first part of the answer, is that your
Yes,
concern?
Your Honor. Move to strike.
All right, so members of the jury, I'm simply striking the part of the answer where the witness uses the term corroborated.
At the time that you went back and spoke.
Another
with
word we can't
Annamarie,
use.
Did she provide you any different information than she had previously provided to you?
She did not.
Yeah, I believe this would be a good time for you to give the instructions previously.
Okay, thank you. Members of the jury, you are about to hear evidence that the defendant was charged with and arrested for assault and battery on the alleged victim. In this case, that charge was later dismissed. The defendant here is not charged with committing any crime other than the one charge in this indictment. You may not take evidence of this arrest and charge for assault and battery as a substitute for proof that the defendant committed the crime with which he is charged here, nor may you consider that evidence as proof that the defendant has a criminal personality or bad character. But you may consider this evidence of this arrest and charge, again, which was later dismissed, on the limited issues of the defendant's motive, state of mind, and intent, and as to whether there was a hostile relationship between the defendant and the alleged victim. You may not consider the evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant was arrested and charged with assault and battery, then she must have also committed the offense for which she has been charged here. It would be extremely unfair to consider this evidence for those purposes, as that evidence has no relevance to the charge in this case.
Thank you. Chief, after you had the second conversation with Annamarie in the basement, did you at that point go back a second time to the defendant?
I did.
And what was your purpose in going back to her? What was your plan at that point in time?
At that point, my plan was to go back upstairs into the lobby and have a conversation with Cara to tell her that I was going to be placing her under arrest.
Okay. And was she still waiting in the lobby area?
She was still in the lobby, yes.
At the time when you first went back upstairs, how would you describe her demeanor when you came back into contact with her?
Initially, it was exactly the same as when I left.
Which was what?
Just calm, cooperative.
At some point, did you say something to her indicating what was going to happen?
I did.
Can you describe what happened and what you said?
So I told her that because of what, I told her that she was going to be being placed under arrest for domestic assault and battery. And so that's what I told her when I went back up.
Okay. How did she react to receiving that information?
Her demeanor towards me changed pretty drastically. She got very demanding. Her body language changed towards me. It was aggressive. She said, "You're not going to arrest me. That's not going to happen." And it was just her complete change in attitude towards me as soon as I told her she was being placed under arrest. It was quite shocking.
And what did
Objection,
you
Your Honor. Do that last comment.
Okay, overruled.
What did you do next?
I told her that it was going to happen and that she was going to be that she was going to be placed under arrest. And then we began to walk. We had to walk outside to walk back around to the booking room.
Okay. Was she placed in handcuffs at that time?
She was not. I chose not to.
Okay. And was it just the two of you, if you remember, walking together?
It was.
Okay. After that initial change in demeanor, as you just described, how was her demeanor now that you're walking from the lobby outside and going towards the booking room?
She was upset, but she was cooperative from that point on.
Once, well, let me ask you this. Can you just describe her as the booking area that you took her to at that point in time?
Sure. So we had to walk from the lobby up a short deck around to the back to another area of the booking area. So basically we walk like in a horseshoe fashion back to the booking area. Again, it's a small room, maybe 10 by 10. It has a desk. There's cameras in there. There's like a breath test machine. There's cameras in there so we can take photos.
As you were walking to the booking area, you said you had to go outside. Why was that the case?
Because it's the way the setup was at the police department there. I would have had to walk her. I would have her let her inside, walk her through the hallway, which was just above where Annamarie and Brianna were downstairs. It just made a lot more sense to walk her out the door and in the second door.
Okay. As you were taking that walk, was there any conversation at all between the two of you? If you
There
remember?
was.
What was that?
When we stepped outside and started to walk towards the booking room, Cara said, "Well, what would happen if I told you she did hit me?" And I explained to her. I said, "Well, if you were to tell me that she hit you or struck you in any way, then she would be charged as well."
And you told her that in those moments?
I did.
Okay. After you got to the booking room, did you engage in a booking process?
I did.
Can you describe what that entailed?
Again, I read her rights again. Take some of the property from her just so we know what she had on her, like a necklace and things like that, her cell phone, any other valuables. The booking process really is about kind of letting that person know what the charges are, reading them their rights, identifying them, getting their identifying information, social security number, date of birth, parents' names, things like that. It's really like the identification process, photographs.
And how would you describe her demeanor during that period of time?
I would say she was very upset.
During that process, did the defendant make any additional statements in regards to what had happened at the house?
She did. During the booking room, during the conversation, she said that she brought up again, what would happen if Ian hit me, and I said, "Well, I told you what would happen." And she said she did. She grabbed my neck, and she proceeded to show us at some point she did have a red mark on her on the lower base of her neck, consistent with what she said.
And were you able to observe that mark yourself?
I did, yes.
Do you remember a photograph being taken?
I did, yes.
Can I approach your honor?
Right.
It's like that sound is so weird. It makes me think that, like, is it here? But it's not. It's there. It's there.
I'm just going to show you.
Hello,
one of the
everyone
two
joining
screen there,
us.
Chief. Are you able to see that?
I can, yes.
Do you
Hello,
recognize that
hello.
photograph?
I do.
For the record, this is marked as exhibit number 39. What do you
That doesn't look
recognize
good.
that photograph to be?
I recognize it as the photo we took of the injury to her neck.
Okay, and that's the mark that you saw that day?
It is, yeah.
Okay.
Yes.
Ouch.
Now, you indicated before that you gave Annamarie an opportunity to write a written statement. Did you also give the defendant that opportunity as well?
I did.
And did she do so?
She did.
Now, in regards to Annamarie, do you remember whether or not she was advised of an option to seek a abuse prevention order or restraining order?
She was.
And do you remember whether or not she indicated she would like to pursue that option?
She did.
And did she fill out an application for a restraining order?
She did.
Yeah, if y'all haven't seen Kathy's
Can you
video
just
on this,
describe for us what
She talks about the
process is
history
in
of
terms
it too.
Your department and your officers when someone is seeking a restraining order when they're at the police station.
So generally speaking, at the time, the process was that we had an application that we would get from the court. It talked about the different things that it would identify who the person that they wanted to be protected from. the people that would be protected, the different types of things that they wanted to be protected from. They would be asked to write a written statement as to, what abuse occurred and the reason why they wanted the restraining order. So we would get that, we would work with them to get through that, and then we would call an on-call judge. We would report to the on-call judge what the person seeking the order had told us, and then the judge would either issue it or not.
Okay, and did that process happen in terms of Annamarie on September 27, 2008?
It did.
And ultimately, after that, did the restraining order that Annamarie was seeking issue?
It did.
Showing on the presenter was been marked as exhibit number 37. Do you recognize that, Chief?
Yes.
And what do you recognize that to be?
That looks like the restraining order that was applied for and issued that day.
Okay, are you familiar with this form in general?
I am,
Have you seen this before?
several times.
Is this a standard pre-printed form for an abuse prevention order in Massachusetts?
It is.
If I could just ask you to stand and grab the pointer that's directly behind you there. And can you just indicate in terms of what information we're seeing in this top box before the word violation?
So before the word what, I'm sorry?
Violation of this order, sort of that top section.
Here?
Yes.
So you have the plaintiff's name, Annamarie Rintala. She was the one seeking the restraining order. This is the name of the court that at the time we were going to. It has the defendant's name and address, place of birth, phone number. Do you want me to keep going?
In terms of this A section, where it says the court has issued the following orders to the defendant, generally speaking, what is in this section?
So in this section here, the whole section together?
Yes.
Generally speaking, this is the area where the judge determines what the defendant can and can't do in terms of contact with people. Do they have to stay away from a person, stay away from a residence or a place of work, things like that.
And in terms of this specific restraining order, can you just walk us through what was ordered?
So the judge ordered that the no abuse of the plaintiff by harming, threatening, attempting to harm the plaintiff physically or placing the person in fear or serious physical harm. She was ordered not to contact the plaintiff, had to stay 100 yards away, and she was ordered to immediately leave and stay away from the plaintiff's residence at 18 Barton Street. She was ordered to stay away from American Medical Response, and then the judge ordered custody of Brianna to Annamarie as well. And then there was no contact. She was to have no contact with Brianna either.
Okay. And you've used the word plaintiff, as I know that appears on the order, but the plaintiff in this restraining order was Annamarie, correct?
Correct.
Okay. And then lastly, number 12, are we seeing an order to surrender any firearms or ammunition?
Yes.
Fair to say, Chief, that's a standard provision of all restraining orders?
It is a standard provision of all restraining orders, yes.
I'm just going to page 2 of this document. Looking at the date of the order, what does it indicate there?
It indicates 9/27, 2008,
And the time?
1400, 2 p.m.
Okay. And when was this order that was issued with the on-call judge set to expire?
It was set to expire 9/29, 09 that should be at 4 p.m.
Okay. And just looking at that next box where it says next hearing date, does it say September 29, 2008
It does.
at 9 a.m. in the morning
Correct.
at the Eastern Hampshire District Court?
It does, yes.
And so the box indicating the expiration date of the order, is your understanding that 2009 is a typo?
It is, absolutely.
Okay. And why do you know that this restraining order would have only issued with the on-call judge until the date of September 29, 2008?
They would only issue it until the next meeting of the court, which would have been that Monday.
Okay. And what is expected to happen in terms of the next meeting of the court?
So at the next meeting of the court, there'll be a hearing where both parties will be heard.
Okay. So the order would have expired on that date?
Correct.
Okay. And then going down to the bottom, is this generally where you would see extensions or modifications to the terms of that order?
That's correct.
I'm gonna go all the way down to the bottom. Do you see F checked off there?
I do.
And what does it indicate happened to this order?
It indicates that that order was vacated. It was vacated at the plaintiff's request on that date, that Monday.
Okay, so on September 29, 2008 at 10:55 a.m.?
Correct.
And the judge?
Looks like John, the Honorable John M. Payne Jr.
Thank you. You want to redeem your seat for a moment, Chief? Thank you.
Oh, he's throwing things. Anger management.
Rachel, would this be
This will be your honor.
a good
Thank
time
you.
for the instruction? So, members of the jury, I'm going to give you an instruction that's essentially the same instruction I gave you concerning the evidence of the arrest and charge, the later dismissed charge for assault and battery against the defendant. This evidence that a restraining order issued, again, can only be used by you for a very limited purpose, and for that purpose only. And that, again, is, or that limited purpose is for the issue of the defendant's motive, state of mind, and intent, and as to whether there was a hostile relationship between the defendant and the alleged victim. You are not to infer anything otherwise from the fact that this restraining order issued. You're not to speculate about the reasons why it issued or the basis for it. Again, you are limited to those considerations, the ones I've just listed. You may not use it to conclude that if the defendant was the subject of this restraining order, then she must also have committed the offense for which she has been charged here. You may not use it to or consider it as proof that the defendant has a criminal personality or bad character. Again, it would be extremely unfair to consider this evidence for those purposes, as those of any thing concerning this restraining order has no other relevance to the charge in this case, other than, again, that very limited purpose, which I've already described.
Thank you. Going back to September 27, 2008, after this restraining order issued with the on-call judge, did you have a conversation with the defendant about the restraining order?
I did.
Can you describe that, please?
I had a conversation with the defendant explaining to her that the restraining order had been applied for, the judge had issued it, and I was explaining to her the different restrictions that it placed on her, for the rest of for the remainder of that weekend.
And specifically, did you advise her that she was not allowed to contact Annamarie, that she had to stay away from their home at 18 Barton Street, that she had to stay away from Ann's workplace, that custody was awarded to Ann and Brianna, and that the defendant could not contact Brianna?
I did.
And what was her reaction to receiving that information?
She was very upset. She was upset about a lot of it. I think she was most upset about not being able to contact Brianna. She was certainly upset about not being able to go back to the house as well. But I think mostly about not being able to have contact with her daughter.
Now, in terms of the domestic assault and battery that you indicated you had placed the defendant under arrest for, are you aware of that matter proceeding to court?
My understanding is that it went to court that Monday.
Can you just describe the process that happened in this case and what happened in a case in order for a case, an arrest, to then become a court case, in other words?
Yes.
Please.
I'm sorry. What was the question?
That's all right. Can you please describe the process in terms of an arrest becoming a court matter?
Okay. So the person gets taken into custody. We take care of the booking process. We call a bail clerk or a magistrate. They determine what amount of money or what conditions the person should be released under. Most of the time, the person gets released and they have to come back to court on a specific day. On that day, my understanding is that, my experience is that that person is told to show up on that day, and that's where they are basically arraigned for that charge.
And in terms of the charges themselves, did the police file paperwork at the clerk's office asking for the charge to issue by the court?
We do. With the arrest packet goes basically an application for complaint.
Okay. And in this case, are you aware of an application being filed and a complaint being issued?
Correct, yes.
just showing on the presenter what's been marked as exhibit number 38. Are you able to see that, Chief?
I can, yes.
Do you recognize it?
I do.
What do you recognize that to be?
It looks like the criminal complaint for the charges for that incident on the 27th.
And specifically the docket that outlined what happened to that case?
Correct.
If I could just ask you to stand, please, and use that pointer again?
Sure.
Thank you. Could you show us, obviously, we're seeing the defendant's name, Cara Rintala there.
Yes.
We're seeing a docket number at the top. In terms of the charge, what are we seeing?
It says the charge was 265-13 A and B, assault and battery.
Okay, with an offense date of September 27, 2008.
Yes.
Okay. Scanning down, are we able to see an arraignment occurring in court on September 29, 2008
Yes.
with Judge Payne?
Yes.
And are you aware of an arraignment being a first appearance in court on a criminal charge?
It is, yes.
Scanning down, are you able to see what next date was set after the arraignment on September 29th?
Oh, I'm sorry. Yes, there's a pretrial for on 11/3 of 2008.
Okay. So the case was scheduled next to be in court on November 3rd?
Correct.
For a pretrial hearing?
Yes.
Okay. Scanning down to the second page of this document, are we able to see here a disposition of that charge?
Yeah, it looks like it was dismissed at the request of the victim.
Okay. And on the top right, do we see what date it was dismissed at the request of the victim?
11/3 of 2008.
Okay, by Judge Walsh.
It looks like yes.
Do you also see the words here, accord and satisfaction filed and allowed? Handwritten.
Yes. Yep.
Okay. And a notation of Commonwealth on no position?
Yes.
Okay. Just looking for a yes or no, are you aware of what an accord and satisfaction is?
Yes.
Okay. I'm gonna scan down to page number 3 here. Do you recognize this as essentially an accord and satisfaction?
Yes.
Okay. Titled here, a motion to discharge the defendant and dismiss the complaint, correct?
Correct.
Can you read that aloud where it says now comes?
Now comes Annamarie Rintala, the alleged victim in the above referenced complaint, and hereby moves this honorable court to dismiss count 1 of this complaint alleging assault and battery against the defendant pursuant to Mass General Laws 276, Section 55. As reasons therefore, Annamarie Rintala asserts that she has reached an agreement with the defendant. Further, Annamarie Rintala states that the satisfaction did not include monetary compensation.
Okay. Do we see a couple of signatures there purportedly by Annamarie and the defendant?
Yes.
Okay, on the November 3rd date?
Correct.
Thank you. Is it your
It'll be
understanding that
interesting-
this document is what caused the case to be dismissed?
Yes.
Thank you. You can read your seat, Chief. Thank you.
It'll be interesting to see how the defense attorney approaches this stuff.
Now, going back to your interaction with the defendant on September 27, 2008, you indicated that at some point she said to you, what would happen to Annamarie if I told you that she hit me, correct?
That's correct.
And you responded that she would be charged as well.
That's correct.
And do you know whether or not any steps were taken by your police department or you to initiate that?
We did. We did a report and filed an application for a criminal complaint against Annamarie.
And do you know whether or not a complaint ever issued against Annamarie?
I do not believe that it did.
Chief, are you familiar with the term mandated reporter?
I am.
And what is that to you?
A mandated reporter is somebody who, by the nature of their job, is required to report certain types of abuse.
Okay. And as a police officer, are you a mandated reporter?
I was, yes.
Okay. All through your career?
Correct.
Okay. And who, in terms of, who would the reports of abuse need to be made to?
To the Department of Children and Families.
Okay. Previously called the Department of Social Services?
Yes.
Okay. And in your career, have you had occasion to file those many times?
I have.
Okay. Particular in this specific case on September 27, 2008, did you file a report with the Department of Children and Families?
We did.
And why did you do that?
We did so because of the altercation that occurred and that Brianna was there for it and witnessed it.
Okay. And as a result of you being a mandated reporter?
Correct.
Okay. Now, in terms of that report that you filed with the Department of Children and Families, what information, if any, at the time did you get about what happened to that?
When we file it, there initially is no indication. We make a phone call and we fax it. And then usually we would hear back at some point whether it was screened in or screened out.
Okay. Beyond finding out if it was screened in or screened out, do you get reports or the substance of any investigation or interviews that they have?
Not that I recall.
I could just want to have a moment now. Thank you. I have no further questions. Thank you, Chief.
Morning.
Right.
I have a few questions for you. So on this incident, when Annamarie Rintala came to the police station, she got there first, it's fair to say, right?
Yes,
Okay. And she gave her statement, whatever that was, first, right?
she did.
And you didn't see any marks on her, is that right?
That's correct.
And she had nothing to corroborate whatever it is she said, it was just her word, right?
That's correct.
And very often that's what happens in these restraining order situations, is that somebody tells you what happens and you're the police and you try to protect the person who's saying that they got hurt, whether they're telling the truth or not, is that right?
I think we try to determine if that person is telling the truth, and yes, we try to protect people, sure.
Okay, so in this case, when Annamarie Rintala got to the police station first, she asked for a complaint to issue against Cara Rintala, is that right?
That's not correct.
No. Did she tell you, she gave you information, right?
She did.
Okay, and as a result of that, you went and you talked to Cara, is that right?
Correct.
And Cara stayed there the whole time, is that right?
She did.
And then you went back down and spoke to Annamarie again, right?
Yes.
And then you spoke to Cara again, right?
Correct.
And then you made the decision to arrest Cara Rintala, is that right?
That's correct, yes.
Okay. And when you arrested Cara Rintala, she was upset, right?
She was.
And that's pretty normal, that when you're gonna arrest someone, people get upset, right? No one's happy to be arrested, right?
I'd say that's fair to say, yes.
Okay. And so there wasn't an abnormal reaction that someone's upset and you're saying you're gonna get arrested, right?
I don't think it's abnormal that people that are told they're going to be placed under arrest generally are upset.
Okay. And in this case, with respect to what happened here, when Cara Rintala found out that she was gonna be arrested, she asked you some questions about what would happen if she told you that Annamarie had assaulted her, right?
She did. That was after she told me that nothing physical had happened, yes.
That wasn't my question. My question is that she told you that Annamarie had assaulted her, right?
She told me that in the booking room afterwards, yes.
Okay. And you actually saw physical manifestations of a mark on her neck, right?
That's correct.
And she told you that Annamarie did that, right?
She did.
Okay. So you had enough evidence right there to arrest Annamarie, right?
I did, yes.
Okay. And Cara asked you not to do that, right?
She did.
Okay. And she said she didn't want Annamarie arrested because she was concerned for Brianna, right? She didn't want Brianna to be in a situation where both her parents were under arrest, right?
No, I don't believe she said that.
She did.
I don't think so.
Okay. Well, do you remember?
I'm like nervous.
Do you
When she
remember
gets up, I get nervous.
Cara Rintala speaking to you about her concern for Brianna that night?
Yes, she did.
Okay. And do you remember you explaining to her that she had the right to explain whatever it was that she believed that Annamarie did to her, right?
That's correct.
And as a result, after having explained that, you then explained to her her right to get a restraining order. Is that right?
Yes.
And you gave her the same exact information that you gave Annamarie Rintala regarding getting a restraining order, right?
Correct.
And do you know whether or not Cara Rintala sought a restraining order that night?
She did not.
Okay. And do you know whether or not that night, did you have any conversation about arresting Annamarie Rintala?
I had a conversation about not arresting Annamarie Rintala with Cara in the booking room, yes.
Okay. And that's because Cara asked you not to, right? Not because she wasn't assaulted, but she asked you not to, right?
No, that's not why.
That's not why she asked you?
That's not why I didn't arrest her.
I'm not asking you why you made your decision, I'm asking you what Cara said to you.
I don't recall Cara telling me that she didn't want her arrested.
You don't recall that at all?
I don't.
Okay, so as you get that night, so you have physical evidence that Annamarie Rintala assaulted Cara Rintala, and you didn't arrest her?
We did not.
And you had no physical evidence that Cara Rintala assaulted Annamarie Rintala, but you arrested her, right?
That's correct.
Okay. And in this case, you talked a little bit about, you talked a little bit about the restraining order that got issued, in this case for Annamarie Rintala, right?
Correct.
Okay. And Annamarie Rintala, it's fair to say when those restraining orders get issued, especially over the phone, it's all done just on the word of the person who's saying that they were assaulted, right?
That's correct.
Okay. And you said at one point you believed that Cara Rintala was ordered not to go back to the residence. Is that right?
That's correct.
Can you look at number 3 and see whether or not it's checked in the boxes of the restraining order, sir?
It's not checked.
And usually it would be checked if you were ordered not to go back to the residence,
It
right?
normally would be checked, yes.
But it's not checked there, right?
Yeah. Yes.
But you told Cara Rintala that the order said she couldn't go back to the residence, right?
That's because that was what was ordered by the judge.
It's not on a piece of paper.
No, I believe
So
that
loud.
was a typo or it was missed.
Well, the judge signed it, right?
The judge doesn't sign that.
You guys signed it.
Correct.
But you don't check box 3 that says she can't go to the residence, right?
No, normally we would have it. But
I'm asking you what normally you would do. I'm asking you about that night, sir. Did you check box 3 that says she can't go back to the apartment? Yes or no?
No.
Okay. And that was the actual order, right?
There was some confusion as to why it wasn't checked, and it should have been checked.
But it's not.
On this copy, it's not, no.
Was there another copy where it's checked that I don't have?
I don't know that there is.
So the only copy that exists, there's no order that says she can't go back to the house. Is that fair to say?
It's just not checked. That's fair to say.
Okay. And it normally would be checked if there was an order from the court. Is that fair to say?
That's fair to say.
Okay. And in this case, sir, you said that at some point, because this order issued, that there was a telephone call to a judge, and an order that issued sort of electronically or telephonically over the phone. Is that right?
That's correct.
And that's all based on whatever it is that Annamarie Rintala said, right?
That's correct.
Okay. And at that point, Cara Rintala's side of the story doesn't get told at all. Is that right?
That's right.
And nothing was told to the judge about Cara Rintala having marks on her neck consistent with her having been assaulted by Annamarie Rintala. Is that fair to say?
I don't know if that was told to the judge or not. That's would be fair to say.
Okay. So it's not there. It's not contained anywhere. And you don't have any way of knowing that if the judge, because normally you only get one side, right?
That's
the whole
correct.
purpose of an ex parte order. Just the person who's making the complaint is the one who controls the information, right?
Correct.
Okay. And that's what happened in this case, right?
Correct, yes.
And it happens in every case of an ex parte restraining order. The person making the complaint is the one who is the only one who the judge listens to that night. Is that right?
That's correct.
Okay. And when the order issued, it issues for a very short period of time to give the other party, the party that's being complained against, the opportunity to come into court and be heard, right?
Correct.
And it's that return date, that 29th, when you're going to come back in, be heard, and that's the first time that Cara Rintala would have had an opportunity to speak to the court about her side of the story. Is that right?
That's right.
And that's usually called the return date, right?
Correct.
Okay. And in this case, on the return date, Annamarie Rintala decided not to go forward. Is that right?
That's correct.
He dismissed it, right?
Correct.
Okay. And Cara Rintala never had the opportunity to tell the court her side of the story. Is that right?
I don't know if she did or she didn't. I wasn't there.
Okay. But in any event, the restraining order gets dismissed. Is that right?
Correct.
Okay. And then you talked a little bit about being a mandated reporter, and the fact that when you're a mandated reporter, anytime that there's a child involved and that there appears to be some issue between parents or crimes that may have been committed or at least alleged, you have to report that to DSS. Is that right?
Correct.
And that's what you did in this case, right?
It is, yes.
Okay. And when you reported to DSS, what happened? Were you aware, or when were you aware that they screened the report out?
I don't remember when I was aware of whether they did or they didn't.
So you didn't follow up?
No.
Okay.
We
Were
wouldn't
you
know.
ever aware when DSS interviewed Annamarie Rintala that she stated
Objection.
that? So was he aware?
In terms of foundation before.
Okay, can I see counsel sidebar?
It's crazy because we are listening in like real speed this time instead of 1.25, and she still sounds like she's at 1.25. She talks fast, and I tend to talk fast when I get to go in, but if I'm tired, then you can tell like I talk slower and I take longer pauses between my words and stuff, trying to make my brain function. But she talks really fast. But she knows her stuff. She's a good attorney. Let's see. Are you asking if this is live or replay? This is live. We are live from Granby, Massachusetts. I don't know if it's Granby. Is that what it was? That's where that document was from. It ain't Boston. I said that wrong the other day. The lawyer's from Boston, but Lord help me. I said the trial's in Boston. All right. So our poll says of the most overused attorney words and phrases, 48% is right. Not like right, like you got the right answer, but 48% said right is the most overused attorney word. And then that one was a landslide. That one's 48%. And then you'd agree with me that one was 20%. That reminds me of Thomy's lawyer. And is it fair to say is after that at 18%, and then correct is coming in last at 14%, except for Thomy's trial. Correct was I think like every maybe, what was it? Was Joshy, was his right or correct? I can't remember. One of them said correct and one of them said right. And Joshy said it more than any person ever. Yeah, right. He would lead that whole thing. It was so frustrating because he'd be like, instead of asking questions, especially when he was questioning Colleen, as they called her. As a matter of fact, he called you multiple times, right? He told you he loved you, right? He said you felt like home, right? Blah. Blah, 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 blah.
So I'm going to ask you, with respect to the 51A that mandated reporters filed, in this case, you said that you weren't aware of what happened to that?
After I filed it,
Yes.
I'm not sure what happened to it.
So as you say today, you don't know that it was dismissed?
I don't know that, no.
No one ever told you it was dismissed?
I don't know that anybody told me that it was dismissed or that it went forward to anything past what I
It was screened out. You learned that at some point, didn't you, sir? It was screened out.
I don't remember if it was screened out or not.
Okay. So in all the times that You came in here to testify. Nobody ever asked you to look at any of the DSS reports,
I know that they exist.
and you looked at them, right?
I know that they exist. I have not looked at one.
You haven't looked at one DSS report. You're the one who made the complaint, and you haven't looked at any DSS report.
No, I've seen a DSS report. I know it exists, but I have not read it.
Well, when you saw the DSS report, did you see the part that said that Annamarie made a claim against the Granby Police Department?
Is that the total question?
I'm sorry?
Is that the end of the question?
No, I was gonna continue the question.
Okay, so sustained.
Well, when you saw the file, and can you just read this paragraph to yourself, please, sir?
Which paragraph?
The one highlighted, one on the top, highlighted in orange.
What? Did we just become best friends? Yep.
Jill, you're best friends now. Welcome. Welcome. You live here now. This is your life. Come in. Join us every day. There's not always construction in the courtroom, but when there is, it's on a Monday.
Sir, does that refresh your memory as to whether or not you ever learned of complaints that Annamarie Rintala made against the Granby Police
Sustained.
Department?
Sustained.
Sir, does it refresh your memory as to the DSS file?
No,
It doesn't.
no.
Okay, sir. In terms of the DSS file, you knew you were coming in here to testify today, right?
I did.
And you knew you were the one who had filed the 51A, right?
Correct.
And you knew you were going to be asked questions about it, right?
About my part in it, yes.
And you never looked at the file, is that
I never
fair to
looked.
say, sir?
The only file that I looked
Or
at.
you never looked at the file, is that fair to say?
And that's the Kayla to answer the question.
Cross-examination.
Yes, he just has to, you can ask a question, just give him enough time to get his answer out, and then you can ask your next one. Go, if you can just ask or answer the last question, sir, if you recall it.
I don't recall.
Okay, if you can ask the question again.
Sure. Even though you knew you were coming in here and you were going to be asked questions about the 51A, you never looked at the file. Is that fair to say, sir?
No, that's not fair to say.
It's not.
No.
But you can't tell us today what the file said, right?
I know that.
Or you can't tell us today what the file said, right?
Well, you just showed it to me. Now I can tell you what that said.
Okay, what does it say?
Objection.
Sustained.
Sir, when I showed you this document, it's the first time you ever saw this document with the allegation.
I don't think I've ever heard or seen that before.
Okay. But nobody was hiding the DSS file from you, right? You could have looked
No.
at it anytime you wanted.
I guess I could have.
Okay, and you didn't in this case, right?
I did not.
Even though you knew you were going to be asked about it, right?
I didn't know I was going to be asked about something that didn't exist. I didn't know existed.
I don't understand, sir.
I put forth a 51A report.
Yes.
I know that existed. I know what I put in that report existed.
Right.
The report that you just showed me is something that I didn't have any involvement in. I didn't create it. I didn't really, so it didn't involve me. That's how I looked at it. So to answer your question, no, I was not aware of that.
What involved the Granby Police Department, right?
Apparently it does, yes.
Okay. And with respect to the Granby Police Department, sir, do you know, as far as this allegation is concerned, whether or not, and without talking about what the allegation is, you know if the allegation about the Granby Police Department was ever communicated to anybody in the Granby Police Department?
I don't recall that it ever was.
Okay. And you know that usually when you file these 51As, they get screened out fairly quickly, right? Because the safety of the child is at stake, right?
I don't know. I can't say that I know how quickly they get screened in or screened out.
Okay. You know in this case that the allegation of 51A got screened out within a day or two?
I do not know that.
Okay. But you could have found it in the file, you just didn't look.
That's correct.
I don't have any further questions.
Mayor, Your Honor.
May.
Just in terms of that question, Chief, in terms of looking at quote unquote the file, in terms of what is at the Granby Police Station and the file there, does it include follow-up reports that may or may not have been completed by the Department of Children and Families?
To my recollection, at the time, that was not part of the file.
Okay. Now, Attorney Scapicchio asked you in regards to box 3 on that restraining order in terms of whether or not there was a vacate order at 18 Barton Street. Do you remember those questions?
I do, yes.
And fair to say 18 Barton Street
Fair
is
to
written
say.
into number 3?
It is.
Okay, but the checkbox is not marked.
It was not. It was an error.
Can you just describe how you know that the judge made the order when it was not noted as a checkbox on that form?
Because I spoke with the officer who spoke with the judge.
Judge
and
Nero.
certified it.
Move to strike.
No, this is a reaction to cross-examination to clarify how he has that information. He was asked this on cross.
All right, so it's being introduced for his knowledge or state of mind.
Correct.
It's what he heard somebody else say that somebody else said.
I understand that, but it's not being introduced for its truth. It's simply being introduced for this witness's state of mind at the time. So I will allow it for that purpose.
So much action.
Can I answer the question, Chief?
Can you ask it one more time? Sorry.
Sure. How do you know that the judge made that order to vacate the home if it's not checked on the form?
Because I clarified with the officer who the order was issued to.
Okay. And did you tell the defendant, when you were explaining the terms of the restraining order to her, that she was ordered to vacate and stay away from 18 Barton Street until the return date 2 days later on that restraining order?
I did very clearly several times.
Attorney Scapicio asked you about the decision not to arrest Annamarie after Cara made an allegation against her. Do you remember those questions?
She did, yes.
And you don't remember Cara making a specific request not to arrest Annamarie, correct?
I don't recall that, no.
Why did you not arrest Annamarie?
We did not arrest Annamarie because generally speaking, we try not to make dual arrests, both parents when a child is involved. So in most circumstances, you try to figure out who was the aggressor with the information that you have at the time, and you move forward with that. The idea is it's in the best interest of the child that both parents aren't arrested.
Okay, and so that was a decision that you made based on your practices and procedures.
That's correct.
I believe you indicated in response to Attorney Scapicio's questions that generally it's not abnormal for people to be upset when they're arrested, correct?
That's correct.
And that's something that you see, people are upset when they're arrested, right?
That's right.
Would you describe the defendant's reaction when you told her that she was being arrested as abnormal?
I thought it was, yes.
And what about it made you believe that?
Her demeanor towards me changed. It was a stark change. It was shocking. It was very aggressive. She looked right through me. It's the only way I can describe it. It was like, I'm not a big guy, but she's not a big person either. And she looked at me like she was.
Objection, Your Honor.
Sustained.
Move to strike.
I don't think you got to the part that you were
Well,
objecting
Judge,
to, at
she
least.
looked right through me.
Okay, well, I'm not gonna strike any portion of the answer, but he can't go any further with it.
Understood. Did you determine that it was abnormal and not within your common experience?
Yes.
Thank you. I have no further questions.
Abnormal? Remember testifying before in this case?
Yes, I testified before, yes.
Okay, you remember testifying on September 22nd of 2016?
If that's the date, yes.
You remember being asked the question, and it's not an unusual thing for you to experience in these situations, talking about somebody getting arrested. And your answer being, in situations where people find out they're under arrest, they can be upset, they can cry, they can be angry, sure. Remember saying that?
I did.
Okay. And so, that's the normal reaction, upset, angry, cry, right?
It can be the normal reaction, yes.
Well, you just said it was the normal reaction. Didn't you say that before, sir? Didn't you say those words when you testified previously? This is page 77, lines 15 and 16. Can you read those to yourself, please, sir?
Oh, sure. What lines, 15 and 16?
15. Yeah, the highlighted ones. 15.
You want me to read it out loud, you said?
No, read them to yourself.
Okay.
Now, sir, you were being asked questions about a reaction, a normal reaction of somebody having been arrested, right?
Yes.
And you never saw Cara Rintala become physically aggressive with you, is that right?
She did not attempt to assault me or anything like that, no.
Okay. And she was angry, right?
She was.
Or she was being arrested, right? Maybe wrongfully so, right?
I would say that she was upset because she was told she was being arrested.
Okay. And that's not an unusual thing for you to experience in these situations, is it? That people get angry when they're going to get arrested, right?
I wouldn't say that It's
So just my question. It's not an unusual thing for you to experience if people get angry when they're getting arrested. It's a yes or no.
Objection.
The question or the last part about limiting the witness to a yes or no? Yes, sir.
Limiting the witness.
So that is, to that extent, it's sustained.
So, sir, you remember saying in 2016, in situations where people find out they're under arrest, they can be upset, they can cry, and they can be angry for sure. Remember saying that?
I did say that.
And you were under oath when you said that, right, sir?
Yes.
I don't have anything further.
Nothing further.
Okay. Next, step down. Thank you.
Thank you. Your Honor.
He's like, get me out of here. Let me unpin him.
May I call the next witness, Your Honor?
You may.
Commonwealth call Lemonard.
Who? Who? Spencer's talking. Yes. She really does. Like, she really does sound like she's like sped up.
Swear or affirm that the evidence which you shall give to the court and jury in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God as you so affirm.
Good morning.
Good morning.
Could you sit a little bit closer to the microphone so we all can hear you? Could you please state your name and spell it for the jurors, please?
Lynn Menard, Lynnmenard.
And Ms. Menard, are you currently employed?
Yes, I am.
Where do you work?
Brandi Police Department.
And what is your job at the Granby Police Department?
I am a dispatcher.
How long have you been a dispatcher for the Granby PD?
35 years.
And have you held that position during that entire time?
Yes.
Could you describe, please, your duties as a dispatcher at Granby Police?
I answer calls and dispatch officers.
Okay. And in addition to dispatching officers, do you sometimes dispatch other?
I also dispatch ambulance and fire.
Okay. At the Granby Police Station, I guess speaking now, how many dispatchers work there?
4.
Okay. And has that been the case fairly consistently over the time that you work there?
For the majority of them.
Okay. What shift do you normally work?
I normally work 7 to 3, 7 a.m. to 3 p.m.,
Any particular days of the week?
Monday through Friday.
Okay. Are you aware of how many 911 calls there are at the Granby Police Station?
No,
Okay, more than one?
more than one.
Okay.
Yes.
Is there, or do you work alone at times, or do you work with another dispatcher?
I work alone.
Okay. If you have to step away from the desk at any period of time as a dispatcher, when you're on your shift 7 to 3, what happens to the lines?
I call an officer in, they sit the desk for me.
Okay, and so they cover whenever you need to step away?
Yes,
In terms of the 911 calls, are you aware that they're recorded?
yes, they are.
Okay, what about business lines at the Granby Police Station? As a dispatcher, do you also answer business lines?
Yes, I do.
And that could be anyone calling in just to the general number?
Yes.
Are those calls to your knowledge recorded?
No, they're not.
What about calls that you make from the dispatch station out from the PD? Do you know whether or not those are recorded?
They are not recorded.
Now, is it as a dispatcher, when a 911 call specifically comes into your station, what kind of information are you trying to obtain from the caller?
The address, the name, what emergency they need, what services.
Okay, and what do you, how do you take in that information and what do you do with it?
I read it on the screen or talk to the person, and then I relay it to the officers.
And in terms of, you indicated that you dispatch police, you dispatch ambulance, and you dispatch fire, correct?
Correct.
And how do you decide which of those services you will dispatch to any given 911 call?
If it's a medical emergency, the ambulance would be dispatched. If it was an accident, both medical and fire would be dispatched. And if it was a criminal matter, the police would be dispatched.
Okay. Are you familiar with the term abandoned 911 call?
Yes, I am.
And what is your understanding of what that is?
An abandoned 911 call is when someone calls 911 and then hangs up right away.
So no communication at all on the line?
No communication.
And have you received abandoned 911 calls as a dispatcher?
Yes, I have.
Many?
A lot.
In terms of what information, if any, you have when an abandoned 911 call comes in, what information do you receive?
If it's a landline call, we get their name, their address, and their phone number,
Okay, even if there's no communication with the
even
caller?
if there's no communication.
What if it's a cell phone?
Now we don't get it. We get the nearest cell tower.
Okay. In terms.
We still get phone number,
You get the phone number, but
the
not
phone
the
number, but not the
location?
address.
Okay. In terms of your protocol of what you do when an abandoned 911 call comes in, what do you do?
I call the number back to find out what the emergency was.
Okay. And just sometimes people answer those callbacks
Sometimes they do,
and sometimes not?
sometimes not.
Okay. Regardless of whether or not you're able to make communication on callback, do you dispatch the police officers?
Yes, I do.
Why do you do that?
Every 911 call should get a police response.
Okay. So even if you're not able to communicate with them, that's your typical protocol?
Yes.
Okay. I want to direct your attention specifically to the date of May 12th, 2009. Do you remember working as a dispatcher on that date?
Yes, I do.
And do you remember if you were working the daytime on a weekday, as you typically do?
Yes.
Okay. Specifically at 12:09 PM on that date, do you remember receiving an abandoned 911 call?
Yes, I do.
And specifically, what do you remember happened when you answered that 911 line?
There was no one there.
Okay, but the call had come in.
The call had come in and there was no one there.
Did you receive any information about that call?
I received the address and the phone number.
Okay, do you remember what address you received?
18 Barton Street
In Granby?
in Granby.
Okay, and your system registered that information?
Yes.
As a result of receiving that call, what did you do?
I dispatched the officers.
Okay. And did you do anything else in terms of your own work in the station?
I tried calling the number back.
And what, whenever you called the number back, what were the results?
I heard screaming and then the call was disconnected.
Okay, so on the call back, the line was open?
Yes.
Okay, and you could hear screaming on the other end?
Yes.
Were you able to make out anything about the screaming in terms of male or female voices?
No.
Number of voices?
No.
Any words?
No words.
How long would you say that line was open before it went dead again?
Couple of seconds.
Okay. And in terms of how the line disconnected, was that something you did on your end or that was something done on the other end?
That was on the other end.
What did you do next?
I called back again.
Okay, and was the line opened that second time?
Yes.
And did someone specifically answer and speak to you?
Yes.
Can you describe what you heard?
Objection.
Your Honor, these are statements of the defendant.
She doesn't know that.
May we approach?
You may.
Oh, that's awful. Oh, so I say, man, I'd rather have the jackhammer than their white noise. Yeah, imagine. I didn't realize I still had that up. Imagine 35 years. The things that she has heard and seen, the calls she has taken, that would be a wild job. I've said before, I don't know that I have the ability to stay calm for something like that, because I've said before, like when somebody would call for something, I'd be like, oh my God, what happened? Oh my God, are you kidding me? What happened? Like, it's too adult for me. Like to have to be such an adult in that situation, like to be so adulty that you have to like tell them calmly, how to get through something. That is not my jam. I cannot. I couldn't do it. I have the utmost respect for those that do. I could not do it. It's crazy. Crazy. Did y'all see that jet that's missing? It's just a jet missing. No biggie.
Ms. Menard, I asked you, once the line became up and you were able to have a conversation with an individual, correct?
Correct.
Do you know if it sounded to be a female or male voice?
A female.
Okay. And what was the conversation you had with that individual?
She said her daughter was playing with the phone and it hit her in the head. It hit her. Hit the phone.
Her daughter was playing with the phone and it hit her in the head?
Yes.
Okay. Did the person that you were speaking to identify themselves?
Mrs. Rintala.
Mrs. Rintala?
Yes.
Okay. Did they provide a first name?
No.
Okay. During the course of that call, the second call back that I'm talking about, did you hear anything else said by anyone on that line?
I heard just leave, just leave.
And did that appear to be the same voice that you had been speaking to about the phone calling on the child?
Yes.
How would you describe the tone of voice of that individual?
Action. No individual, how do you know the tone of voice?
Overruled.
Can you answer?
Stern.
Do you remember any other conversation or words that you heard coming from the other line of that call?
No.
What happened to that call?
The call was disconnected
Again?
again.
Do you know about how long it was open on the second occasion?
Maybe a minute.
Okay.
Mm,
Okay. Now, I think you indicated previously that when you get a abandoned 911 call, you always dispatch the police officers.
yes,
Do you remember in this situation, on this 911 call, if you had dispatched the officers?
I did.
Do you know who specifically was dispatched by you?
Sergeant Wishart, Detective Fenn, and Officer Jason Richard.
And did you specifically dispatch them to 18 Barton Street?
Yes, I did.
Okay. And other than dispatching the officers and perhaps communicating with them about their response, did you have any further involvement after that point in time?
No.
No additional call back to the residents?
No.
Now, Ms. Menard, you indicated that the date of this 911 call was May 12, 2009.
Yes.
Just going to show, and the presenter was been marked as exhibit number 40. Now, have you seen this document before?
At the last trial.
You've seen
You
it.
showed,
Oh, she allowed to say that?
Sustained.
Just a simple yes or no. Have you seen this document before?
Oh, she said the last trial.
yes.
Okay. And do you recognize it to be a divorce filing?
We've seen,
Yes.
Take it out the screen, please.
Uh-oh. She wasn't supposed to say that. That was one of the forbidden words. Oops. Well, we'll see how that goes. Oops. Yeah, the jet. Oh, I see. Y'all are answering the question. Yeah, just a jet, no biggie. Just went missing. Yeah, the pilot ejected out of it, and now it's just missing. Just because, you know, South Carolina. It's like a heavy news week for South Carolina. These things happen. All right, let's see. Which is normally like more of a Florida thing, I'll be honest. But when it rains, it pours in news. Have you noticed that? When we have a story somewhere, then all of a sudden other stories happen there. But Shunk of Bacon, it's funny that you say that because I literally was just sitting here making a meme about that. Because why not? I just made a here, let me pull it up. You don't know when I'm a smart aleck. I sit here and do stuff like this. So I shared the article, breaking whatever, and then I made a little Queen Janie. Alex stole it. I love her. All right, let's see. The stealth system is making it hard for them to track the jet. That's crazy, isn't it? The witness said the last trial, they asked her a question and her answer was, at the last trial. And that was one of those forbidden words.
Thank you, Your Honor. No further questions of this witness. Thank you.
I have no questions, Judge.
You may step down.
Thank you.
Your Honor, may I have permission to publish for the jurors what's been marked as exhibit number 440 by displaying it on the TV screens?
You may.
Thank you.
Members of the jury, the term publish is a term we use for some reason. It simply means that we're going to show you something. And so take a look at it, but keep in mind that because it's an exhibit, you will have it along with the other exhibits when it comes time to deliberate. So you will have all the time in the world, or all the time, I should say, that you need to view this document later.
Like those little shot things for the witnesses, like, you know, like you see on like the comedy shows and stuff. Yeah, military officials are looking for a jet because the pilot like ejected out of it and it's just flying on autopilot. It's wild, isn't it? It's like every Monday we start the week and we're like, this week has got to be calmer and more normal than last week, right? Nope. There's a jet on autopilot flying around. Nobody knows where it's at.
Thank you, Anna. Should I call the next witness?
Perhaps this would be a good time to take our morning break. We got a late start, so we're going to take a shorter break. So I will ask you to be back in 10 minutes, which is roughly 11:30. We'll call it 11:35.
All rise.
Anything before we take our break?
No.
And just so you know, I'm going to tell the jury that we're going to come back at 2:45, and that's because, as I understand it, we have a few quick matters, which is okay. Okay, so if I say 2:45, that's the reason. I understand that there may be some way around even that, but just so you know.
Thank you, Anna.
Thank you.
Court stands in recess.
All right, so this is what I pulled up because I briefly saw some stuff about it before I got started this morning. So this is what I see as the most recent. Let's see. 2 fighter jets were flying side by side when the incident took place. For unknown reasons, the jet's transponder isn't working. The incident took place over North Charleston. The jet's range is 1,200 miles. However, it's not known how much fuel was in the jet at the time of ejection. And the search for the jet is now focused on Lake Moultrie, which is about 50 miles north of Charleston. That was the most recent one I had. I'm sure there's more recent ones now, but that's the one that I read this morning. Let me see what I can find. Let's see. Let's go to the internets. Let's go to the internets. Looking at the internets. Oh, I'm not subscribing to you. Are you kidding me? No. Not for one article. No, sirree, Bob. Let's see. U.S. asks for help finding missing F-35 fighter jet after pilot ejects during mishap. Possibility it could still be airborne somewhere over South Carolina. Isn't that crazy? Stealth abilities appear to be working too well. Joint Base Charleston and Air Base in North Charleston said it was working with Marine Corps Air Station Beaufort to locate F-35 that was involved in mishap Sunday afternoon. Pilot Sunday afternoon. Wait, this was from yesterday? This is from yesterday? I thought this was from this morning. Yesterday, I was eyeball deep in research and did not look at anything going on around me. That's wild. The jet was, oh wait, I skipped some. Pilot was able to safely eject from the aircraft an F-35B Lightning II jet and was taken to a local medical center in stable condition. The jet was left in autopilot mode when he ejected, so there's possibility it could still be airborne. Jeremy Huggins, spokesman at Joint Base Charleston, told NBC News. Searchers were focusing their attention north of the air base around Lake Moultrie and Lake Marion based on the jet's last known position and coordination with the Federal Aviation Administration. Goodness gracious. Thank God he's okay. Can you imagine? Representative asking, how the hell do you lose an F-35? Well, that's crazy. Jet hunt. Jet hunt. I have I have the air map thing, but you know, that don't come up on that. Maybe they need to get the paid version of Flight Radar. I have the paid version, but that kind of stuff won't come up on there. Let's see who's over South Carolina right now. Well, this is when I was looking for somebody the other day in my friend's. There was an escapee in my friend's neighborhood. We have a falcon right there. Where are you going? You seen a jet? The Big Dog 360. Private owner. That's a private one. Ask the big dog if he's seen one. Let's see. It's another little one. Let's see. Here's Lake Moultrie and Lake Marion. I bet, you know, how crazy would, like, if I had me a little plane, I'd be like, that'd be really cool to, like, let's go find it, you know, like treasure hunting. Let's go find a lost jet. But then at the same time, I don't know if I want to be flying while there's, you know, that takes a whole lot of defensive driving to have to, you know, to know what you're doing with that. But maybe some of these little guys could find them. Let's see. What's that one? Oh, there's a Navy plane. I didn't know it was yesterday. That shows how much I pay attention, though. Like, when I tell y'all I was eyeball deep in research, I did not look at anything. That's crazy. All right, so there's the Navy one. Let's see what else is up here. But where are y'all going? Where's everybody going? Let's be nosy. Let's see. Oh, look at this guy making little, ain't he precious? Just making little 4-leaf clovers, 3-leaf clovers, technically, I guess. Not that one. That one's a straight shot. Why are these so close? That one's a private owner. Where are you coming from? Where you been? You seen a jet? What about this guy? Aircraft type not available on this guy. You know, I know we laugh about the aliens. Have y'all seen that? Have y'all seen that video? Where there's like 2 different videos, and I have not fact checked it. My kid showed it to me, and we talked about how crazy it is. But could you imagine? There's a video that the plane that went missing, and there was no record of it or anything. There's videos where it shows like these 3 things like orbiting around it, and then all of a sudden, pew, pew. It's a possibility. Where are you going? There's a chopper. Where are you going? See, this one's not available. But this Navy plane, maybe there. Where's that Navy plane coming from? Oh. Just be nosy. Yeah. That one. Have y'all seen those videos? My kid showed me a couple of them from like different perspectives and different angles, but it looks like the same type thing. There was 2 of them. But it looks like the same type thing. And I was like, if those are real, that would be nuts. So maybe these are out looking for him. Just tell him, somebody get these fellas on the phone. Ask them what they see. Oh, this one's just going back and forth and back and forth. I'm just getting all up in people's business. I love to look at those sometimes. Maybe a portal to chatter, Lori. Ooh. Oh, show you the video. Let me see. Let me see if I can find the video he sent me. Well, he didn't send it to me. He showed it to me. So I got to try to find it. Let me see. Let me text him. If he's not at work, let me check his location. Nope, he ain't at work. So see if he can send it to me. I was looking to see if I could find it on here. I don't see it. It was crazy though, because it's like, let's see. What are you doing, Luce? Oh, you tagged me in the video on Twitter. Even better. Now I don't have to wait on my... Let's see. Oh, let me go back. All right. Oh, this isn't the one I saw. Oh, wait. Yeah, it is. Yeah. See how it's got the things like going around it? It's got those three things bouncing around there. And then boom, gone. So stuff like that, like, you know, if that kind of stuff is like, what if that's real? That could be crazy. Like, just like, hey, come on with us. Let us see what you got going on there. And then the stuff, my kid's like really into aliens. He thinks all that stuff is, he's always thought it was so interesting, you know, because I totally believe in aliens. I think that it would be silly for us to think that we're the only, you know, life on Earth. But he's always been like fascinated by it, you know. And when the stuff came out where they're showing the little aliens in Mexico last week, it was he was like, that is not, like, he's like, I've been waiting this whole time, and that is not what, you know, what I was expecting to see. But he's like all excited about it anytime something comes out, because it's always like one of those things, like, you know, could this be real, could this not, you know. So it's always fun to look at everything. I definitely believe that aliens are out there. I have a family member who has seen I guess you'd call it a UFO because nobody knows what the heck it was, but it was like craziness. So, but haven't seen an alien yet. But I definitely believe they're out there. The problem is there's also people out there who will alter videos and try to pass it off, you know? So then it sucks because then it's like, it makes, you know, it makes that like when you see stuff, it makes it like, oh, you know, oh, this could be so cool. This could be, you know, this could be like actual footage, but then you can't trust people. So then you just never really know for sure. But it's fun to look at the stuff. Yeah, nobody knows what's real anymore. Yeah, I have the paid version too. That's the paid version, but it's not going to be on Flight Radar because of stealth mode. Look, you know how I know aliens are real? They took over every day at 4 p.m. Central, 5 p.m. Eastern for 3 weeks. So don't tell me they're not real. Oh, that scared me.
Secure court is back in session.
Yes.
I did not see the meme where they're like cake. That's funny though. Who do you think we'll find first? Loch Ness Monster? We'll do a poll. We'll do a poll. Aliens? All right. Good poll. Riveting stuff here. Riveting stuff here. They did enjoy our chat. Yeah, have y'all seen that? Oh my God, my stomach's growling. I forgot to eat today. Have y'all seen that that meme where it's like, oh yeah, the aliens are real. They just, they see Earth and what we're doing down here, and they, lock their doors as they're driving by. Oh, I should have added that one. You don't know that, Nikki. Somebody makes those Cadbury eggs every year. Psh.
May I, Your Honor?
You may.
Thank you, Your Honor. I want to call Barbara Fisher.
Look, if Easter Bunny was real, he would be terrifying. Could you imagine like a 7-foot rabbit?
You stand for basic court every morning.
You solemnly swear or affirm that the evidence which you shall give to the court and jury in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, or do you so affirm?
I do.
Thank you.
Good morning.
Good morning.
Could you please state your name and spell it for the jurors?
Barbara Fisher, Barbara Fisher.
Ms. Fisher, did you previously go by a different name?
Yes.
What was that?
Barbara Fenn,
And when did you use that name?
when I was employed with Granby Police Department, was changed in 2018.
Okay. You indicated that you were previously employed with the Granby Police,
Yes.
and what years did you work there?
From auxiliary in 1996 and permanently retired in 2019.
Okay, can you tell us about the various roles that you had over that period of time?
Patrol, SRO, court officer, detective,
What is SRO?
school resource officer.
Okay. How many years did you spend as a detective with Granby PD?
About 13 years.
And what were your duties when you held that role?
Primary investigations
And what types of cases would you primarily investigate?
from B&Es, breaking and entering, sexual assault cases, various types of car accidents, crime scenes.
Okay. And you indicated you retired in 2019?
Yes. Officially.
I want to ask you about the date of May 26, 2009. Do you
Yes.
remember
It's my
that
daddy's
date?
birthday.
Yes.
And do you remember what you were doing at 1:18 p.m. in the afternoon?
I was in dispatch.
And why were you there?
The dispatcher had to leave the room.
And do you remember what dispatcher was working that day that had to leave the room?
Lynn Menard.
Okay. And why was it that you were, what were you doing for her?
I was just covering the phones.
Would that be any types of calls that had come into the Granby Police?
Yes.
That include 911 calls?
Yes.
Or calls into the business line?
Yes.
Is this something you had done before when Ms. Menard or another dispatcher had to step away from the desk?
Yes.
At approximately 1:18 p.m., do you remember a 911 call coming in that you answered?
Yes.
And do you remember who it was that was speaking to you on that 911 call?
Yes.
Who was that?
Cara Rintala.
And prior to that 911 call, were you familiar with Cara Rintala?
Yes.
How so?
She did work the town's ambulance service.
Okay. And so you knew her professionally
Yes.
as a paramedic and a firefighter?
Yes.
Do you see the person that you knew to be Cara Rintala here in the courtroom today?
Yes.
Can you please indicate where she is in article of clothing for the record?
She's sitting to my right when in an olive colored shirt.
Your Honor, the record reflects to identify the defendant.
You will.
This 911 call that you took from the defendant on May 26th, was that recorded?
Yes.
And have you had a chance to listen to that recording prior to today?
Yes.
Your Honor, at this point, I would ask to play what's been marked as exhibit number 41, which is that 911 call.
Okay.
Entry. Good girl.
If I could just have 1 second, Your Honor, get the TV working again.
What's an emergency? Well, it's not an emergency. I want to come down and speak with an officer, please. This is Cara Rintala. It's not an emergency. I'm going to let you know that I want to come down and speak with my daughter. Okay. My spouse and I are disagreeing, and she's threatening to take my daughter from me. You want us at the hospital? No, I'm very upset because my spouse and I are going through divorce proceedings. Okay. And she's over my head in the back there. She'll take everything from me, she'll take my daughter, she'll do the talk to you. Can you come down there? I feel like I'm walking to that show, and I feel like I'm walking to him. Are you alone right now? No, I have my daughter. I'm sorry, I'm not going to cry. Is she there now? She is, you know, she's very good, but she's always crying. I'm joking. Can you come here? Why are you doing this? I'm so upset. Oh my gosh, like I'm walking on that shoulder. I'm upset. I'm upset. I'm upset. I feel like I'm really upset. And my daughter's fine, you know, everything
Attorney Sewell, there was an instruction. Did that relate to this exhibit?
Yes, it does in part, yes, Your Honor.
Should I give that now?
I think that would make sense. Yes, thank you.
Members of the jury, you've just heard an audio exhibit that was accompanied by words on the screen that come from a transcript produced at the Commonwealth's request. You may or may not find these words helpful in understanding and interpreting the audio, which again is an exhibit and you will have during your deliberations. However, it is up to you, the jury, to determine what you hear in this exhibit. So if what you hear does not match up with the words shown on the screen, you should disregard the words and instead rely on what you hear.
Thank you. Madam, maybe we approach sidebar?
Well, I guess upset is one word that's allowed. Oh, that's awful. There we go. That was the defendant who was saying that she was upset. She was very upset. Hysterical. Yeah, they had, I mean, you can tell, like, just from their history and stuff, like, you know, you can tell that that was a toxic situation. Which makes this interesting too, because yeah, like Buffy Bot says, I don't think the volatility in this relationship was one-sided. I think that I don't know. I mean, you know, and also to like think about if when things get toxic and think about like, you know, how bad they can get. And it just, when you're already exhausted emotionally and physically and mentally over something, and then it keeps happening, you know, it just keeps irritating the situation even more and things get worse and worse. So it's crazy. But yeah, that was Cara. That was the defendant saying that she was upset. I don't remember. How long were they together, y'all? I don't remember that. This is like the first case that we've done where I haven't done a lot of digging on it before we started, because we started it before they did the Hollywood case, because they still weren't releasing it, and it had been so long on that one. So we started this one not knowing what was happening with it. But Kathy has a good video with a lot of the information on it. So during lunch break today, everybody go check that out. She's done the digging, so we don't have to. Yeah, they had a daughter who was 2 years old at the time. So she'd be a teenager now. Isn't that crazy? I feel terrible for the daughter too, because I mean, this is, you know, her two parents, and could you imagine having to go through, this is the fourth time she's had to go through the trial of one parent allegedly killing the other. How terrible is that?
At this time, with the court's permission, I'm going to publish for the jurors, on the TV screen what has been marked as exhibit number 42. I'll just scan down slowly on that document.
So that one was May 26th. The only reason I remember that is because it's my daddy's birthday. She was in jail, but after the last mistrial, I think they gave her bond, so she's been out since then. I believe it was hands, right? So Annamarie filed for divorce. I am not sure who has their daughter. But I mean, keep in mind, as long ago as this happened, I don't know that they would have let her go back because she's only been out the last couple years. You know, while the 2 mistrials were happening, she was still locked up, and then there was the conviction. So what are you wanting for? We'll go out in just a minute.
Detective Fisher, I have a couple of additional questions for you. After the 911 call that we just heard, after you spoke to the defendant on the 911 call, what did you do?
I responded to 18 Barton Street.
And did any other officers go with you?
Officer Jason Richard.
Okay. And do you remember if you were wearing a uniform? Did you typically wear a uniform as a detective?
No, plain clothes.
Okay. Do you remember if Officer Richard had a uniform
I
on?
believe he was in uniform.
Okay. Separate cars or the same car?
Separate.
Okay. And when you got there, well, could you estimate approximately how long it would have taken you to arrive there from the station?
2 to 3 minutes.
Okay. When you got there, did you observe anybody outside?
Yes.
Who did you see?
Cara Rintala and Annamarie Rintala.
At that period of time, do you have a memory of seeing their daughter Brianna?
At that moment, no, I don't recall that,
Okay.
where she was at that point.
And where specifically did you see Cara and Annamarie?
They're on the front lawn.
Okay. And prior to this date, were you also familiar with Annamarie as a paramedic? Do you
Yes.
remember?
Yes.
Okay. And who did you speak to either one of them?
I did.
Who did you speak with?
And
And who did Officer Richard speak with?
Cara.
Okay. Without getting into any of the content of your conversation with Ann, how would you describe her demeanor?
She was upset.
After you and Officer Richard spoke with the defendant and Annamarie, during those conversations, did you provide them any information about some options to seek a restraining order?
Yes.
Okay. And did you see them leave 18 Barton Street sometime after that?
Yes.
And did they indicate where they were going?
Going to Eastern Hampshire District Court in Belchertown.
Do you know if they left in the same car or different cars?
Separate.
Are you familiar with the Eastern Hampshire District Court?
Yes.
And do you know approximately how far away it is from 18 Barton Street in Granby?
5 to 6 miles, maybe.
Did you accompany either one of them to court or go to court yourself in your own vehicle?
No.
After that, did you have any additional involvement with them at all that day?
No.
Your Honor, with the court's permission, I'd ask to display what's been marked as exhibit number 43 for the jurors on the screen.
Right.
In a minute. It's not time yet.
Your Honor, at this point, I would publish, with the court's permission, what's been marked as exhibit number 44.
May I do so?
Thank you, Your Honor. Your Honor, may I now display for the jurors on the screen what's been marked as exhibit number 45?
You may.
Thank you.
My kid is just now texting me back about the aliens.
Your Honor, may I now display on the screens what's been marked as exhibit number 46?
Hold on just a minute.
Yes.
Yes, thank you, Your Honor.
Okay, let me see.
You would think this dang dog is abused. Come here. Come here. You're so needy. Come here. Come see your mama. We'll go out in just a minute. She knows it's almost time for our break. You're so needy. You're so needy. They all see you acting up. They see you. They see you acting up. Yeah, they see it. They all know you. They know you're spoiled. They see it. They'll be breaking for lunch in just a couple minutes, so I can take her out when we take our break. Oh, you're so bad. You're so bad. You see this? Trying to get sympathy. Trying to get sympathy. Oh, yeah. Oh, yeah. She's been a trooper, though. I've been glued to my desk like yesterday, well, pretty much all week, working on everything. So she's been a trooper.
Just for the record, I'm displaying again what's been marked as exhibit number 46. And lastly, Your Honor, at this point, I would ask permission to publish to the jurors what's been marked as exhibit number 47, which is a restraining order hearing recording from the Eastern Hampshire District Court.
You may.
Thank you.
Do we have that same instruction?
Yes.
Thank you.
So again, members of the jury, you're about to hear an audio exhibit that will be accompanied by words on the screen that come from a transcript produced by or at the Commonwealth's request. Again, you may or may not find these words helpful in understanding and interpreting the audio. However, it is up to you, the jury, to determine what you hear in this exhibit if what you hear does not match up with the word shown or what you see on the screen, you should disregard the words and instead rely on what you hear. In other words, what's important is what you hear, not what you read. And if those two don't square or match up, then you need to consider only what you hear. Go ahead.
I'll call the cases at this time. On docket number 0998 RO132, Cara Rintala versus Annamarie Rintala. On docket number 0998 RO133, Annamarie Rintala versus Cara Rintala. Would you please raise your right hands? Do you solemnly swear or affirm to make true answers to such questions that shall be put to you by the court in a manner now pending? So help you God. Thank you.
All right, and for the record, who is Cara Rintala?
I am.
And you are Annamarie Rintala? And is it my understanding that the two of you are married? And there is a child involved here, is that correct, Brianna?
Yes.
And both of you are here seeking restraining orders, is that correct?
Yes, sir. I am.
Yeah, I think you both are. And you're what's the status with the marriage at this point? Is there a divorce action taking place?
Karen had gotten to an altercation on the 12th, the morning of the 12th.
Listen to my question. This incident happened on the 12th. Why is it that it's 2 weeks later that we're now in court?
Because Karen was served with divorce papers this morning by the sheriff. She went ballistic. Brianna and I left the home. Upon our return, which is around 1 o'clock, she started screaming and yelling, "You're not taking my house, you're not taking Brianna." Because
That's fine, you've answered the question. The Cara Rintala, what is the basis of you seeking a restraining order? Go right ahead.
Today I reached all that I can take, and I'm afraid to be in my house because of what Ann's gonna say, because I'm constantly threatened, verbally and bodily, as far as in my personal space all the time. And I called the police department twice, and I had asked what to do about it. And today she's right. I mean, I filed 2 weeks ago, and I held it off, and then I told her.
You filed what 2 weeks ago?
I filed divorce 2 weeks ago.
You filed papers?
I did, and then
And
I didn't have them served because my lawyer said that double luck, because they can't afford it, and let's see if we can't do the mediation together. And I told her, and she freaked. And then about a week ago, I told him so that she could start saving some money if we could do it together. Or she'd have to come up with a lot of money. And then when I told her that, she went and got a lawyer and had me served. So when he called me Friday, we were going to the zoo. And on Friday, you can come to the zoo and meet me, or I'll be home all week long. So that's when I got the papers today. And what brought it up today is I had taken Brianna, our daughter, down to see my family in Rhode Island on Sunday. And when we came back, Ann said since I had her by myself, that Ann wanted her for herself today or tomorrow. And I said, go ahead. Go right ahead and take her. I don't ask for her. She's going, I'll ask when she'll come back because, she's her mom too. But if it were me, I need to, I have to tell her exactly where I'm going and when I'm going to be back. And so today, I was reading to my lawyer about the whole thing, and we had always said we were going to share custody because Ann loves Brianna as much as I do. And I'm a great mom, and she's a great mom. And when I read down the fact that she was going for custody, I called her on the telephone because she had said she wanted the day with her. I said, by all means, of course she can have the day. And so we were talking on the phone, and then I hung up because I was very upset. And I talked to her mom, and I said I was upset because we had agreed that we were going to do this together. And I was in my car to go travel in, and she was behind me. And she drove one way and I drove the other. And when she came home a little bit later, But Brianna came running to me because I hadn't seen her, you know? And was upset, was mad because she was only there for a little bit and I was holding her, and again, she just loud, and she constantly threatens me with, because we had up until October, there was an incident in October, and we had, the two of us had, you know, it's a long story, but up until October, she said it's only been verbal. And she constantly threatens me that she's gonna take my job, my livelihood, you know, my daughter, and she's constantly threatening me. I call my parents, I've called 3 lawyers because they don't know what to do. I feel so helpless. It's like, how? It's because no matter what I do, if she comes in my face, I have to look away or look down because she says we already have set precedent.
All right.
So I'm afraid. I want peace in the house. My family lives in Rhode Island. It's not, and I own the house. I pay the whole mortgage myself. I pay all the bills myself. And that's what I don't need. And his family lives 1 town away. He said, is there any way you could just stay with your family for a little bit? Just because so we don't, there's no volatility in front of Brianna. And that's all. I'm just nervous. I don't know what to do.
Well, I'm sorry? Very briefly.
I was very upset because I wanted a divorce. No, I filed first and, sorry.
I would have taken on care of schedule, so when she has to work, I have to take days off. I'm like the primary caregiver for Brianna. I'm always in the home. I cook, I clean, I do everything for Cara. She made $80,000 last year. I made $20,000 because I'm a stay-at-home mom for Brianna.
All right.
Her problem is she doesn't want me to have. I filed before, she's very upset with me. We have a court case, I have a restraining order against Cara.
And that case was,
All dismissed because there were lies.
all right.
So I believed her, and since then, the reason why, I actually spoke to her on May 6th, May 12th, when I told Cara I wanted a divorce, she went and did the paperwork, and since then, taking my name out of things and trying to get my name, trying to get these papers, and get my name off.
All right. This is an issue that goes well beyond a simple restraining order. We can have criminal charges going back and forth against both of you, and the only one that's going to really affect in the long run is your daughter.
Right.
Because eventually, with what's going on here, DCF is going to be involved.
Right.
And neither one of you will have to worry about custody, because the DCF will come in, and the DCF will take the child and deal with the child and put the child in a home that's a little more stable. That's where we are. With respect to both of you. Listen to me.
Ooh.
I'm going to issue 2 restraining orders of no abuse. No abuse. The 2 of you both have lawyers in the probate court. Deal with it with respect to your marriage. Get into the probate court and resolve it. I'm not going to order the custody of this child to either of you at this point. You're going to have to deal with it as parents.
Did I say something?
Very briefly.
Thank you for the joint custody, because that's what truly is best for our daughter. I firmly believe that. Second of all, as far as the home situation, it's very volatile as far as like arguments, and it's not healthy for us folks to be there, which is what I called the Granby Police Department. They came down today and they told me to come here because I fear that Brianna hears, this, and we can't both be there.
Yeah, then you know something?
There's 1 town away. Is there any way, and please, if my family lived next town, I would go there.
If you wanted to go there, I'm going to give her the custody of the child at this point. I'm not going to play games with this. The 2 of you can either deal with this as adults and deal with it in the probate court as your marriage dissolves, or if you want, I'll call DCF right now. And I'll have DCF come in here, and I'll indicate to them that I don't think either one of you is stable enough to deal with that child. That's how close I am to going off this bench and picking up the phone right now. Is that what you want?
Definitely not.
Is that what you want? And the ultimate issue of custody and visitation and support, all of that's gonna come out of the probate court. But right now, the two of you are gonna walk a very fine line. You're either gonna exist in that house until you get this straightened out, or you're gonna look at criminal charges, one or both of you, and I can promise you this. If one of you makes an allegation of abuse against the other, you better have documentation, because the other one's gonna make the same allegation, and at that point, there's gonna be criminal charges against both of you. And I promise you, if I see that come into this court, I will be on the phone to DCF so fast, they'll be here before you get out the door.
Wow. Wow.
Members of the jury, I'm going to give you the same instruction I gave with respect to the arrest and the criminal charge that was dismissed. Again, this evidence is being introduced for a limited purpose, to the extent that you find it credible, and to whatever extent you feel that it deserves weight, and that's up to you. It's weight. In other words, the importance you assign to it. You can only consider it for the limited issues of the defendant's motive, state of mind, and intent, and as to whether there was a hostile relationship between the defendant and the alleged victim. Again, you may not consider this evidence for any other purpose.
Detective Fisher, the day that you responded to the home at 18 Barton Street and the day of these restraining orders was May 26, 2009.
Yes.
Do you remember responding to that house on March 29, 2010?
Yes.
Are you aware of any calls coming into the Granby Police Department from 18 Barton Street, or requests from either Cara or Annamarie between those two dates of May 26, 2009 and March 29, 2010?
No.
I want to ask you about the date of March 29, 2010. Were you working as a detective on that date?
I wasn't working at that time, but yes.
Okay.
Yes.
You were on call or came in based on a call?
Yes.
Okay. You were a detective with the department?
Yes.
And ultimately, did you respond to the home at 18 Barton Street in Granby?
Yes.
Do you remember who called you asking you to come in?
At the time, Sergeant Mark Smith.
Okay. Was he one of your supervisors?
Yes.
And when you were called, did you respond directly there or go to the station, if you remember?
I went to the station first.
Okay. And then ultimately, did you go there?
Yes.
Do you know approximately what time it was that you arrived?
Around 8:30 p.m.
When you arrived, can you generally describe what sorts of personnel or vehicles were there?
I first encountered Sergeant Smith, and then I entered the house. That's who I saw out front.
Okay, so you saw Sergeant Smith outside of the home?
Yes.
And after, did you, again, without getting into any content, did you have a conversation with him?
Briefly.
Okay, and then you entered the home?
Yes.
Do you remember what door you entered through?
The side door.
Under the breezeway?
Yes.
Okay, when you entered the home, where in the home did you go?
Entered through the door and then into the kitchen.
And did you see anyone already in the kitchen at that time?
Yes.
Who did you see?
Paramedic Pandora, he was standing in the kitchen. Officer Polar, and Gene Oz and Cara
Okay. And where specifically did you see the defendant, Cara Rintala?
at the kitchen table.
Was she sitting with anyone at that time, if you remember?
Yes, Gene Oz.
At the time that you arrived and observed them there, were you aware of what was happening at the kitchen?
Yes.
Okay. Did you overhear any conversation between them?
No.
Okay. At some point, were you asked to stay with the defendant yourself?
Yes.
And that came after this point in time when you saw her in the kitchen?
Yes.
Did you say hello to her whenever you initially saw her? Do you remember?
I don't remember acknowledging her.
How was it that you came to spend some time with the defendant? What was the reason for that?
Through the direction of Trooper McGarrian, asked me if I would stay with Cara.
Okay. When you arrived on scene, do you know whether or not Trooper McGarrion was already there?
I don't recall seeing him initially.
Okay, and is that Trooper Jamie McGarrion?
Yes,
Do you know him to be a state police detective?
yes,
And he asked you to sit with the defendant?
yes.
Where specifically did he ask you to do so?
In the living room.
Do you know how you got to the living room area?
At one point, we all exited from that side door and were asked to enter through the front door.
Okay, and did you do that?
Yes,
Did you see the defendant do that?
yes,
And then were you with her in the living room area?
yes.
Does the front door to the home go into the living room? To your memory?
I don't recall if it was
Okay.
directly into there.
Okay, but you went in the front door and went to the living room there.
Yes.
Did you sit down with her?
I don't recall if I was sitting, but I was in the same room with her, yes.
Okay. And were you within her presence for a period of time?
Yes,
At some point after that, were you asked to do anything in regards to the defendant's clothing?
yes.
What were you asked to do?
Trooper McGarren asked if I could seize her clothing.
Okay, and how did you go about doing that in terms of a conversation with the defendant?
I asked her if I could escort her to the bathroom, and then she'd have to disrobe, and I'd have to take her clothing that she was wearing at that time.
Was she cooperative with you?
Yes,
And where specifically in the home did you go?
in the bathroom.
Okay. In terms of the bathroom itself, do you remember the size of the bathroom?
Very small.
Okay. Did you go physically into the bathroom with her?
Yes,
And just the two of you?
yes.
Okay. And do you remember if the door was closed or open?
I think it was small enough that the door wasn't quite closed completely.
Okay.
Yeah.
Did she take off her clothes in the bathroom?
Yes,
And did that include all of her outer garments?
yes,
Okay. As well as some jewelry?
yes,
Now, did you take possession of it while you were in the bathroom?
yes.
Okay. And while she was disrobing, were you watching her at that period of time?
I was watching, making sure nothing was disturbed at that point, yes.
Okay. Were you examining her body?
No,
After the bathroom, where did you go with her?
to her bedroom.
What was the purpose of that?
So she should get put on clean clothes.
Okay. And was that sound down just a couple doors down that
She-
same hallway?
Yes,
Just the two of you still?
yes,
All right. And was she able to retrieve some clean clothing in there?
yes.
Did you do that for her or did she do that herself?
She did,
All right. Were you with her during that period of time?
yes.
Did you examine her body at that period of time?
No,
In terms of the clothing that you had collected from her, what did you do with that?
that was placed in paper bags and was turned over to the state police.
When you took the clothing, do you remember if you were wearing latex gloves?
Yes,
Okay. And the paper bags, was everything put in a single paper bag or individual bags?
each item was placed in an individual bag.
All right, and you turned that over all to the state police?
Yes,
After the defendant was able to retrieve some clean clothes from the bedroom, where did she go?
right back to the living room.
Did you go with her?
Yes,
Do you also remember at some point taking the defendant's cell phone?
yes.
Do you remember who requested that you do that?
Trooper McGarren.
Okay. And did you have a conversation with the defendant about that or Trooper McGarren, to your memory?
I believe I presented her with the consent form to take her phone.
Okay. And did she sign that?
Yes, she did.
Would you describe her as cooperative?
Yes,
At some point, well, let me ask you this. After that point in time, to your knowledge, did the defendant remain in the living room area of the home?
to my recollection, yes.
Okay. At one point, did you leave her presence and go over to 20 Barton Street?
Yes.
And what was your reason for going over there?
I went with Lieutenant Trooper Whitney to interview Brianna.
Detective Lieutenant Robin Whitney?
Yes,
With the state police?
yes,
Okay. And to your knowledge, did she work with Trooper McGarrion?
yes,
And you went with her in order to try to speak to Brianna?
yes.
How did you know Brianna was over there, if you know?
I don't recall how I knew she was there.
Okay. In terms of the attempted interview, were you trying to speak with Brianna? Was Detective Lieutenant Whitney or both of you together? What role did you have?
I was present. Lieutenant Whitney did the interview. She did most of the, conducted the interview.
Okay. When you went over to 20 Barton Street, did you come into contact with any adults that you remember?
I don't.
Okay. You remember at least some adult was caring for Brianna over there?
Yes.
Okay.
Yes.
All right. And in terms of the conversation with Brianna, was that short in nature?
Yes.
Fair to say she wasn't willing or able to speak to you?
Correct.
Okay. Do you remember her being about 2.5 years or the age at that time?
Yes.
Now, at some point later that night, did you go to the Granby Police Station?
Yes,
And ultimately, were you present during an interview conducted by the Detective Lieutenant Whitney of the defendant?
yes.
And what role did you have in terms of the interview with the defendant at the Granby Police Station?
I was present in the room.
And was that audio and video recorded?
Yes.
Now, before, at any point, before you left 18 Barton Street, before you went to the station and were present during the interview of the defendant, did you go down into the basement at 18 Barton Street yourself?
No,
Okay, so you never saw the basement yourself?
no.
This is that judge.
Like you just have one moment.
He's retired now. This is the one who was just yelling at them.
After the interview that you were present for of the defendant, conducted by Detective Lieutenant Whitney, what involvement in any, if any, did you have in terms of the investigation in this case?
Very minimal. I just had some specific tasks that I was asked to do.
Okay, and who would ask you to do those tasks to your memory?
Usually Trooper McGarrian.
Okay, what sort of tasks, if you remember?
I did some canvassing at some point, and also some retrieval of some evidence, surveillance type cameras in different businesses.
Okay, when you say canvassing, are you talking about the neighborhood around 18 Martin Street?
Yes,
Trying to speak to neighbors and such?
yes,
Did you do that within a couple of weeks after March 29, 2010, to your memory?
yes. It was in April sometime.
Okay, and the surveillance video that you did, same thing, same time frame, in other words?
Yes, to see who had cameras and such. Yes.
Okay. And in terms of any information that you gathered from either the canvas or looking for surveillance videos, what did you do with that information?
All of that was turned over to state police.
Did you follow up yourself on any of that information?
No,
Do you know what follow-up, if any, the state police did with that information?
no.
After April of 2010 or so, were you involved in terms of having requests to participate or help with any tasks to your memory?
The only task I recall was being asked to do a measurement from one property to another.
Okay, and specifically, were you asked to do a measurement from the door at 18 Barton Street to the door at 20 Barton Street?
Yes.
Okay, and how did you do that?
It was an odometer on wheels that's on a metal pole, and I measured out as far as calibrating it from like a 36-inch point, started at the top and wheeled it to 36 inches to calibrate it, make sure it was accurate.
Okay, and then did you use that, the distance between the door at 18 Barton to the door at 20?
Yes.
Do you remember which door you used at 18 Barton?
It was the side door
Okay, under the
by the
breezeway?
breezeway.
Okay. And do you remember using that measuring wheel, what the measurement was between those two residences?
184 inches.
184?
I'm sorry, feet. Feet.
184 feet?
Yes.
Okay. I'm just gonna show you what's been previously marked as exhibit number 48. Do you recognize what's depicted in that photograph?
Yes.
And what do you recognize that as?
The house on the left? Or the-
Both.
Both, yeah. 18 and 20 Barton Street.
Okay, and are you able to show us with the pointer that's located right behind you, propped up there? If you could, you see it on the back wall?
Oh.
If you could just stand and show us which house is 18 and which house is 20.
This is 18 and this is 20.
Okay, and that's the measurement you took?
Yes. On the
Okay.
side over here, to the front door here.
Okay, thank you. You can resume your seat. Thank you. I have no further questions on it. Good afternoon.
Good afternoon.
I have a few questions for you. First of all, is it fair to say that when you entered and exited
Fair
the
to say.
house at 18 Barton Street, that you did so with that side breezeway door?
Yes,
Okay. And did you put any booties on or anything to protect your feet before you entered?
I did not.
Did you see anyone else doing that?
I did not.
And did the door that you went to, that seemed to be the door everybody was sort of entering and exiting that night?
I can't speak for everybody else. I know that's the door that I entered and then who exited at one point.
Right. Do you remember previously testifying that you thought it was the door everybody was entering and exiting that night?
From my recollection, it was the people that I know when I got there that entered and then exited.
Okay. But you remember previously testifying that it seemed that everyone was going in and out of that door?
I don't know what I meant by everyone, but yes.
You remember saying that?
Yes.
Okay. And you remember being asked the question about that door, and you say, that seemed to be the door that everyone was going in and out of, correct? And you said yes. Do you remember that?
Yes.
Okay. Now, you testified on direct examination as to taking Cara into the bathroom to take her clothes. Do you remember that testimony?
Yes.
Okay. And she didn't object at all to taking her clothes, right?
No.
Okay. And it was something that Trooper McGarrian told you to do, right?
Yes.
And he ordered you to accompany her into the bathroom to take her clothes. Is that right?
Yes.
Okay. And that bathroom was fairly small. Is that right?
Yes.
And it was just you and Cara in there. Is that right?
Yes.
And you saw her remove her clothes, right?
Yes.
All of them?
Yes.
Okay. And that included her underwear?
I don't recall the underwear.
No.
I don't.
You don't recall her being naked?
Yes.
Okay. You recall her being naked. You were about 2 to 3 feet from her. Is that fair to say?
Yes.
Okay. And you had ample opportunity to view her body. Is that correct? Right there in the small room.
Yes, but the situation wasn't conducive to really seeing her entire body at any one time.
Was she trying to hide anything from you?
No.
Okay. So if you didn't, I'm not asking you whether you examined her.
Okay.
But I'm asking you, did she attempt to hide anything from you?
No.
Okay. And you were standing right there as she took off her clothes, right?
Yes.
In a room that's pretty small, right?
Yes.
Okay. And at some point, she was completely naked, right?
Yes.
Okay. So now you remember completely naked.
Yes, ma'am.
Okay. So she took off her underwear.
Yes, ma'am.
And she took off her bra.
Yes.
And she was standing there completely naked.
Yes.
And when she was standing there completely naked, you didn't notice any bruises on her, right?
I did not.
And you didn't notice any blood on her, right?
I did not.
Okay. And when she went into the bedroom, so when she's naked in the bathroom, she walks down the hall of her house naked to her bedroom. Is that what happens?
Yes, but it's not a very far distance from the bathroom to the bedroom.
Okay.
Very short.
And just to be clear, you didn't see any abrasions that caught your attention. Is that right?
No.
Okay. And if you had seen abrasions, you would have made note of it, right?
Yes.
Okay. And you didn't make any notes that there were any abrasions on her body anywhere.
Correct.
Okay. And there was nothing in your notes regarding any blood underneath her clothing. Is that right?
Correct.
Okay. And you didn't notice any blood on her or any blood coming out of her nose. Is that correct?
I did not.
Okay. And Cara didn't resist in any way. Is that fair to say?
It is.
Okay. And I think you described her as fairly cooperative. Is that right?
Yes.
Okay. Now, you also testified on direct examination about going across the street to 20 Barton Street. You remember that testimony?
Yes.
Okay. And you actually wrote a report in this case. Is that right?
I don't recall.
You don't recall writing a report?
No.
Report's finished, Your Honor?
Right.
Thank you.
Sure. Take a look at that. Second page is the one I'm interested in.
Thank you. Okay.
Is that your report?
Yes.
Okay, and it appears to be the report you wrote after this incident. Is that right?
Yes.
Okay. I just have that for a second. After having read that, does it refresh your memory as to whether or not you interviewed Roy Dupuis, who lived at the house at 20 Barton Street?
From reviewing that, yes.
Okay. And it's fair to say that he said that Cara came over around 7:15 and said Ian was in the basement and to call 911. That's in your report. Is that right?
I recall him saying they called 911 or to call 911.
Well, Your report's a little more than that, doesn't it, ma'am?
I'm still going by memory.
Okay. I want you to read your report and see.
Okay.
Now, ma'am, does that refresh your memory as to whether or not you wrote in your report that, sorry, I want to get it right, that Cara told him that Ian was in the basement and to call 911? Is that what your report says?
It does.
Okay. And he said Cara seemed distressed and pretty upset. Is that right?
From what he states, yes.
Okay. And there's nothing in your report about Roy Dupuis saying it was a domestic, right?
No, I don't believe so.
And he never, in fact, told you it was a domestic, right?
I don't recall that, no.
Well, if he said it, it would have been in your report, right?
Yes,
And it's not in your report, right?
correct.
Okay. And then you mentioned on direct examination that you saw Gary Kohler at the scene, is that right?
Yes.
I'm sorry, Michael Pandora?
Yes,
And Michael Pandora was one of the interviews that you were actually at, is that right?
yes,
And when Michael Pandora gave you a statement, do you remember him saying that Ian was trying to figure out a way to stop the divorce?
Objection.
Sidebar.
Sidebar. Take a shot, do a squat. She says right a lot. Like as much as Thami's lawyer, Joshy. Yeah, this one is messy. This is a whole big messy situation. I still want to hear from the boyfriend though. That's what I'm like. So I'm all about, like, I just want to, I want to get the tea. Bring the boyfriend. Bring the mister. And he's got a whole wife. Just so we're clear, the boyfriend has a whole wife. All three parties involved had a whole wife. But yet, I got a piece of hair in my mouth. I am a mess today. Speaking of messy. I did not see how long I did not see. I don't know if somebody else did. Did anybody else see how long they estimated this trial to be? I did not see that. But Thursday and Friday, I will not be streaming because I will be gone to CrimeCon.
So do you have a memory of the interview of Michael Pandora?
No.
I'm just going to ask you to focus on the second to last paragraph in this report.
This is not my report.
This is the interview that you were at.
I was at, but I did not write this report.
Right. I'm not asking if you wrote it. You were there, and I'm asking you questions about it.
Okay.
You were there. Can you read that paragraph to yourself, please?
Which
ma'am?
one?
The second to last paragraph on that page?
Several months after.
No, to yourself.
Oh.
I'm going to skip on Jim Griffin. We'll skip that part. I want to actually believe the people that I'm listening to when I'm there.
Yeah, and after having read that paragraph, does it refresh your memory as to whether or not Michael Pandora told you and Trooper Bresnahan, who was the other one interviewing, that Annamarie Rintala wanted to stop the divorce.
It does not.
Does it refresh your memory?
No,
I mean, did you read the whole thing?
I did.
Okay. So this part right here,
Yes.
did you read that paragraph?
Yes, but I don't recall the interview.
You don't recall the
I
interview?
do not.
Well, you know you're gonna be testifying here today, right?
Yes,
Okay. And you know you're gonna be asked about what you did in the investigation, right?
yes.
Okay, so you remember everything about that night, everything that Cara said, but you don't remember this interview, is that right?
I never stated I knew everything. And no, I did not write that report or to have I review that report.
So take your time to review it, man. Review the whole thing. Maybe that'll bring it back to you.
Well, that's the thing. I'm not going to remember it.
Well, you don't even know, you haven't tried.
Objection.
Well, I'll permit this witness to take a look at the entire report. If it doesn't jog her memory, it doesn't jog her memory. She can state as much.
Fanny pack, pressing your luck there. Just start the stream remotely. You know, take it from there. I was checking every once in a while. Carol, you're late. Tisk, tisk, Carol. I'm just joking. Come on in. Have a seat. Have a seat. Have a seat. Grab you a beanbag or a cushion or couch or a chair. Oh, I didn't do the throne this morning. Oh, failed miserably. That's what happens when I'm sleep deprived. I forget things. I'm sorry. I forget things. I hope it takes 2 days for her to read it. We'll just sit here and watch paint dry while she's reading the report that she says won't jog her memory because she doesn't remember it and didn't write it. We'll just sit here. Read our own books. We'll take time. We'll take this time to meditate. Deep breaths in. Deep breaths out.
It's been 84 years.
She's reading.
2 hours later.
She's still reading. It's fine. Everything's fine. Everything's fine. Everything's fine. We can do squats. Take shots. Yeah, Cameron could at least be on the judge. Judge is a cutie. He is. Normally I don't go for the rule followers, but he's a cutie. She didn't come here to read, but yeah, they're making her. What? Oh my gosh, that would be freaking hilarious if she took like 3 hours to read it, and then she's like, nope, doesn't refresh anything. Oh my gosh, that would be hilarious. That would be so funny. Have you refreshed? And she'd be like, no.
Have an opportunity to review that, ma'am?
Yes, ma'am.
Does that refresh your memory as to the interview with Michael Pandora on March 30th, 2010 at about 14:34 hours?
It does not.
See?
No.
Okay. Do you ever remember learning in the course of your involvement in this investigation that Annamarie Rintala wanted to stop the divorce proceedings?
Yes.
When did you learn that?
Probably around the time of when we responded to the call on the 26th of May.
Okay. And so you knew that before this incident, is that fair to say?
I don't recall.
Okay.
When exactly.
But do you know whether or not your police department or the state police did anything to investigate the steps that Annamarie Rintala took to stop the divorce proceedings?
I don't.
Do you know whether you were assigned to do anything to investigate Annamarie Rintala's wish to stop the divorce proceedings?
No.
Okay. Now, in terms of you being present when Cara Rintala was interviewed, you remember that testimony of direct examination? That you were present?
I was present, yes.
Right, okay. And you took some notes, right?
I don't recall taking notes, no.
You know?
I don't.
No one showed you your notes before today?
No.
Okay, let me ask you a question. Do you remember Cara Rintala being asked if anyone would want to hurt Ann, and her saying the name Paul Michelson, who's having an argument or some ongoing altercation with Annamarie Rintala?
No.
An argument.
Take a look at these notes. Tell me whether or not you recognize them. Those appear to be your notes?
They are not.
They're not your notes?
No. It's
Okay.
not, my name's not even spelled right on that.
So do you remember during Cara Rintala's interview mentioning this name, Paul Michelson?
I don't.
Okay. Do you remember ever being assigned to investigate a Paul Michelson at all?
No.
Did anyone ever ask you to investigate Paul Michelson?
No.
This is not going how
I have no further questions.
I think it was expected.
I have nothing further. Thank you, Your Honor.
Okay, you can step down. Thank you.
Thank you.
So it's almost 1 o'clock. Going to take our lunch break. I have a few quick matters at 2 o'clock that I have to attend to. I apologize for that, but I am the only Superior Court judge who sits in this county. Only one judge sits at a time, and we've done our best to reschedule other things, but there are a few things I need to address. So I'm going to give you a longer lunch break and ask that you be back here for 2:30.
I'm gonna pin that. Pin it. She's like, who's texting? Who's texting?
All right, so we were able to clear the decks for this afternoon, so I'll see you back at 2 o'clock.
Thank you. Thank you.
So they'll be back at 2 to argue some more. Hot mic moment. Hot mic moment. They took it from us. They'll be back at 2. I am going to take Miss Priss here outside. And I think she's like given up on me. She finally has passed out on her little rug. Like she's just the most abused little thing in the world. You want to go potty? Oh, she jumped up. You see that? You want to go potty? I'll take you. I'm going to take her and then we will be back. They've got break, and I'm going to scarf down some food real quick too, because I forgot to eat and my stomach is growling. But they have arguments that they're going to do at 2:00. So we'll listen to them bring the arguments. We'll listen to them do that. But I'm going to take her out and come right back. So I'll see y'all in just a few minutes. I'm sneaking back in. Oh, I have to go mute that. Okay. All right. Hello. Hello, family. Hello, friends. Hello. Welcome back. Welcome back. I tried to let Lucy have like a little bit of extra time outside. It is hot outside. I tried to have her take a little bit of extra time so that she'll be occupied and be happy. Especially because when I finish our stream today, I've got to record. I've got everything ready for the podcast, but I've got to actually record it. I've got like the intro recorded. But I've got to actually record the rest, so I know she's going to be like stuck here. Bored. Y'all want to hear the intro? I'll give you a sneak peek at what this episode is. Let me pull it up. Give you a little sneak peek. I don't know how loud this is on here. If you have, I don't know how, I have to keep this loud so I can hear every little detail on there. So I don't know if this is going to be really loud. So I'm going to give you a sneak peek, but you might want to turn your volume down because I keep this loud and I don't know how to turn down my recorder thing for y'all. But anyway, this is the little sneak peek. This is like the first little intro about what it's like the previously and then what the new episode is about. It's like a minute and a half, I think. Previously on Conspiracy in Canton.
Boston police officer John O'Keefe was found face up in the snow on Saturday morning
outside a home currently occupied by people known to O'Keefe.
The body of a fellow Boston police officer is dead in your yard, and nobody from inside the house even comes outside.
State prosecutors accuse Karen Reed, who was O'Keefe's girlfriend, of backing into him and leaving him to die in the snow.
It's impossible to report on this without acknowledging the bitter debates from both sides.
Prosecutors point to pieces of a broken taillight. Her lawyers argue the police report was altered. Pieces of her taillight weren't found until after her car was taken into custody.
First got to that scene at 6 a.m. and did not find a single piece of taillight. And then 12 hours later, boom, they found taillight everywhere.
I don't think there's any kind of conspiracy or anything like that.
Lawyers for the woman under arrest not only say their client is innocent, but they're alleging a cover-up.
Anytime there's a cover-up, there's always someone involved who has two things. One is powerful connections, and number two, something to hide.
The lead detective is very close with the owners of that property.
The Alberts also have connections to the Attorney General's office, to a firefighter that was on scene, and even to the judge.
They say there were a lot of people at the home that night, and one of them Googled how long to die in the cold hours before Reed would have known O'Keefe was missing.
With every new detail comes a new controversy, and nothing is what it seems on the surface. Even if the theory of how John died is not correct, that part to me right now doesn't even matter. What matters to me is that they are lying. They are lying on court documents. They are lying to the public. And that is the part that should scare the shit out of everybody in Massachusetts. That's preventing justice.
Free Cara Rintala. Free Cara Rintala. Free Cara Rintala. Free Cara Rintala.
If you missed episode 1 of Conspiracy in Canton, I recommend stopping here and going back to listen to that one first. This is a complicated case, and there are a lot of people involved, a lot of information, and a lot of discrepancies in information. On episode 1, I introduced the controversial case of Karen Reed and went over some of the main points that originally grabbed my attention. For example, the arguments over the broken taillight, the Google searches and deleted calls, and how the injuries that John sustained could be due to a 3-point turn, but the only significant damage to the car was a broken taillight. I started to question everything, and the first thing I do when I'm trying to get answers is go to the public documents. I always say that the devil is in the details, and I have a process that I use when I'm starting out on a new case. I like to take the court documents, everything with official timestamps, data, all the information that I can find, and I compile it into one spreadsheet in a timeline. People can misremember things or get details mixed up or just flat out lie, but data doesn't lie.
My favorite
I
thing.
compile everything into one timeline, and I use this as my base. These are the things that we know without a doubt happened at these times. Or did they? So that's your little sneak peek. So that's fun. I have like right now like the first like 5 or 6 minutes I think recorded. So not a ton yet, but I've got everything together. So I just have to, I've got all the research stuff together. I just have to actually put it all record it all, I guess. Oh, there's a lot to it. There's so much. But it's good. It's a good thing that there's so much because it keeps me busy. Right? Busy is a good thing. All right, my cameras are all messed up. Let's see. Remove. Add. Let's see. You got beach cam back. I know y'all like beach cam. So I went and did that as soon as we took a little break. Let's see. Try to get these situated. There we go. Perfect, except for that we don't have any video feed yet. Yeah, I know. I love beach cam too. I try to keep it up. But then like this weekend, you know, when I was working and stuff, I did a lot of research this weekend and I didn't want to sit at my desk the whole time. So I was using my laptop. So I set, I have a chair over there right by, like I had a floor to ceiling window right there. And I sat in front of that so I could, even if I can't be out on the beach, I could at least see it while I was doing research. But I can do that with my laptop. So then I always end up, like I get it set up for beach cam and then I mess it all up because then I need to use my laptop. I just need to get I kept saying I was going to get the camera and just do the camera so I didn't have to use my laptop right there in the window. But I just haven't had a chance to do it yet. So I will. Beach cam's great though because it's so relaxing. And what is it now, September? So see how the chairs and stuff are out there right now and like the little tiki hut. The chairs at the end of next month, the chairs will be taken up. They take them up after October 31st, and they don't bring them back until the end of February, early March. So the beach will be like empty out there, and I love it. I love it. Let's see. Has the boyfriend testified yet? No, and we're all waiting. We're all like, we're wanting all the gossip. We're waiting on him to come spill the beans. I want to know what he has to say. Very nosy. Very nosy. Which works out good in this business when you're nosy. It's a good thing. Hey, you could be my neighbor. There's like, now that it's the end of the season, there's like 3 condos for sale in my building right now. You can come be my neighbor. Won't you be my neighbor? And all the drilling is done now. For now. They've informed us that they're redoing the floors. At least it's the last big project. So there'll be like 4 days where I won't be able to be here because I can't walk on the floor. So I got to find out when they're doing mine. And it all kind of depends on weather too. So I'll have to play that by ear and see what happens. But other than that, at least there's not drilling every day now. Let's see. Yay, I'm glad y'all like it. Thank you. Thank you. I'm glad y'all like it. It has been crazy looking at everything, putting everything together. It took so much time. Like the episode that is going to be released tomorrow. I'm going to record it tonight, release it tomorrow. It is all about the first, because I have to break it down because there's so much information. So it's about the first few months of the investigation and like how the stories changed, how the documents changed, how there's a lot, and things that I can't believe that it's even made it to court record and they're okay with it. It's just mind-blowing. But I think it's going to give a good, this case is so complicated that it's hard to like really like jump into it full force, because you hear so much about so many different things about it. So last week I tried to do like just, basic introduction in the background, and then, kind of a little tidbit about why it's so controversial, some of the questions that, come up, and just like a little hint of some of the stuff that's, going to come. And then now we're going to basically walk through the investigation. So it'll be today, or tomorrow's episode will be the first few months of the court documents and stuff like that, and then we're gonna keep it moving. And for all the stuff, I mean, there's gonna be like, stuff that I go into about like the connections between them, which I've found some. Turtle Boy has found a lot of the connections. And then I have some locals who have been messaging me. It's crazy. It is nuts. Let me see. And I am so tired from working on this, but I'm so excited about it. Do I know Manny Matney personally at all? You guys seem like you would be best friends. No, we've never met in person, but we've talked, like through like email and social media and stuff like that. It's funny because she's fantastic, and she's very supportive which I appreciate. But like, I remember, I listened to her podcast, like I listened to Murdoch Murders, her and Liz. And before I ever even got, before I ever even got on Twitter, and a friend of mine who lives in Charleston, she and I, both listened, like we both like listened to like everything Murdoch. My friend she works in the legal field. So she's worked with some of the Murdochs before. So she and I would like literally just be texting all day long, watching the trial and stuff. And I remember when I put out the chart and Mandy liked it. And I remember I screenshot that. I was like, oh my God, Mandy Matney, liked my, like she saw this. Like, how weird is that? Because I thought I was going to put on Twitter because that one person asked me to, and like maybe 10 people would see it. And I thought it was like, it's just the strangest thing. Like, But then she ended up like, it's crazy how things work out. Because then she ended up being such a big support. She's just so, she's very honest with the crap that people put her through and how it affects her. And I love that about her because it helps hearing that, that the people who are, jerks are just going to be jerks. And that's just, something that happens to everybody, and not to take it personally. But she's been a huge support. I love her and Liz. Let's see. Oh, Ricky Watson, I miss riding horses. Oh, I used to love riding horses. I grew up riding. I loved it. I want to ride horses on the beach. That's one thing I've never done. Liz Farrell too, though. She's where the true sarcasm and pettiness is. That Brandi would click with. Yeah, I love her sarcasm. Like, I love her sarcasm. And she's a smart cookie. Do we not like her? Do we not like who? Who don't we like? We like everybody. Well, we don't like Thami or Alex Murdoch. Alec. Let's see. I'm a true silent subscriber, and I listened to the Corey Fleming sentencing last week. I said in the chat that I needed a Brandi Churchwell chart to keep all the who's who in check. I know, right? They're complicated. They are complicated. They just need to get somewhere. Stop sealing stuff. Okay, good. Yeah. We like everybody except for Thami and Alec Murdoch. And trolls. We don't like trolls. But everybody else we loved. Well, I don't say we love everybody else. We love their potential. Some people we just gotta, yeah, or her. Okay, we don't love everybody. There are like Letitia. We don't love her. We don't love Lori Vallow. We don't love John Thomas. No, not Letitia. But we try. We try. We try. I always say that people need love the most when they don't deserve it. So I try to, even if I don't feel it in my heart, I try to fake it till I make it and make myself love and support other people who are total jerkwads until I can feel it in my heart. except for people like Letitia and all of them. What I love is that they can't hurt anybody again. Dominique, I love Dominique. She gave me jokes for days, weeks, months. Don't love her as a person, though. She's a crappy person. Hopefully she will change. And she hasn't yet, because you've seen her social media lately, she hasn't changed yet. But hopefully there's hope. There's hope for everybody. Almost. Maybe not Tommy. Tommy's been doing this a hot minute. He ain't learned his lesson by now. He ain't going to. That's okay. Yeah, we don't love those who commit horrible crimes. But other people we do. Holly Mack says, I have great hopes for Tommy. Okay. All right. Yeah. Sure. Yeah. Holly's been drinking. No, I support that. I support your optimism. I support that optimism. When my voice goes up like that, that's when 83% bless your heart, Holly. Bless your heart, Holly. Holly has hope. Holly has hope. Yeah, when the high-pitched voice goes up, that means that I don't agree, but I'm trying to be nice. That's so funny. My people know me. Oh, yes. Christina's mom. I love Christina. We love Christina. Where's your hope for him? Oh, wait, I missed it. Did I miss it? Hold on. Everything's running together. I don't see it. Alex is a thief, but not a murderer. We can agree to disagree on that one. Oh, we got audio. We like people who don't commit murder. Yes. Where am I missing? I'm missing that.
All right, Your Honor. I want to try and jump in.
Just give me a moment.
He said, just give me a moment. I'm not quite ready for y'all yet. Oh, here we go. I said I hoped he fell over. Bump that noggin. He'll blame the lead detective. I don't think they are, Casey Smith. I think they're about to have a whole another 30 minutes of fighting.
All right, good afternoon.
Good afternoon. Welcome back. Thank you.
Do you want to start?
Sure, yeah, sorry. Okay, I think that since Nancy Kaufman is about to take a stand, I think that maybe it makes sense to first begin with.
Nancy
We had
Kaufman.
an objection to one of Nancy Kaufman's statements we know from prior testimony. So we filed a motion to exclude defendant's irrelevant comment. And the specific irrelevant comment that we're talking about
Clark.
is that Mr. Rintala was embarrassed to go to the beach with Ann because of Ann's weight. Again, we know this because Nancy Kaufman has testified previously. And in a nutshell, we submit that this is inadmissible under 401, 403, and 404B. It's irrelevant. It is more prejudicial than probative, and it's a 404B prior bad act that's just prejudicial. And on 401, I know that the court just today noted that instructed the jury that evidence that's relevant to determining whether the defendant has a hostile relationship with the decedent is relevant, but calling your partner fat, I submit, is miles away from that sort of evidence of a hostile relationship. And in fact, the real danger here is in our current environment. Maybe even there's a difference 13 years later than there was in 2010. I don't know. But in any event, in the current environment with this current jury, we're obviously worried about the notion of calling somebody fat might be viewed as, I don't know what best way to put it, but very unpopular and very prejudicial sort of thing to say. But it's very prejudicial, and that substantial prejudicial effect outweighs any relevance. Because again, the only thing you might plausibly argue that this is relevant to is the evidence of a hostile relationship. But hostile relationship to kill somebody is simply an unreasonable stretch from the statement, you think she's fat. And by the way, we dispute that she even said that. But that's the nutshell of the argument.
Okay. Commonwealth?
Just to clarify what the evidence would be expected to be, this is Annamarie's aunt. It's weeks before the murder, at the end of February, beginning of March. Ann and Cara travel down to Florida to go on a cruise together. They visit Ann's aunt, Nancy Kaufman, who lives in Florida at that time. They stay with her for a few days, both before and after the cruise. And Nancy's able to make observations of how they behave with one another, how they're interacting or lack of interaction between them, and some comments that are made. What she would be expected to testify is at some point during that trip, her and Ann and the defendant, and the fact that Ann is present for this conversation is important, I believe, for the evidence, that Nancy makes a reference, why don't I take the baby, why don't I take Brianna, and you guys can go to the beach together. And in response to that, the defendant said, with a gesture, why would something like this take something like that to the beach? It was within earshot of Ann. And had a reaction visibly, according to Aunt Nancy, receiving the information. She began crying and left the room. The importance of this testimony is this time frame, in addition to the nature of the relationship. The defendant has argued and presented in past trials happy cruise photos, that they were reconciled, that everything was great among the relationship at that time, that the past issues about which we've heard testimony this morning in 2008 and 2009 were over, the divorce was done, and they're in a great relationship at this point in time. This proves otherwise, that within the weeks leading up to the murder, they still were arguing and still hostile to one another. And again, the reaction of Ann, it being said in the presence of Ann, and hearing it, and her being upset about it, is important for the jury to be able to hear. And there's other information that Nancy would testify to as well, but that limited conversation, I would suggest, is admissible.
Did you want to add something?
Just very briefly, I think it's important to keep in mind the evidence that the Commonwealth submitted to this point is custody over a child in restraining orders, fear of bodily harm, fear of being excluded from your own house. Those are all, I submit, exponentially different than what we now have In other words, I think they're arguing, that's all, to the extent the defense is arguing that's in the past, and there's been a long period of reconciliation where they move back in and are in counseling. We see, it's the problems are all still there. And my point is, what are they talking about? That's a completely different, those are apples and oranges. We're now talking, you're saying that a cruel comment about body image is the equivalent or somehow evidence of the old problems. And I submit that that's a false dichotomy. Those are apples and oranges, and it's more prejudicial than probative.
Okay. Well, given the context and without considering what the defense may offer in rebuttal, I do find, again, given the context and also given the time frame here, that the evidence is probative on the issue of the relationship between the defendant and the alleged victim, specifically whether it was hostile or still hostile, and that probative value outweighs any prejudicial effect. So I am denying the motion.
Thank you. Note our objection, Your Honor. The next, I think the only other topic of business before the jury comes in is the redactions to the two statements by Mr. Rintala. And so I just want to preface this. I know Your Honor is aware that we've agreed to some things. The most important category here, from our perspective, is discussion of the paint in light of the SJC's decision and in light of this court's rulings in this trial. To the extent that the detective is articulating a view that the paint is fresh and the paint has been poured, that is clearly, I think, now inadmissible. And I recognize the Commonwealth has agreed to some of this and I think we've reported to the court, our sections E and F, which deal with that. But that's not all of it. And so I guess the place to start, the easiest place to start, is our section C. So 1C, transcript for the first day, March 29th, transcript at page 88, lines 1 to 8. And what we're talking, let me just get there, Your Honor. Yeah. Okay, so Detective Whitney, I believe it's Detective Whitney, says, it was pink, wasn't it, Ms. Rintala? Yeah, they do that on purpose because when you paint it on, you see where you hit. When it dries, the pink goes away. Her dad got her that. I know that there's 2 spots in the kitchen that's been bugging her. She's been after me to get it done for Fiona's birthday, but it's not till May. You know, birthday, not till end of May. So from our point of view, this is yet again an effort to develop this idea, which has been disproven by the defense on appeal of the last trial, that this paint, you can see that it's pink, that it's fresh because it's pink. That's just wrong. That's the way it was designed. But only if you roll it on at a 1/8 millimeter thickness, or 1/8 of an inch thickness, like you're super thin, with a roller onto a wall. The pink will go away. But the way it actually came in here, forensically, spilled, we don't know how, just dumped into big pools of thickness, varying thickness, on slabs of concrete. It never is going to become white. And so that's the biggest problem. So this entire idea of this entire topic of talking about where it's pink and that the point of it being pink is so that you can tell where it dries. When the pink goes away, when it dries, the pink goes away, so you can see where you already painted pink, is grossly misleading. And I mean, on top of that, Mr. Rintala is not actually being responsive to the questions, so it's confusing. But the point is, this is dangerously misleading to the jury, and it's also just confusing. And so I think that's the first place to start. We would ask that be excluded. I can keep going, or the Commonwealth can respond. I'm not sure what you want. Because each topic is a little bit different, and so I feel like it might be fairer and more efficient if the Commonwealth responds to each one, but I leave it to the court.
Okay. Commonwealth?
Yeah, actually, my response to most of these redactions is cumulative. In other words, that it's all paint evidence. And so I would withhold argument until, Attorney would reference all of them.
That's fine, that's fine. Okay, so, then I guess the other, there's another, big category, which is questions are put to Mr. Rintala, and the answer is, I don't know. And I submit that unless there's evidence that Mr. Rintala should have known this thing, whatever you're asking, it's irrelevant. And so it just doesn't meet the very first rule of evidence, Rule 401. It's just, I don't know, that's irrelevant. It's also confusing to the jury, and so should be inadmissible. So that, I think, covers the first section, 86, 7 to 19. Does she know how the paint container got open and whether the paint was on Ann's back? The defendant repeatedly states she doesn't know. It's just not relevant. It just doesn't help answer any question. Also, the next section, B, transcript 87, lines 14 to 25. The trooper asks the defendant, why would Ann have the paint out? Again, the defendant says, Mr. Rintala says she doesn't know. Right, and there's also a false premise buried in the question. There's no evidence that the paint was out. And it's not clear what she means by out, if she means the trooper, if she means was the paint can, why was it taken off of some other place and put on the floor, or was the lid taken off? It's not clear what she means by was the paint. Why would Ann get the paint out? So it creates a lot of confusion. In any event, again, Mr. Rintala says simply, I don't know. And then our next objectionable section, transcript page 88, lines 1 to 8. Sorry, I've covered that. That's the pink roll. It rolls on pink. I talked about that. The next section is transcript 108, line 12 through 109, line 20. The trooper asks Mr. Rintala where the paint came from. And again, this is another instance of, I think, just clear confusion. I think they're talking past one another, the best I can tell. I think that the trooper's question is really, how did the paint get spilled, poured, dumped onto this crime scene? But Mr. Rintala clearly understands the question as sort of, how did the paint come to be in the basement? And she starts talking about how her father or Ann's father, I can't remember, got it for them, and then sort of why they have paint and who's in charge of painting in the house. It's all a bunch of non sequiturs that's completely irrelevant to the case. And so it's, again, completely confusing. Oh, okay. Also, in that same section, the detective asks, so she's saying, where did the paint come from? This is the detective's question. This is her specific question, the most problematic part. It looked like the paint was, clearly the paint was still wet. So where did the paint come from? So, sorry, the officer's question is pretty clear. She's talking about this paint and that's at the crime scene and characterizing it as wet. And again, the idea is, what she's getting at is an idea of freshness. And Mr. Rintala is misunderstanding the question, saying all the things that I said before. So her answer is not responsive, and it's clearly an indication of confusion. She doesn't understand the question. So those are the sections that we are asking to be redacted. We do have one more on the next day, but the Commonwealth has moved to redact that section, so I think we're going to be in agreement on that one. But I'll talk about that one when we talk about the Commonwealth's redactions.
So in regards to the four that are in dispute, which is A, B, C, and D in the defendant's motion, all of these touch upon the paint issue. The Commonwealth has agreed to some of the redactions at the back end of the interview in E and F when there's targeted questions regarding references to words like pouring. Did you pour it? It looks poured. The Commonwealth is agreeing that based on those questions and the responses, it's more prejudicial and probative, it should stay out. And in terms also of the use of the word fresh. Nowhere in A through D are the words poured or fresh used in the conversation about the paint. And the Commonwealth understands those words are off the table in terms of the evidence that will be admitted. But wetness is not off the table, and
Witness is not off the table.
How the paint may have gotten to that location. In the big picture, these four passages, A, B, C, and D, all are relevant because the Commonwealth alleges in this case, as Your Honor notes, that the paint is an instrumentality of the cover-up of this crime. So the defendant's knowledge of this paint, her claim about the status of the paint when she got to the bottom of the stairs, her access to this paint, are all relevant and important issues for the jury to be able to consider. To the fact that she knows that where it used to be stored, it used to be over here, it used to be over here. This is ceiling paint. We have been planning to paint ceiling paint on various parts of the house. This is all proving that she knows what this paint is. She's had access to this paint. She touched this paint can. She knows where it is, and is relevant to the jury's consideration of why it may have ended up in that place in the basement on this particular date. To the extent words are used like wet, and the passage that was just picked up by Attorney Wood about Lieutenant Whitney saying it's clearly wet. These are not facts that are not already in evidence. We had 4 first responders who testified the paint was wet. So that fact is in evidence already on this trial. The defendant, other portions that they're not moving to exclude, indicated that she allegedly slipped on the paint when she went downstairs, which could be seen as admission that the paint was wet if she's saying she slipped on that paint when she went downstairs. To the extent that the reference of pink is brought up in that one passage, and I want to clarify that, the Commonwealth is not intending to argue that because the paint looked pink, it therefore was fresh. That is not part of the Commonwealth's case. It's not what we're planning to argue. We're focusing on the observations of the first responders in terms of it being wet with no coagulation, it being shiny, the fact that it transferred on the shoes. So to the extent the defendant has some knowledge about the pink and the fact that it changes over time, again, it shows her knowledge and access to this particular paint can, which is highly relevant to the Commonwealth's theory of why this was used. To the extent there are statements made by Lieutenant Whitney that are or are not adopted by the defendant, there could be a limiting instruction if necessary to say statements made by interviewers that are not adopted by the witness are not evidence. A statement or assertion in a statement. But it's the context of that and her responses about the paint issue, I would suggest, Judge, are admissible in the ones that are left in A through D.
Just very briefly, the thing that's most problematic to us in all of that is the pinkness of the paint. The fact that the paint is pink. And because I think it's simply, well, the great danger, at the very least, if not unavoidable danger, is that the jury will infer that from this statement about it going on pink and then drying white, that, oh, okay, there's a clue. And they'll look at the crime scene and see pink paint. And then somebody will infer, aha, we can put it all together. This is clearly fresh. The Commonwealth's so-called expert in trial 3 did his own so-called experiments. And those experiments established that when paint is poured onto or spilled onto a concrete floor at a thickness beyond what it's supposed to be used, the pinkness never goes away. And so what I'm worried about is that little passage giving the jury a false train of thought to conclude erroneously that the paint in this situation was freshly poured because it was pink. That is demonstrably false. That's the big problem with that.
Okay, so let me just be clear about paint and the role it plays here. Based on the SJC's ruling, I precluded the Commonwealth from asking or eliciting lay opinions from its witnesses about when the paint was poured. And out of an abundance of caution, I forbid witnesses to use terms like fresh, even though I think in all likelihood they are simply shorthand for the observations that the witnesses did describe. In other words, that the paint was wet, that it was shiny, that there was no film that had developed on the top. And I will permit the Commonwealth to argue that that evidence is consistent with its theory that the defendant poured the paint at some point shortly after she arrived back home and before the first responders arrived, because it is consistent. But it's also consistent with a defense theory that the paint was poured at some point earlier. I think it's within the knowledge of the lay juror that paint starts off as liquid, and when it leaves the can, when it's exposed to air, it begins to dry. There's no evidence here, nothing, or no evidence from which a jury could infer an exact time or even a time frame. But again, it's consistent with that, and they're permitted to argue that. I'm a little surprised, honestly, that you want this portion out, because what I've heard so far from witnesses is that the paint, if you look at it as a whole, the paint was white, maybe it was pink, it was pink here and there, but that it was shiny, that it was wet, and that there was no film that was developing what you would call, I think, clues for the jury, for them to infer that the paint was wet, and that it had not, there was no indication at that point that, based on those observations, that the paint had started drying at all. Whereas based on what the defendant explains, that actually constitutes evidence that the paint had started drying. At what rate, no one can say, but at least it's evidence that the paint was in the process of drying, which you don't otherwise have. So, and I'm not saying that I'm ruling based on that. I'm just, I just want everyone to understand what the parameters are here. And again, it's not that the Commonwealth can't argue that the paint was poured, that it was fresh, that there isn't evidence from which the jury could find that that theory is accurate, that evidence at least is consistent with that theory. Again, it doesn't rule out other theories in the way that perhaps the expert testimony, if believed, did. But based on those parameters and based on just these statements sort of put in context, I agree with the Commonwealth that they are relevant, and there's nothing in my prior ruling that prohibits them, and I don't agree that they're more prejudicial than probative or out of line with the SJC's decision. So I am denying the defendant's motion as to those sections, or at least to the sections that have not already been agreed to.
No, no objection. I just need to. I'm sorry. You know you made your ruling, and I respect your ruling. I'm not asking you to reconsider your ruling. I'm simply pointing out that what we're trying to do is get the evidence, ensure that the evidence is consistent with the knowledge, is reliable. And this statement about pinkness, it's not so much the time frame. It's contrary to the scientific. To the extent we have experimentation, it has taught us some things about this paint in this context. And it has taught us that the pinkness is essentially useless for determining freshness. And that's contrary to the way it was designed when it's rolled on. And so it's not so much that we're arguing it's new or it's not new, or it's fresh or it's not fresh. We're arguing that you can't know based on the pinkness of it. And the statement is a reflection of the manufacturer's recommendation, but it's disconnected from the reality of the situation. And so it's going to lead to misunderstanding. It could lead to a conclusion that is contrary to what we know about this. That's the core of my objection.
All right. Well, that expert testimony isn't in play here for good reason.
Right.
It was deemed unreliable, as was the expert by the SJC.
Right.
We have testimony that the paint, in addition to being shiny and wet and free of any sort of film or coating, was at spots pink. And I think that that's a little confused. That's confusing for the jury just to sort of leave it out there, because I think they would assume from that somehow that's a mixture of blood and pain, which it's not. That's not. I don't believe that's what the testimony was about. This is simply the defendant giving a statement as to her understanding of the qualities of this paint in a way that, if anything, is helpful. But I don't think it's misleading. At some point, this paint maybe starts off pink and then eventually turns to white. And obviously, there's a difference between spreading a thin layer of paint onto a dry surface and paint that's been poured or spilled, an entire container's worth. And even as to what would happen if you just painted it on a wall, how long, in other words, it would take for the paint to go from pink to white. There's no evidence of that. It could be, it simply is evidence that the fact that the paint is shiny and wet, etc., is consistent with fresh paint, but it's also not inconsistent with paint that was poured or spilled an hour, 2 hours, or 3 hours, or however long before that. And so it explains a detail about the case that I think is otherwise not explained. Again, I don't think it explains it in a way that's harmful to the defendant, and perhaps is even helpful. If the Commonwealth decides on its own to redact it, I would understand that, but I'm not going to exclude it based on the defendant's motion.
Thank you, no objection.
Okay. So that takes care of the redactions.
No, Judge, the Commonwealth actually sent 3 redactions last night and 1 this morning that they're requesting after 13 years.
And I'm happy to start to address those, Your Honor.
Yes.
But they're the Commonwealth's redactions.
Okay.
So speaking first, I think we're talking right now about the interview of March 29th, the defendant's first interview. The Commonwealth had filed a notice of redactions, intended redactions to the defendant's interview, 3 different sections. And just in terms of the lay of the land, the Commonwealth has the ability to admit portions of this interview as the defendant is a party opponent in this case, not required to offer all of her statements into evidence.
And I understand that the real question is whether the doctrine of completeness would compel the addition of whatever portion that you're now seeking to leave out of the statement.
Yes, Your Honor, I was just going to address that. The first 2 points that are indicated here are times where the defendant sort of on her own starts making disparaging statements about the family of Annamarie, not necessarily Annamarie herself, but her extended family or her immediate family, regarding connections they may have to people in Springfield with bad things happening and things falling off trucks. It's not responsive in terms of any statements, it's information she gives, and there's no context. In other words, it's not out of the context of anything else she says during the course of this interview. There's 2 portions where she just kind of goes off on a tangent, says that, and then it circles back to a relevant topic. So I would suggest under the doctrine of completeness, there would be no reason for the addition of those paragraphs or those pages and lines. In regards to the 3rd redaction, which is starting on page 104, line 24 through page 108, line 11, this is a similar sort of.
I'm sorry, what?
Yes.
Day
what
1.
Page, because I just have page, according to the motion I have, it says page 1.
It is. I'm
So it's-
sorry, I think you're looking at the motion or the notice Your Honor filed about the March 30th interview.
Oh, sorry.
And the one I'm referring to is the March 29th interview, if you have that.
Right, and this is transcript page 10, line 18 through 11.
Yes. And then the second, which is page 32, line 7 through 23.
Okay.
Those both are sections that I just indicated.
Yes,
in
okay,
terms of-
okay.
Yes. And then turning the page, Your Honor, on that same document, there's a 3rd indication of a redaction the Commonwealth intends to make, which is starting at page 104, line 24 through line 108, line 11. During this portion of the interview, the defendant is asked about the coldness of the defendant's body, her training in regards to what coldness means. There's a reference to rigor mortis in her body in terms of what she understands that to mean and in terms of the coldness. The conversation is actually very similar almost in terms of the content to the redactions we just agreed to be made at the defendant's request, which is E and F in the defendant's motion. In both of those sections, which the defendant asked to be redacted and the Commonwealth agreed, is the same sort of conversation where the investigator is pressing the defendant, what does coldness mean in your training, what's your understanding of rigor mortis? And so it's in line with what's already being redacted out. And again, I understand that her feelings and her beliefs and her opinions about rigor mortis are not relevant here. And so we're seeking to redact the same sort of conversation that's already been redacted at the defendant's request, where she's being asked about these topics. It's not out of context, there's no other places. We're redacting out everything where she's talking about based on her training, what coldness means and her understanding of rigor mortis. So it's consistent with the redactions already made at the defendant's request.
On that last point, apologize, just moving quickly, we agree with the Commonwealth on that last redaction. So the 104, line 20, I have to make sure I'm understanding, line 24. Well,
So
page 104, line
Paragraph
20.
3.
Yes,
Paragraph 3.
yes, paragraph 3. That's right. We agree with that one.
Okay, so that's
I
just,
didn't want to be early, other two, but. we
sure,
agree.
but why don't we also, so let's address the March 30th.
Yes, Your Honor. The Commonwealth had filed a separate notice of an intended redaction in regards to that interview, specifically the very beginning of the interview, starting at the top of the interview through page 12, line 18. I don't know if Your Honor had an opportunity to review this interview, but
I did, but I'm sorry, this is the one maybe that's confusing me. It says transcript page 1 on my motion. So is it,
the very start of the interview.
okay, so all I have is a cover sheet and the numbering starts with page 2.
My apologies, Your Honor. It is page 2, line 2.
Oh,
Which
okay.
is technically where the substance of the interview begins. I apologize. Page 1 is a cover sheet. Essentially, that we would start the interview as opposed to at the beginning of the recording, but begin it starting on page 12, line 19. If Your
Hello,
Honor had
Julie.
an opportunity to observe the interview as you said you did, you might remember that the interview recording sort of starts in the middle of a conversation that's already occurring, sort of some rapport building that's happening between the detective lieutenant and the victim, where they're just sort of talking generally about matters, not about this case, not about the relationship with Anne, not about any of that, during which the defendant makes many sort of statements about how she's feeling and what she thinks of the investigators. And the investigator also makes statements in regards to other officers. So I don't think there's any reason, this is not for completeness, that this would be necessary to be admitted. It's general conversation where the defendant makes several statements unsolicited that have nothing to do with the facts of the case or again, her relationship to Anne or anything relevant. So we would be seeking to begin the interview recording at page 12, line 19. And that, if Your Honor allow that redaction, it would include the specific redaction requested by the defendant in regards to this March 30th interview, where they are seeking just the redaction of page 3, lines 6 through 16. But that would be covered in this redaction.
All of this because it has to do with the timeline of when the paint was poured. Yeah, they're saying it's pink when it's wet and then it dries white, but only if it's done in the, whatever he said, 1/8 of a, whatever the heck he said. They just need to bring in an expert in paint. And then we'll all just watch it dry and time it. can discuss amongst ourselves.
So is it really more to line 17? Line 18 is a sort of mid-sentence.
Yes, I really, starting where the interviewer in that line, halfway through line 18 says, "How is Brianna doing?" To give some context to their,
Okay.
conversation moving
Sure.
forward.
That's a good
So it
point,
doesn't
Judy D.
start in the middle of a conversation about that day. So we would seek to begin with the statement on line 18, "How is Brianna doing?"
Okay. All right.
So we have three pieces of these subsets of these redactions that we would want to keep in. So their first requested redaction, the first two are on March 29th. And their first requested redaction, we would want to keep in page 10, starting at line 11. Anne has very expensive taste. Going through page 11, line 8, all the way through the end of the line. His federal job was taken away because he was, And we submit that this statement is relevant to our Bowden defense. In a nutshell, it is Ms. Rintala's observation about Anne Rintala's irresponsible spending habits and her history of getting material goods in suspicious ways. And the basic idea is she owed money to lots of different people. Any one of those issues should have been investigated by the police. And so that's consistent with our Bowden defense, that the police failed to investigate. The next section would be in the Commonwealth's second requested redaction. So I would move to page 32, line 7, detective. Did some come from money? I'm not sure what's, I think it's a typo, but did some come from money? And then all the way down to line 23, Ms. Rintala, and the gist of it, again, this is consistent with the last section that we want to keep in. It again raises this question of Annamarie Rintala's family and the fact that she had a history of spending money that she didn't have, and it's relevant to a Bowden defense. And then the last section that we would, within their requested redactions, is now we're on to March 30th, their redacted section. And what I'm focusing on is page 7 of that March 30th transcript. Line 23, interviewer. Let's go back to what you were saying. And then all the way down to page 8, line 19. I want it done. I'm not hiding anything. So that section, it's crucial to the defense because it described the state trooper is admitting that the Granby Police Department have no experience with homicide investigations. And in particular, the investigator is apologizing for the fact that Barbara Fenn had Ms. Rintala walking naked down the hallway in front of a bunch of other local police officers, and basically saying that never would have happened if I'd been in charge. So that's important to our defense about the lack of experience the Granby Police Department has with specifically with homicide investigations. And then the final section, one more section, page 10, line 4. Mr. Rintala, do you have any tissue? The interviewer, I'm sorry, down to line 17. I know they have to do their thing, but you know what? Why can't I go see my wife? We think that's all very important because it demonstrates Mr. Rintala's innocent state of mind, that she is experiencing the trauma of having lost her wife and is basically begging to see her wife. And we submit that that is consciousness of innocence and crucial, effectively a denial that is emotionally important for the jury to see and understand. So we would ask that that section be included as well. Thank you.
Okay, well, so what I'm hearing is that this evidence is relevant primarily for your Bowden defense.
Yes.
I'm not so sure about the consciousness of innocence.
That's a different category. That's right.
But either way, I'm not ruling that you can't pursue those using this evidence. But right now, the question is whether the Commonwealth has to keep all of this in. In other words, that they're limited in what they can redact based on the doctrine of completeness. And so I haven't heard why any of the proposed redactions are necessary to qualify or explain some other portion of the statement that's being admitted. So I'm going to allow the Commonwealth to redact the statement in the way that they have indicated. But I have not ruled on whether you can ask Trooper Whitney questions about what she said that would go to her state of mind in terms of the investigation. I would need to see something more about the consciousness of innocence argument that you've made. But again, it doesn't mean that you, even under the doctrine of completeness, it's really, I think, envisioned that the opposing party produces that on their own and then argues that it should be combined. So for now, I'm going to allow the Commonwealth again to make the redactions that it has indicated it wishes to make, along with those that have been agreed to by the parties.
Understood, Your Honor.
And I will note your objection.
Thank you.
Okay, so it is 2:52. I still, I suppose, have to rule on the voluntariness of the statement. I have had a chance to look at it. I'll hear arguments on that, but perhaps we can, I think right now that the more pressing point was to decide what the videotape, if it's admitted, should look like in terms of redactions. And so that the Commonwealth can have someone start that process in order that it's ready for tomorrow. I think the plan is, and that's really up to you, but I think that's the plan. So perhaps we can take whether the statement itself is voluntary and what kind of instructions you'd like me to give, either at the very end of today or very beginning of tomorrow, or at some point prior to.
I would prefer to do that tomorrow morning because Your Honor has indicated that you prefer things in writing to the extent you get something in writing. And I think it might be useful to everybody if we put something short in writing on voluntariness for you tonight. I think we will get it to you by close of business today, but at least it'll be short and you'll have something.
Okay, I don't think there's any, I don't think you're going to cite something that I'm not already familiar with.
Right, I agree. Thank you, Your Honor.
So can we bring the jury back in? Oh, I'm sorry, before we do that.
I was about to say, bring the jury. He called me.
I think I need to instruct this jury on the references to prior proceedings and at times prior trials. And I understand that unless you're about to tell me you've reached some agreement, my understanding is that there is no agreement as to how I should phrase that. So I came up with my own wording, which is as follows. At various times during this trial, you have heard and will likely continue to hear references to prior testimony or proceedings. You may consider the substance of any prior testimony that is introduced at this trial, but you may not speculate about, discuss, consider, or otherwise draw any conclusions from the fact that there were prior court proceedings related to this case at which testimony was taken.
That's fine.
It's fine, thank you.
Okay.
Now, before the jury comes in, may I have one moment with our paralegal so we can begin the redactions this afternoon? While
Sure.
we're with the jury?
Judge, perhaps the rest of us could approach time out with just a quick question regarding the scheduling.
Okay, is that okay without Attorney Sewell, or would you?
I can handle that.
This has been white noise. This has been just a day of fussing. That's pretty much it. And now they're finally about to bring the jury. Finally, hopefully, whatever happens. I will say this is a new one for me, to have this many disputes, or this long of a dispute over, which I realize, like, the whole paint thing, you know, that was part of, I mean, that's what got their paint expert wasn't really a paint expert last time, which is the whole reason that, you know, the conviction got overturned. So I know that they want to, like, avoid that at all costs, you know, but it's very strange to have this much, like, behind the scenes debate over how fresh the paint was. It's honestly just making me tired. And, like, I'm already tired anyway. So it's really just, I'm like, fresh paint. Fresh paint. But we're awake. We're alive. We're moving. We're grooving. We're awake. Maybe I need to make some coffee. I think that's what I need, actually. I think I need to make some coffee. I think that's what I need. Yeah, all the talk got me sleepy too. I'm about to make some coffee while they're finishing up their whatever the heck they're doing now. Because I can feel myself, like, drifting off into the abyss. And, well, it's about 2:00, which is about what time that happens, right? And, oh, I said right. She's got me saying right. Right. That's not what I meant to say. Interesting. She's lazy. Lucy is. She's got her little paws like this. She's a cute little thing. She is a mess. But she's a cute little thing. All right, let's see. I need to
re-entering. Seated, court is now back in session.
Members of the jury, apologize for the delay. I'll say that a lot, I think, during the course of this trial, as you lose belief in my ability to estimate time. I do want to give you one instruction before we move on to our next witness, which is as follows. At various times during this trial, you have heard and will likely continue to hear references to prior testimony or proceedings. You may consider the substance of any prior testimony that is introduced at this trial, but you may not speculate about, discuss, consider, or otherwise draw any conclusions from the fact that there were prior court proceedings related to this case at which testimony was taken.
Thank you. Mayor of the Common, we call Nancy Kaufman.
Do you solemnly swear or affirm that the evidence which you shall give to the court and jury in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God or do you so affirm?
I do. Thank you.
Good afternoon.
Good afternoon.
Do you just scoot your chair in and make sure you're close enough to the mic so we all can hear you?
Testing.
You don't have to be right on it. Could you please state your name for the jurors and spell your last name for them?
Nancy Marie Kaufman, Kaufman.
Ms. Kaufman, how old are you?
63,
And where do you currently live?
Tampa, Florida.
How long have you lived in Florida?
29 years.
And do you know a person by the name of Annamarie Rintala?
Yes, I do.
And what relationship was she to you?
My niece.
And how far apart were you and Annamarie in age?
I wanted to 12 years.
Okay,
I believe I was 12 when she was born.
okay. Where, I know you live in Florida now. Where did you grow up?
Springfield, Massachusetts.
All through your life?
Until I was 34. I
Okay.
moved to Florida.
And moved to Florida at that time?
Yes.
Okay. Who's in your family in terms of your immediate family?
My children, I have 2 sons. I have a 35-year-old and a 29-year-old.
Okay. And do they live in Florida or elsewhere?
They live in Florida.
Okay. You indicated that you're Annamarie's aunt, correct?
Yes.
And can you describe the relationship that you had when she was growing up?
Like I previously said, I was 12 years old when she was born, and we had a very, very big home. We lived in the front of the home, and my sister and my brother-in-law lived in the back. And it had taken my sister several years to have a child. Make a long story short, she had Ann, and I became sort of like a second mom. We were just very close, sister's mom, whatever I did, she did, and we basically grew up together. You know, I was a 12-year-old, but a girl with 7 brothers, so I wasn't allowed out very much. So I stayed in, and we became friends, and then we talked, and it was someone I trusted growing up as a teenager, and we just were very close.
Okay. And I failed to ask you exactly how you were related as an aunt. Is your sister Lucy?
My sister's Lucy Ann.
And
Yes.
is Lucy Annamarie's mother?
Yes.
Okay. And at the time that you were growing up and you had this close relationship with Annamarie, did you live in close proximity to one another in Massachusetts?
I did. they had lived in the back of the home and we lived in the front of the home. So I believe I wasn't maybe 20 when I moved out of the house. So I was from 12 to 20. I lived with her. The house here, and we lived in the front of the home and she lived in the back of the home.
Okay.
So we all grew up together.
Once both of you became adults, how would you describe your relationship at that time?
It never actually changed from growing up. When we grew up close. And like I previously said, it was like a sister bond. We spoke daily for many, many years. It never changed through the adulthood. Actually became stronger because I had children. She was my son's godmother. We just tight.
I gotta make
even
coffee.
When I moved, we were in constant contact daily, several times a week, whether it be through text messages or through the phone, or several times a year. Everybody would come visit me, which was beautiful.
Let me stop you there. You
Sorry.
indicated, it's okay. You indicated that you spoke to Annamarie daily over the phone. Either did you call and also text message with her?
Either or vice versa. Either she would call, or if I didn't get to the phone, it would be a text back or a phone call. But one way, and there would be a day, certainly would miss the text or the phone calls and, carry on the next day. But we were always in pretty close contact.
And when she was an adult, did you have the opportunity to also see her in person on visits?
Yes.
Did you come to Massachusetts or did she come to Florida or both?
Both.
Okay. How often would you estimate in her adult life you would see her in person?
When I moved to Florida, how often did I see her?
Yes.
When I first moved to Florida, she came in, she had stayed several weeks with me. She was going to go to nursing school at the time. We're talking many years ago. And then she came down, stood another several weeks with me, got a scuba diving license, did several other things. And I don't recall how it ended up, where she ended up at AMR or was with AMR. I don't know. So through the years, either I would come visit my sister. There was a time I came and I stayed with Cara and Ian in Brianna with my ex-husband and my two sons. But they came several times a year. My niece would come to Florida to visit me, or I would come to visit either my sister or any other part of my family. So I was always, when I first moved once a year, I would come back. So I was always, or she would come see me. So there was never more than a year where I didn't see her physically.
Okay.
With me.
At some point in Anne-Marie's adult life, did you come to know that she was in a relationship with the defendant, Cara Rintala?
Yes.
And did you have an occasion to meet Cara whenever she was in a relationship with Annamarie?
Yes.
Would that happen in Massachusetts whenever you would come up to visit?
Yes.
And would they also come to visit you in Florida?
Yes.
Do you know approximately how many times Annamarie and Cara came to visit you in Florida together?
I'm going to say, I don't want to say an exact amount because I don't want to say something that's not so, but I can recall at least 2 times. One time I had gone to Orlando. They had come down with Bree, and I went to Orlando and met them. And then there was a storm, so I decided to stay on. And I stood on for the storm, and then I came home. And then on my 50th birthday, they came back to visit me.
Okay.
So I want to say 2 times in the course of those years.
And did you come to know when they had the opportunity to adopt Brianna?
Yes.
Okay. And did you interact and get to see Brianna on these occasions whenever you were together?
Oh, they always had Bree with her.
Okay.
When they had Bree together, they would take Bree with them.
Okay. I want to ask you specifically about your 50th birthday and that time frame. You indicated that Annamarie and Cara came to visit you at that time.
Yes.
And when would that have been? When was your 50th birthday?
February 27th.
Of what year?
That was 2010.
Okay. Do you know, did they visit you on that actual date of your birthday or around that time, if you know what dates they came?
It was pretty darn close to it, because they were going on a cruise, and they had visited me before the cruise for a couple of days. Then I believe it was on my birthday. We had gone out to dinner, the whole family, and then we came back home, and then maybe a day or two later, I can't recall. I don't know, don't recall. And then they came back after a little bit of a cruise, and they came back to the house. And that was during the 50th birthday in 2010.
Okay, in late February or early March of 2010?
Absolutely. It was definitely the end of my birthday.
Okay.
So that end of, because it was only 28 days, I believe, that year.
And on this trip, was it Cara, Annamarie, and Brianna all together?
Yes, ma'am.
Okay. Now, I think you indicated that they were intending to go on a cruise out of Florida?
Yes, ma'am.
Okay, so they came to visit you first before the cruise, correct?
Yes.
And then I think you said after the cruise, they came back to visit you for a few days after that?
Yes.
Before they went back home?
Yes.
Okay. And at that time, do you remember who else was living in your household with you?
It was my 2 sons and my husband, my ex-husband.
Okay. And were they also part of spending time with Cara, Annamarie, and Brianna?
Yes.
Okay. I want to focus you first on the initial days when they got to Florida, before they went on the cruise. I assume they were staying with you at your house during this period of time?
Yes.
Okay. Can you describe, were you able to make observations of their interactions with one another during that time frame before they went on the cruise?
Yes.
And what observations did you make, just in terms of generally how they would act around one another?
I didn't put very much together, only because it was the first evening coming in, and I think it was 10:30 in the evening. They came in very late that night. And I sensed friction, but I'm figuring it was along whatever they had to do. And they came to the house. At the time, we only had 3-bedroom home. I had taken my younger son out of his room, and I had given that room to Bree, Cara, and Ann. And I just let them be. I figured they're tired. It was a long day, but it was just, as Ann, she's like, I didn't talk to anybody. I had everyone go to bed, but I'm an old lady, so I just sensed something was not kosher. So I didn't say anything, and I let everyone go to bed until the following morning. And that's what I did, figuring it was just a tough night. Let them sleep. We'll get up. We'll have a nice day. And that's how my very first interaction that evening.
And going to the next days, in other words, in the days before they went into the cruise in your house, without getting into any content of conversations, how did you generally observe them being around or communicating with one another?
One would be in one room and another one would be in another room. It wasn't as though they were together. Bree would be, Brianna, love her. There wasn't very much communication with 2 people that are supposedly going on a cruise and you're with your baby and having a good time. It was tense. Sorry.
What's the basis?
It's this witness's opinion about what she's observing, Judge. She can talk about what she observes, but I don't know that she can talk about her opinion about what she sees, what people do. It's not relevant.
Okay, well, I'll stand if you could just ask a different question.
Sure.
Again, she can testify to what she's observing, and I will allow a certain amount of, shorthand to describe those observations.
Sure. Just focusing on what you observed, what you heard, and and I don't mean content of communications, but in terms of what you saw of one another. I think you indicated that they were spending mostly time away from one another.
They were separated. One was in one room, one would be in the kitchen, the other one would be in that bedroom, or who would go out, and so they weren't together.
Okay.
That's what I observed.
Okay. Now, at some point, did they go to the cruise?
Yes.
And leave your presence, right?
Yes, they
You
did.
didn't get to go on the cruise?
No.
Okay. And they came back after that period of time?
Yes.
And also with Brianna still, correct?
Yes.
Okay. And do you remember making some observations of them, again, generally speaking, how they were around or not around each other when they came back from the cruise?
Yes.
What do you remember?
Friction, anger, tense. If you just want me to use a word, I don't want to say my opinion, so I'm trying to use the word what I saw.
Okay.
Tense, anger.
Okay.
That can sum it up.
Okay. I want to ask you about a couple of specific moments in these days after the cruise. Do you remember at some point you making a suggestion that the 2 of them go to the beach?
Yes, ma'am.
And do you remember having a conversation with Ann and Cara about that topic?
I do.
And can you describe what that conversation was, please?
We were in my kitchen, and my kitchen had my laundry room was attached to it, and my niece and I were standing by the, at the time, telephone, and Cara had came out, and I had offered to watch Brianna because of the tension. I had offered.
Objection, Your Honor, in terms of because of detention.
Overruled.
Aw, bless her heart.
I had offered to watch Brianna so that they could go. I offered them to go to the beach for the day. And at that point, Cara was in the kitchen, came storming into the kitchen. I had asked Cara, would you like to go to the beach? I will watch Brianna while you guys get out for a couple hours. Her instantly looked at me and says, do you think this wants to go to the beach with that? She took her sneakers, put them on, and I had a very big door, and she stormed out the door, and my niece just broke down and started to cry. It was an insult to her weight because she had gained weight.
Sustained.
Move to strike.
Sorry.
Last answer is stricken.
Oh, she's shaking. Bless her heart.
Let me just clarify a couple of things. Was Ann within the room when Cara made that comment?
Yes, ma'am.
And I know we're making an oral record here, but you made some gesturing motion, so I just want the record to reflect. Are you saying that she was gesturing to her own body originally?
Cara had taken her hand and said, with this, want to go to the beach with something like that.
And
So
what
it was this or that.
Was she motioning to something specific when she said that?
To Ann.
Okay, so Ann was standing there.
Yes, ma'am.
And what was Ann's response after the defendant made that statement?
Broken.
In terms
Broken. How did she feel?
Sustained. Just that answer is stricken. Witnesses.
Yeah, another question.
Yes, ma'am.
Not in terms of what you think she was feeling
Oh,
inside.
sorry.
What observations did you make in terms of her outward demeanor?
How can I explain it in a word? I want to say the word, but I don't want to say an objection, and I'm saying something incorrectly. She was beside herself. Is that appropriate or not? I don't know what word to use exactly.
Strike, Your Honor.
Hold on. I will strike the last answer.
Well, okay, focusing on her face, or did she stay in the
Sad.
room?
Sad.
Oh, bless her heart. I feel so bad for her. She's.
I think that's basically shorthand for a sad expression.
Okay. Let me ask you this.
Okay.
Did the defendant and Annamarie end up going to the beach that day?
No.
Now, I want to ask you about another point in time, focusing on that time frame where they were with you after the cruise.
Yes,
Do
ma'am.
you remember, do you recall a time when the defendant was considering going out for a run in a conversation or a comment that she made at that period of time?
Yes.
What do you remember?
Once again, there was friction, and
Objection, Your Honor.
Cara put her sneakers on, continued to run out.
Hold on. So what, if the attorney objects, you have to wait until I rule on the objection. So I'm going to overrule the objection. If you can just maybe ask the question again.
If you could just indicate in terms of the physical observations, the body movements you saw Cara in terms of where she was coming from and what she said.
Came out of a back bedroom, came storming into the kitchen, put her sneakers on, turned to me, said, I will never take Brianna away from you. I want a divorce, and continued out the door running.
Do you remember if Ann was in the room at that point in time?
Yes, she was.
Okay. And Cara made the comment, I want a divorce.
Yes, ma'am.
And I think you said that she also said the words, I'll never take Brianna away from
me. I'll never take Brianna away from you, Auntie.
Okay, so I'm looking for clarification of who she was making that comment to, if that was to Ann or if that was to you.
To me.
Okay,
She was speaking to me in those words.
okay,
I wasn't directed to Ann.
okay. And did she leave at that point to go on a run?
Yes, ma'am.
Now, at some point, did they leave your house and go back to Massachusetts together?
Yes.
Okay. I now want to direct your attention to a different date after the cruise. Is it fair to say that would have been beginning of March or so that they had left your house in Florida?
Yes.
Okay. And are you aware that Ann passed on March 29th?
Yes.
Okay. So I want to ask you about a phone call, if you received a phone call from the defendant in that time frame, after the cruise, but before Ann passed. Do you remember receiving a phone call from her?
Yes.
Now, before you got this phone call from the defendant, had you ever received a phone call from her prior to that date?
No.
Okay. Were you aware at that point if she even had your phone number?
No, ma'am.
Do you remember the date that this occurred?
I do remember. It was a Wednesday before, because my niece passed on a Monday. And there's certain things you don't forget. And I remember that clearly.
Okay, so about 5 days before?
Yes,
or
ma'am.
5 days before?
Wednesday evening, called me, and my niece passed that Monday.
Okay. When you received the call, did you recognize the number it was calling from? The person was calling from?
No,
Did you recognize the area code?
I did.
What was that, if you remember?
413.
Okay, did you know that to be Western Mass?
And that's the only reason I picked up the phone,
Okay.
was because it was 413, and I didn't know it was one of my family members. That's the only reason I picked up that phone,
Okay,
was because I knew the area code.
so you answered the phone call,
Yes, ma'am.
and how do you know it was the defendant calling?
She told me it was her, and
Okay.
she stated who it was.
What did she tell you about why she was calling? What did she say?
When she had called me, she had wanted to talk to me. She had says to me, the only one she's going to listen to you is you. And it was about a dog. You need to tell her I can't afford the dog. We can't afford a dog. And in the meanwhile, the alarm went off.
Objection.
Sustain.
Move to strike.
We'll strike the portion of the witness's answer where she refers to the alarm.
Let me just clarify that. Did you physically hear an alarm sound in the back of the call?
No,
Okay.
but
You're
that's what I
talking-
was told.
Okay, I
So I
understand.
believed it.
Okay. Did she tell you where she was calling from?
Yes, because she hung up the phone and then called me back.
Okay,
That's within minutes. Whatever happened, hung up the phone, then called me back. And at that time, I had asked, where are you? She was at the fire station. She was doing a 24-hour shift that night. And she was at the fire station when I received that phone call on that Wednesday. The date, I don't know, but I know the day, not the date.
okay. So she indicated to you that Ann was the only person you listened to, and there was a dispute about money for a dog.
Yes.
Okay. Did you have any conversation with the defendant at that point about how she got your number?
I had asked
And
because
how
I
did
had
she
never,
respond?
I was under a fictitious name, and
Objection.
Sustain.
Move to strike.
that's what she had told me.
Hold on.
I'm sorry.
So I will strike that last answer. No responses. Hold on. Attorney Sewell will ask you another question.
Thank you.
Did she indicate that she had received your phone number from Ann's phone?
Yes.
Okay. And did she indicate if she had saved your phone number in her own phone?
Can you just repeat that?
Sure. She said she got your phone number from Ann's phone,
Yes.
correct? Okay. Did she say if she had saved your phone number in her own phone?
Yes, my number was in her phone.
Okay. Did she indicate whose name that phone number was under that she put in her phone?
Yes.
What did she indicate?
Some Taylor, John Taylor or something. All I recall was Taylor. I don't recall the first name, but it wasn't Nancy or was it on, or it wasn't me.
Okay. During this phone call with the defendant, she said she was at the fire station?
Yes.
Did she indicate at all where Ann was while she was making that phone call?
Ann may have been home.
Okay,
May have been home.
okay. I think you said just a minute ago that there were 2 separate phone calls,
Yes,
all within a short period of time.
yes.
Do you know why there were 2? In other words, did she say why she was calling twice?
Yes, that she had a call. When you're at the fire station, you have a call. So I'm not assuming anything. She had a call. So she hung up the phone. I didn't question it, and then called me back, and I picked up the phone. I didn't question why, or I didn't think to question why you're calling me back. I didn't know you were going to hang up. So.
When the defendant was telling you that she had concerns about the money for the dog on the phone, how would you describe her demeanor?
Upset.
There.
After that period of time, is that the last time and only time that you spoke with the defendant on the phone?
Yes, no.
I want to ask you about the date of March 29, 2010. Do you remember that was the day that Ann passed?
Yes, ma'am.
Okay. Do you remember if you had any communication with Ann on that date?
I didn't physically speak with her, but there was communication.
Okay, and at this point, you're in Florida, correct?
Yes.
And she's in Massachusetts?
Yes.
Okay, so this would have been over the phone?
Yes.
Do you remember receiving some phone calls from her phone?
Yes.
Do you remember whether or not you answered those phone calls?
I didn't.
Okay. Do you remember what time those phone calls came in or what time of day?
They were early morning, and maybe it was 10:30, 11 o'clock. And then I received another one, maybe 11:30, 11:45 when I looked at my my missed calls on my phone.
Okay. And do you remember, I know you indicated that you didn't answer the phone that day when Ann called. Do you remember whether or not she left any voicemails for you?
Yes.
Okay. Do you remember also receiving any text messages from Ann that morning of the 29th?
Yes, ma'am.
And do you remember, I'm assuming you don't remember the exact wording of the text messages, but do you remember the
I don't.
topics of conversation of the text messages?
I remember the topic, but not the exact words.
Okay, what do you remember?
She had asked about a couple of different movies that were out at the time.
Yes, Sharon.
Basis,
Do you say?
you're saying? Attorney Sewell.
Judge, it's not being offered for the truth. It's being offered in terms of what she was communicating with individuals about that morning, which I do think there'll be additional evidence regarding that.
Okay. Can I see the parties in sidebar?
Sidebar. Take a shot, do a squat. Flashbacks. I feel, oh, bless her heart. Ooh, that's loud. I feel so bad for the aunt. She, bless her heart, she is doing the best she can. She's having to like tiptoe around answering, like they answer questions. She doesn't know how she wants, what answer they're looking for. So she just answers it as honestly as she can. And, oh, I feel so bad for her. She's trying. And you can tell she's nervous. She's a sweet thing. Bless her heart. Yeah, I guess so. I guess this would be the 4th time that I don't know if she testified in every other trial, but I would think probably since she's kind of like, had witnessed how they were with each other right towards the end. So sad. So sad. The thing is, I'm really interested to hear the defense's story about this whole boyfriend who had a whole wife. But the thing is with the restraining orders and the previous issues, that's not something that the jury is going to be able to easily just move on from, or like forget about. Look at Lucy laying on her little rug. She'll get out of that bed sometimes and just. I'm talking about you. You bad dog. The defense's theory, we heard about it a little bit in the opening statements, but the defense's theory was that there was a boyfriend, there was and he was apparently married. So it was like a full-on, when stuff like that happens, I always picture like that old, you remember that show? I don't know if it's still around. I haven't watched TV in so long, but you remember that show Cheaters? Where like they would like, come at you with like a full camera in like a restaurant or something and then chase you out to the parking lot as, somebody's like throwing shoes at you and stuff. Like, you remember that? I didn't dream that, right? That was a show. So anytime they talk about stuff like that, I always picture that happening. Where was the boyfriend's whole wife at the time of the crime? I don't know. See, that's why I have questions. They brought this boyfriend up, and now I have questions. Yeah, I was like, better you than me. This is what you get. Sit there, eat my popcorn.
So the question I have for you is, without getting into any of the content of the text messages that you received from Ann, do you remember receiving some text messages from her in the late morning around 11 o'clock or so?
Yes.
Okay. If I could just have a moment here.
They went into some.
Thank you.
They went into some details about it. Oh, here we go. Oh, defense be nice to her. She's defense be nice to her.
Good afternoon.
I just have a few questions for you. We were texting back and forth. Let me just ask you this. Did you know from your conversations with Annamarie Rintala that she was in some financial trouble?
Yes.
And did you know that she had taken out loans?
No.
Did you know that she had taken out a $20,000 loan in Cara's name?
No.
Did you know that she had 3 credit cards from Marco Zach that she was charging on?
No.
Do you know Paula Daniele?
I do.
Was that a former girlfriend of your niece?
Years ago.
Okay. Did you know that Cara Rintala's credit card, that she was using a credit card from Cara Rintala that she had about $10,000 on?
No.
Can I see the attorney sidebar again?
Sidebar. Michael Lissack. Oof. Lissack. On it. Oh, he took the stand in 2014. Let's see. I'm pulling up the story from when he testified before. Oh, dang. Oh, dang. Got the tea. All right. Olasek worked as a paramedic with Cochrane-Rintala. So he worked as a paramedic with Annamarie, who police found dead in the lap of her wife on March 29, 2010 in their Granby home. Cara is charged with first-degree murder. The first time in state history a woman had been charged with killing her lawfully wedded wife. Okay, defense argued investigators failed to look hard at other suspects, naming Olasek as one. The two text each other flirtatiously, with Annamarie promising a big kiss, quote, big kiss, and Olasek professing his love. However, Rintala's team did not call him to the stand in the first trial, and he did not testify. On Tuesday, prosecutor Steve Gagne, who called Olasek, who lives in Westfield with his wife of 30 years. I bet she wasn't happy about that. He's got a whole wife. He said he met Annamarie on the job 12 years ago and bonded with her because of the nature of their work. We did some very bad calls, citing infant deaths as an example, and they bonded over that. Over time, their relationship developed into an emotional one. They played golf and went to the movies together and sometimes went out for a beer. We had a strong bond. I truly did love her. I bet his whole wife is just loving that that's on public record now. That's awful. Because she was in financial straits, Olasak made Cochrane-Rintala, that's Annamarie, an authorized user on 3 of his credit cards. On one, she ran up a bill of $6,000 to $7,000. The 2 also pitched in for a $20 sleeping bag. There's that sleeping bag to use on the job during overnight shifts. There's that sleeping bag. He testifies that their relationship never turned sexual, although he used the sleeping bag for a while after she died. He said he put it in a box when he cleaned out her locker. That was the last time I've seen it. Interesting. Oh, and it says Olasak's testimony also touched on another person named by the defense as a potential suspect, Springfield policewoman Carla Danielle. Carla and Annamarie had been in a relationship and began communicating again when Annamarie planned to divorce Cara. It was only after Annamarie texted she loved him on Valentine's Day that they resumed their friendship. He appeared uncomfortable on the stand. Well, I would assume he would be. He also acknowledged that he continually deceived his wife about his relationship with Annamarie. You've lived a life of daily deception, the attorney said. At any point, is it starting to dawn on you, Mr. Olasak, that you were being used?
Hey, Aaron.
You may.
Thank you. So during examination, you were telling the prosecutor you were very close with your niece, is that right?
Yes, ma'am.
And you guys talked every day, is that right?
Pretty much.
Or texted every day, is that right?
Yes, ma'am.
And you would tell each other everything, right?
Basically, what we want. Yes, what I thought.
Okay. You would tell her what you thought, she would tell you what she thought, because you guys were like sisters, right?
Yes, ma'am.
Now, in that close relationship that you had with your niece, you said she didn't tell you about Carla Danielle's $10,000 on a credit card debt that she had? Objection.
I'll allow this question.
Thank you. You can answer, ma'am.
Excuse me, can you repeat it?
Sure.
Thank you.
In the relationship that you had with your niece that was very close, she didn't tell you about the $10,000 credit card debt that she had with her old girlfriend, Carla Danielle, right?
I don't recall. I don't recall
You don't
that.
recall her ever saying that?
No, I don't recall it.
Now, when Cara Rintala and your niece and Brianna came to see you, they took some pictures, is that right?
I believe so. I'm sure they did.
And I don't mean to upset you, but I'm gonna approach you with some pictures. So if you need a minute, take a minute.
I need a minute then.
Aw. Aw, bless her heart.
Oh, you want to bring them to me here? Oh, I didn't. Oh, I thought you wanted me to go out and look.
No, I'm gonna bring, if you need a minute.
Oh,
you need
no,
some
I'm good.
pictures.
I could look.
Okay, all right.
I'm sorry.
It's okay if you need to take a break.
No, I'm fine.
Okay. But let us know.
Okay, can you look at those pictures for me, please?
Absolutely. Mhm.
Thank you.
Oh.
Do you need a minute, ma'am?
No, I'm good.
Okay.
Oh.
And ma'am, is it fair to say that these are the pictures that were taken in that visit that you told the prosecutor about when Cara and Annamarie and Brianna went on the cruise and they stayed with you before and they stayed with you after? Okay. I'm just gonna go through them one by one. Do you recognize this picture as a picture that was taken on that visit in late February that you talked about your 50th birthday?
I can't recall where that picture was taken.
You don't?
No.
Do you recall testifying about this picture in another proceeding?
I don't recall.
Next time, Your Honor.
Lindsay Hendricks says, I read a CBS article that said the night before Cara had over a male companion, and Annamarie was floored about it. I wonder if it was said guy with a whole wife. Well,
Now I'm going to show you.
the guy with the wife was
I'm going to show you a transcript of your testimony
Annamarie's.
back on September 20th of 2016 about this photograph.
Okay.
So if you can just read lines 12 through 21 to yourself, please.
Sure.
Yeah, well, that's a good thing because I think the jury would not react well to that instinctively.
Does
You
that
know,
refresh your memory, ma'am, as to whether or not this picture right here
Mm-hmm.
with this marking on it was taken when Cara and Cochrane-Rintala and Brianna came to see you for your birthday?
I'm sorry, ma'am, but even this isn't telling me if I recall this particular picture. I don't recall this particular picture. Even reading this isn't saying that I recall this picture. If you could show me where I can remember, I can't.
Sure.
You told me 12 to
This
21.
picture is marked 37.
Mhm.
And here in this, you say,
You told me to 31 to read.
I'm sorry, I was wrong then.
Oh,
I should have
okay,
said
'cause
more
I-
than that. That was
okay.
my fault.
I stopped.
So, in this case, this is a photograph that was taken about that time of the visit with you,
Okay,
yes.
so that's 9.
And then all the way
9.
down here, this is that photograph.
Okay, so
37.
you want me to read from 9 to 17?
Yes, please.
Okay,
It was my fault, the wrong
not a
numbers.
problem.
I gave you the wrong
We're
numbers.
good.
yeah, because you know, people we're going to be empathetic, and you can't see this poor woman up here without
Once again,
feeling
I
something.
guess
So
I'm going to have to say yes, because this isn't particularly telling me that I recall this picture.
Well, this is the same number on the picture as the exhibit here, right?
Right, but
37 and 37.
Yes, but nowhere here does it say I saw that picture. You're
This is
telling-
your testimony, where
Right,
you say this is the same picture. That's what you say here. You were asked the question, is this a picture of your niece, Cara? And
My
is this
niece
a photo-
Ann.
I'm sorry, this is a picture of your niece and Cara. Okay. And is this a photograph that was taken on or about that time of your visit? Yes. And then this is the photograph,
okay.
number 37.
Okay, I just didn't want, I thought you wanted me to say where this picture was taken.
No, just saying.
Oh,
Do you recognize that then?
Yes.
Okay.
Oh.
Judge, I move to introduce this.
bless her heart. You got this, Aunt Nancy. You're good.
Number 49.
Thank you. And the next photograph, I ask you to look at that and tell me whether or not you recognize that.
I recognize it.
And what do you recognize it to be?
A picture in front of a cruise ship, so that I would take it this was the cruise ship they went on.
Okay, that would have been when they went down to visit you for your birthday?
It may have been, I don't particularly know the cruise ship they went on, so they might have gone on, I don't know if that was the exact same picture. I didn't take it.
Well, didn't you testify previously that you recognize this picture as the one that had been taken at the time that they visited you on your birthday?
I don't recall. I think it's like so long ago, I just can't just picture the picture, and you want me to tell you, and I don't want to say something that I don't recall. I don't want to say something I don't know.
I'm just asking if you remember previously testifying that you did recognize this picture.
Yes, I do recognize it. I don't know where
At
it
a
was
previous hearing, you
taken.
recognized it as the picture that Cara and your niece and Brianna took outside of the cruise that they took when they went to see you on your birthday. Is that right?
Yes, ma'am.
I move to introduce this to.
Can I see the photograph? Thank you, I have no objection. Exhibit number 50.
Yes.
Hey, Judge.
Now, I'm gonna put 3 photographs in front of you now. I'm gonna ask you if you recognize them from the same time period when Cara Rintala, your niece Annamarie Rintala, and Brianna came down to see you for your birthday and went on that cruise. Do you recognize those photographs from that time period?
Every one of them.
Okay, move to introduce them.
No objection. 3?
3.
51, 52, 53.
If I were there and I'd upset, I'd be like, I just need a moment with the judge. Or like a drink with the judge when this is over, and then I'll be fine. Then it'll calm my nerves. Temporary fix.
Yes, can we just be seen briefly?
I don't know the judge's name. He, you know, it might be better that I don't know. Because then if I look him up and he's like a jerk or something, who am I kidding? That's more my type anyway. I feel bad for sweet Aunt Nancy. She's doing good. I'm glad that the defense is like keeping it, you know, keeping it even keel with Aunt Nancy. That would be hard to watch if she was not, you know. His name don't matter. He don't matter. I'm not here for his name, his opinions. I'm just here for his beard. That's all. I like people more when I don't, when they don't talk. So that's why I'm not married. Please explain about the whole wife. So, well, during the Travis Rudolph trial, when she was mad about him texting other girls, I was outraged that she was outraged because I was like, how can she possibly get mad? She has a whole husband at home. She's a whole husband at home. So now it's become a thing. Everybody's got a whole husband, except for the business trial. That one was a little bit like, I said it out of habit and I was like, oh, that's a little, it hit different on that trial. So we tried not to say it on that one. It was different. But other than business, that's been like our thing. You have a whole husband or a whole wife at home. Doesn't apply for that one. I felt really bad too after I said it, and then everybody's like, well, technically. And then I felt really bad. So we tried to not say it during that trial. But other than that, whole husband at home or a whole wife at home. Oh, Tobel says Aunt Nancy reminds me of my Aunt Sally. She and my mom were from Massachusetts. Aw. She's adorable. She's doing good. I think about how frustrating it is. Like she's patient up there. Like, because think about like, you know, how annoying it would be to not want to have to be up there doing this again anyway. And then to be up there and trying to answer the questions, and everything you say, they're like, nope, stop. That'd be annoying. She is. She's keeping her cool, and she's doing a good job. Speaking of keeping her cool, look at Lucy. She is useless. Useless.
So this exhibit that's now been marked
Marked.
49. Could you take a look at this and tell the jury who's depicted in that exhibit, in that photograph?
My niece, show them.
Yes.
Sorry, my niece Annamarie and Cara on the right and on the left.
Thank you.
Sure.
And the same for exhibit 50. Could you tell the jury? I'll publish these afterwards, Judge, so the jury can see them. I just want a witness to.
Sorry, Cara on the right, Ian on the left, and their daughter Brianna in the center.
And exhibit 51.
Myself, my ex-husband, and my niece Ann.
And exhibit 52.
Sure. My 50th birthday at the restaurant, myself and my ex-husband.
And exhibit 53.
Ian, Cara, and Brianna.
Judge, may I publish these to the jury?
You may.
Thank you.
And again, publish is a legal term of art. It simply means that we're going to show these photographs to you. So you can, instead of being on the screen, you're going to have the photographs and you can just look at them and then pass them to the next juror. Keep in mind that these are exhibits, and so you will have them with you when it comes time to deliberate. Also keep in mind that the questioning continues, and so don't become distracted by looking at the photographs. Please also keep your focus on the witness testifying.
I have no further questions, Judge. Thank you.
Okay.
Good. Good.
Ms. Kaufman, did you take any photographs in your house when the defendant and Annamarie were in separate rooms of them?
I don't recall doing that.
Do you remember taking any photographs when the defendant made the gesture towards Ann and her body?
No.
Did you take any photographs when she came out of the room and said, I want a divorce?
No, ma'am.
Okay, thank you. I have no further questions.
I have nothing further on.
All right, you may step down. Thank you.
Thank you.
Good job, Aunt Nancy. Come on back to Florida.
Next witness, Ron?
Please.
Call David Swan.
Every time I'm like, hoping it's the boyfriend.
Legislation.
You stand here, face the clerk, and raise your right hand and sworn.
Do you solemnly swear or affirm that the evidence which you shall give to the court and jury in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, or do you so affirm?
I do.
May I proceed, Your Honor? You may. Thank you.
Good afternoon, sir.
Good afternoon, sir.
Would you please introduce yourself to the jury and spell your last name for us?
My name is David Swan, last name spelled S-W-A-N, and I'm a trooper with the Massachusetts State Police, assigned to the Office of the Attorney General.
You stole my second question. How long have you worked for the Attorney General's office as a member of the state police?
I transferred this past February.
So why don't we do this sort of in chronological order, going back to 1999. Did you start working for the Middlesex VA's office that year?
I did.
And prior to that point, what was your educational background?
I had a bachelor's of science degree in criminal justice from American International College.
And what did you go to work doing for the Middlesex VA's office?
Initially as an investigator for the Middlesex District Attorney's Office, and then it transcended into getting into computer forensics and digital evidence forensics.
How long did you work for the Middlesex VA's office?
5 years, from June '99 to 2004. I forget what month.
And in 2004, did you move on to a different law enforcement agency here in the Commonwealth?
I moved over to the Attorney General's office as a civilian, doing cell phone forensics and computer forensics.
How was it that you sort of ended up or gravitated toward doing cell phone and computer forensics?
It started at the Middlesex VA's office. There was somewhat the godfather of computer forensics in Massachusetts, J.J. McLean.
Objection, Your Honor.
Overruled. Who's Mr. McLean?
He is now retired, but was a Medford police detective and was an expert in computer forensics and cell phone forensics. He had a case, a murder case out of Medford, I believe.
Objection, Your Honor.
Oh, bless you.
What's the basis?
Relevance?
Okay. So we're talking about this witness's background.
We're talking about somebody else's background.
No, I'm speaking to Mr.
Oh,
Gagnon at this
I'm
point.
sorry, Judge, I apologize.
So what is the relevance of this other case? I guess I'm not clear how this is relevant to this witness's training and experience, that background information.
Yes, my understanding is Mr. Swan is attempting to explain how he became involved in and educated in computer forensics. And this is part of his explanation.
Okay, we could keep this segue brief.
Yes.
I'll allow. Go ahead.
So I assisted him on the case that he was investigating in regards to a computer and digital forensics standpoint.
Did you become interested in the topic?
I did.
So what sort of additional training, education, courses, et cetera, did you embark upon to broaden your knowledge of computer forensics?
After assisting Detective McLean, I started taking the best I could the courses available to further my knowledge in computer and forensic, digital forensic.
And did that education and training and coursework continue during your 9 years at the Middlesex Attorney General's office, the Massachusetts Attorney General's office?
It did.
And did you achieve any sort of title or certification or whatnot in this field?
I've attained several certificates in the products that we were using at the time. One of which was Cellbrite, spelled Cellellebrite, and another product from Guidance Software called NCASE, ENCASE.
And are those both programs that help you extract data from digital devices?
Two of many, yes, but
Okay.
those are the primary ones.
Now, in 2013, am I correct that you took a leave from the Attorney General's office to embark on another endeavor?
I did. I left the Attorney General's office and began the State Police Academy on December 2nd of 2013.
How long was the academy?
26 weeks.
And I take it you graduated?
Graduated May 9th, 2014.
And what did you do next?
After a short field training stint at the Brighton Barracks, I was transferred to the Millbury Barracks for approximately 10 months. Then I was transferred to the State Police Detective Unit out of the Suffolk District Attorney's Office.
Am I correct that each district attorney's office in Massachusetts has its own state police detective unit attached to it?
Yes.
Okay. And how long were you with the Suffolk County State Police Detective Unit?
Roughly 9 years.
And where are you now?
Again, in February, I transferred from Suffolk. At Suffolk, I was primarily doing homicide investigations and major felonies, and then transferred to the AG's office in February of 2020.
While you were in Suffolk investigating homicides and whatnot, did you continue to investigate sort of cyber or digital aspects to your investigations?
I did. The knowledge base that I had, having conducted hundreds of cell phone exams and computer forensic examinations, it gave me a skill set that is, helps me in these other investigations.
I would like to focus more directly, sir, on the year 2010. And at that time, am I right that you were at the Attorney General's office?
That is correct.
And am I right that you were focusing primarily, if not exclusively, on digital and cyber forensic type evidence?
Yes.
Now, what sort of services did the Attorney General's office offer to other DA's offices in the state when it comes to analyzing electronic devices?
We were a fully functional forensic lab, so we offered our services to assist in any investigation that they may have, from child pornography to homicide to anything else, bank robberies and the like.
And to your knowledge, did different district attorneys' offices throughout the state have different capabilities in-house, their own capabilities when it came to digital evidence?
Some did, some didn't, but we were there to assist them in any way.
Sir, in connection with the investigation into the death of Annamarie Rintala in March of 2010, did the State Police Detective Unit attached to the Northwestern DA's office request some assistance from the Attorney General's office?
They did.
And what specifically was requested?
They had seized 2 BlackBerry cell phones and requested the Attorney General's office assistance in examining those phones.
And were you specifically assigned, sir, to assist the Northwestern SPDU with that task?
I was.
Am I right that one of those phones was a BlackBerry 9550 quote unquote Storm 2 belonging to Annamarie Rintala?
Yes.
And am I right the second phone was a BlackBerry 8330 belonging to a Cara Rintala?
That is correct.
And do you recall how these 2 phones appeared in terms of their outward appearance, their color and whatnot?
I believe Cara's phone had a pink purplish rubber casing encasing or surrounding it, and then the other BlackBerry, if memory serves me, did not have any case on it.
Sir, sort of going back in time to 2010, 13 years ago from now, is 13 years a long time when it comes to digital or computer-related equipment?
Yes.
Okay, so back in 2010, when you were assigned to assist with this case, how would you have gone about extracting information or examining the contents of these 2 BlackBerries?
I used Cellbrite to conduct a logical extraction from the phone, which provided essentially the low-hanging fruit of the data within the phone.
And what do you mean by that?
So there are numerous data fields and data sets that that a phone keeps. So call logs, text messages, emails, and the like. And so the logical exam essentially gets that stuff if it's capable of obtaining that stuff from the phone.
And how do you actually go about using Celebrite to get that data out of the phone? What does the process actually involve?
So Cellbrite has a physical component and a software application that works in concert with each other. You affix the phone to the hardware portion of the of Cellbrite, and then run the program, and it extracts the data from that phone,
And
it extracts a copy of what's on it. It does not take everything, doesn't touch or alter any of the data. Still resides on the phone.
And in what format does the information that comes out of the phone, how is that presented or stored?
It then is stored in a proprietary format, and then we're able to use the software application to read that data, and then we're able to extract that data in PDF form or other various types of readable format.
About how many times would you say that you used the Celebrite software to extract data from cell phones during your career?
Hundreds, if not close to 1,000. I don't recall, but
Were you specifically trained and educated on how to use Celebrite?
Yes.
And I'd like to ask you about certain types of data and ask you whether or not using Celebrite on BlackBerries in 2010, you were able to extract that type of data in this case in particular. The phone number associated with the phone.
Yes.
Okay. Call logs.
Yes.
And when I say call logs, what do you interpret that to mean?
Incoming calls, outgoing calls, and missed calls.
Text messages.
Yes.
What about MMS? What does that mean to you?
It's a form of it's multimedia service. It's a text message that then may have attached a picture or some other file.
Any pictures stored within the phone?
Yes.
Videos inside the phone?
Yes.
Voice messages?
Yes.
Internet history?
Yes, if it has it.
Emails sent or received?
Correct.
Contact list?
Yes.
And could you also get any data off of any memory cards or SIM cards that might have popped into the phone?
Yes, the SIM card we can get through Cellbrite, and if there's a memory card, we typically would take that out and extract it using Encase.
Okay,
Now,
this is our judge.
What about, nowadays with
This is-
iPhones, Androids, does the term precision location data mean anything to you?
Yes.
And what do you understand that to mean?
I just wanna-
That essentially is the geolocational of the phone, that type of data now, where your everyday Apple, iPhone, or newer Android device is using geolocational data to know where you're at, and also guide you to someplace, something like Waze or something to that effect.
Okay, and that was like a modern day 2023 description you just gave?
Yes.
Going back in time 13 years to 2010 with these two BlackBerries, was that type of precision data available within the phone?
No.
Okay. Now, with respect to calls, can Celebrite detect calls that were placed, meaning outgoing calls from the phone?
Yes.
How about calls that came in, calls that were received by the phone?
Yes.
And what about missed calls?
Yes, it can determine whether or not a call was missed or not.
Okay, now, would whether or not the phone was powered on or powered off change the way a call may show up as either missed or going straight to voicemail, for example?
So if the phone was off, and given the age of these phones, if the phone was off and a call was made to it, it would not show up unless the phone was one on or two. Once it was powered back on, it may come back and say, that a call was missed, or there may be a voicemail that shows no call other.
Okay. With respect to text messages, given these phones in 2010 with Celebrate, were you able to extract text messages that had been sent out from the phone?
Yes.
And text messages that were received by the phone?
Yes.
Does Celebrate have the ability to distinguish whether a text was read or unread?
Yes.
Can it tell you when those text messages may have been read?
It cannot.
Just simply that they had been read?
Correct.
Can it tell you by whom the text was read?
No.
Similarly, with calls placed, calls received, text sent, text received, does Celebrate tell you which human being was actually doing those things?
It does not.
Now, what about some other sources of data that you were able to obtain in this case, and which you obtained in connection with these types of extractions? Specifically, when I say toll records from a service provider, what does that mean?
So the toll records, somewhat of an antiquated term now. It's called call detail records. So those are records kept by the service provider. So Verizon, AT&T, T-Mobile, and they would keep track of, certainly for billing purposes, calls made, calls received, and the like, I guess.
Now, if you're getting all or some of that data out of a phone itself through Celebrate, why would you bother essentially to get what sounds like the same information from the provider? Is that a standard investigative step?
It is, because it kind of bootstraps, and you're able to compare. There's stuff on the phone that you can delete, and you cannot change or alter the stuff that come from the service provider.
And lastly, how about just manually examining the phone itself, like turning on the phone, going into the phone? Can you also do that?
Yes.
Is that considered forensically sound, so to speak, as some of the other methods we've been describing so far?
No, but if there's no other means to obtain that data, it's best to obtain it and photograph it or video that data.
Sir, in this particular case, I believe you've already said that you conducted a Celebrate logical exam of both phones, correct?
Correct.
And you also, there was, in connection with this investigation, call detail records obtained for each phone, correct?
Yes.
And were you able to review and analyze all of that data from both Annamarie's phone and Cara Rintala's phone?
Yes.
This may be a segue point, unless you want me to keep going.
No, it's almost 4:15, so would be a good time to break.
It is.
Okay. So members of the jury, we are going to break for today. I'll ask that you be back tomorrow instead of 9:30, because there is one brief matter that I need to take up, so as not to keep you waiting around more than I already have.
I'll wait on you.
9:30 as opposed to 9. Once again, I instruct you not to discuss this case with anyone, including each other. I instruct you to refrain from any form of outside research or investigation concerning this case or any related aspect of this case. I instruct you not to, or to avoid rather, any contact with any of the participants in this matter. And again, I instruct you to actively avoid any and all media accounts concerning this case. And have a good evening, and we'll see you back here at 9:30.
See, look, we kind of make, look, let me put us. See, we make a good couple. I can see it. Yeah, I can see it. He lives in another state, so I don't have to like actually deal with him. He's good looking. He can give me inside info. Yep. I see it. I can see it.
Anything that we need to take up before we break? Oh, I'm sorry. So, sir, you may step down.
Thank you.
No, let him go.
May I answer your question?
Sure.
Your Honor, I have several exhibits that I plan to use with Mr. Trooper Swan tomorrow. They consist primarily of data charts, which will show the content of communications on each of the two phones, starting the evening of the 28th, going in through the evening of the 29th of March, 2010. I've provided those to the defense in advance, hoping we don't encounter any last-minute issues with those. I've been told, to my knowledge, there's only one objection, and it is to a graphic representation of the data, a chart that we've prepared. And I'm not sure if we'd like to address that now or address it in the morning, but to my knowledge, that is the only issue, the only objection that I expect tomorrow during Trooper Swan's testimony.
Okay. Does it make sense to address that now, or at least to begin that discussion? I assume that if it involves making some change to that chart, it's something
Yes.
that you would need some time
That would be helpful,
to
Your Honor.
achieve.
If I may hand up through the clerk. This was admitted. This was actually introduced as an exhibit at the third trial. And what this chart represents is on the date of March 29, 2010, between the hours of 8 a.m. and 8 p.m., this is a graphic representation of the activity, the user-initiated activity on Anne-Marie's phone. And what I mean by that is this is when the phone or the person holding the phone is actively doing something with the phone, whether it be sending a text, making a call, taking a photo. And the significance of this is that it shows a timeline of her activity throughout the morning. This is in 15-minute increments. It shows when her activity was at some higher points than others. And it shows that the last action taken with that phone was at 12:21 p.m. That's when she placed an outgoing call. The phone placed an outgoing call. The evidence will show that was to Nancy Kaufman in Florida. And from 12:21 p.m. onward, there is, as shown in the chart, no activity. So this is a graphic, visual representation of data and testimony that we intend to elicit through Trooper Swan. We think it's important to help sort of corral and marshal the evidence. And also, it is relevant, highly relevant to the timeline of the day, what Anne-Marie was doing during certain hours and not doing during certain hours. This is also evidence that the medical examiner, Joanne Richmond, has already referenced that she reviewed, and we expect that Dr. Thomas Andrew will also testify that he reviewed. They took this information into account in formulating whether or not their time of death estimate was accurate or whether it corroborated their time of death estimates. So for those reasons, we don't see any prejudice to this. It's all firmly rooted in the evidence. We don't think it's prejudicial in any way, so we ask to admit it.
Okay, so just so I'm clear, you're seeking to admit this as an exhibit as opposed to using it merely as a chalk. Is that correct?
Yes.
Okay. And you're telling me that there are other records that will be in evidence that were used to compile this?
Yes.
Okay. Attorney Scapiccio?
Because I don't get to tell the Commonwealth what to do with their own exhibits. I understand that. Well, this to me seems not a complete picture. So this, they're saying, is a picture of Annamarie Rintala's texts and phone calls made from, they say 8 in the morning till 7:15. They don't have on this graph anyhow, and there's no graph to my knowledge that in existence, as to the incoming texts that were coming to her phone. And that's why I think it's somewhat misleading, Judge. And they get to do whatever they want. I understand that completely. I want to make sure. And then in terms of how this chart was generated, and what was used to generate the chart to make it way up at, I don't know what 8 means. I don't know what 1 means. I don't know if it means 8 calls, 8 texts. I just don't know, Judge. So to the extent that this was generated by this witness, I would suggest, Judge, that the information is a little incomplete, and I don't know that we need a visual picture of the phone calls. We're gonna have the phone calls, we're gonna have another chart that they have, Judge, which I also think I had an objection to that.
I haven't heard.
So they have a list of partial phone calls, Judge, that they cross-reference with a bunch of photos of receipts that they find. So I'm just saying, Judge, with respect to this, I'm going to try to keep it to this. I can't tell them what to do. I'm just noting for the court that I don't know how this is going to get explained to the jury. I don't know. I certainly can cross-examine on what's not contained in the report. I get that completely. I'm just saying to put this on the screen as this is it. This is all that happened with that phone, I think is misleading.
Okay, so you said there's another chart that you're objecting to?
Well, there's another chart, Judge, that I think I sent a notice last night saying that we would object to. I'm gonna look at that today and make sure that, let me take another look at it, Judge, before, sorry, I didn't mean to say when I was speaking to you. Let me take a look at it tonight to make sure that, I think that's the one. It's not, okay, all right.
The other chart is not coming in tomorrow, and I'm ready to address it right now.
So the only chart that the Commonwealth is seeking to introduce tomorrow would be this,
To which they have an objection.
to which the defendant has an objection. And what are you asking me to do? To simply exclude it? Or is there, here's my question. I don't know because I haven't heard the evidence. I haven't heard the witness testify about what went into this chart. So it's kind of hard for me to say whether this is somehow misleading or it's prejudicial because it leaves certain things out that one would expect to see in a chart like this. I just don't know. So I don't know what you're asking me to do. If you are simply objecting to the introduction of this, that's one thing. As opposed to you're arguing that if this is going to come, it needs to sort of be more balanced and show a more complete picture, and the Commonwealth needs to add certain other things.
I can't make the Commonwealth add anything to their own exhibit, Judge. I get that. I'm just saying, when we're talking about, cognitive bias, when we're talking about inherent bias, when you see a photograph or a chart like that, it doesn't have all of the information in it, and that's the first thing you see as a jury. You start to form certain opinions, and again, that's my concern, Judge, is that if it's not complete, if it's not balanced, and they start forming opinions based on this one little snapshot of what the Commonwealth wants them to focus on, I can certainly cross-examine on what's not contained in there. But to have that photograph of this chart in evidence, I think is prejudicial, Judge, and I'm asking you to exclude it.
Okay, well, at this point, I don't know that I know enough about it because I haven't heard anything from this witness about how it was created or what it represents. So it's premature for me to rule on that objection. But I'm happy to get a heads up, so I'm prepared to sort of evaluate the testimony, understanding that objection is coming. So is this a copy for me, or do you need this back?
You can keep that.
Okay, thank you. So I guess we'll address that when the time comes tomorrow.
And then the only other thing, Judge, is just to line up for tomorrow so we can be ready. Again, we're trying to coordinate our witnesses, and I know the Commonwealth still doesn't know when they're going to rest, but I'm trying to make estimates here so I can rebook flights.
It's hard to tell.
It is. I'm not suggesting anyone's doing anything wrong.
Sure.
Your Honor, at this point, we will obviously continue with Trooper Swan, and then we expect to call Detective Lieutenant Robin Whitney with 3+ hours of video. I don't think we'll get farther than that tomorrow.
Okay. Well, that's sufficient for the lineup that you would represent. I suppose it might be a good idea, just given how things have gone so far, to have a few people waiting in the wings if necessary, but I'll leave that to you. Okay, anything else before we adjourn?
No, Your Honor.
No.
All right. See you tomorrow at 9.
Thank you, Your Honor. Thank you, Madam Clerk.
For all rise.
Blood pressure rise. Court rise. So tomorrow at 9, we'll be back with McDreamy over here. Yeah, we have, it's so funny here. We're so funny. This has been a day. It has been a good day with my peeps. I had fun with y'all today. I am Miss Bobby says I'll be there tomorrow. I can pass along your info. I'm all talk. Look, I'm all talk. I will sit here and laugh and talk crap about his chambers and whatnot. But I am all talk. I am all talk. I am too busy to take care of somebody else's son. So I just think it's funny. But I will definitely look. But I enjoy looking a lot more when I don't have to wash their underwear and do their dishes. All right. Wait, did I say something? Nobody's listening to me right now. Nobody's listening to me. Yeah, it's funny. But he is a handsome fella, and I am a sucker for blue eyes and a beard. It reminds me of my ex, not the one, but the one that I'm still very close to, love him to death. I love that, like those baby blue eyes and a beard. Love it. Love it. Love it. I am Amanda Davis said, I've got to remember your Brandyisms. I don't want to raise someone else's son. Yeah, been there, done that. He's a handsome fella. He's a handsome fella. I'll tell him he can be March in the. It's like we're literally to like March 2048 or something at this point. Like that's how far we are. Judge Daddy. Rima said I'll raise him. Oh, y'all are cracking me up. Oh, cracking me up. Yep. All right. So they will be back in session tomorrow at 9. Unfortunately, on Thursday and Friday, you'll have to hang out with Judge Daddy without me because I will be Thursday. I will be traveling, and then Friday I'll be at Comic-Con, not Comic-Con. Took my kid to that one year. CrimeCon. So I will be everybody getting fresh. We're everybody getting fresh. So Thursday. So unfortunately, Thursday and Friday, you will have to hang out with Judge Daddy without me. So I will miss y'all, but we can pick right back up on Monday. But I will be here tomorrow though, and Wednesday. I am going to wrap up here, say our goodbyes because I need to get the episode of podcast recorded so that I can get it out tomorrow and y'all make sure to listen. I gave y'all a little sneak peek of it today. Krista Ranges, welcome. Thank you for the super chat. I've been lurking for weeks, but this judge and all of you making me smile so much has made me come out of hiding. Yay! Welcome out of hiding. We're glad to have you. Yeah, it's the eyes, isn't it? It's like come on out, Twisted Branches. Come on out. Come hang out with us. Come on out. He does have some pretty eyeballs. He does. So thank you for the super chat. I appreciate it. And the other super chat was hilarious too. Thank you for streaming this trial. And Marie Moss's count on testimony. So funny. Y'all crack me up. His name is the Honorable Judge Francis Flannery. Name's not as cute as he is. Not that his name's not cute, but it's not one of those that like rolls off your tongue. Francis Flannery. I think of Flannery O'Connor, who, you know, being from Georgia, she's obviously like, you know, being from Georgia, I'm going to think of, you know, Flannery O'Connor. But he goes by Frank. Frank I can handle. All right, Frank. Hey, Frank. Hey, Frank. Can we get in trouble for sexually harassing? Maybe. Look, if some of the trolls can get away with saying the things that they say online and not get in trouble, then I think us complimenting Judge Daddy over here should be fine. Chat's gone off the rails. Off the rails. Oh, y'all crack me up. I appreciate it. Yeah, he would love this attention. He would love it. He'd be like, what, me in my robe? What? It's all that jackhammering. It all went downhill after that. All right, so tomorrow morning we will do, we'll get started about the same time. We'll do about 10 till 9. They're going to be there at 9, so we'll do about 10 till and get our party started. And don't forget, tonight we have, I need to start. We could interview him, but I would be like, we'll see. I can be professional. Like, so tell me, what kind of cologne do you wear? I'm just joking. So tomorrow, 9 a.m., we'll start about 10 minutes early. And then don't forget, tonight is night court with Brother Brewmeister. So make sure you show up for that. 8:45, 7:45 Central. And that is always a good time. So I am going to get going so I can get this podcast recorded. We obviously can't. I would have to turn off the chat. I would have to make it to where he can't see it, but also to where I can't see it, because then y'all know how I am. So I'll get embarrassed and I'll turn bright red. So yeah. But yeah, Lucy is no longer the screensaver. Now it's Judge Daddy over here. I'm just joking. She don't care. She ain't listening to me. All right, so night court tonight, and then we will be back with Judge Daddy tomorrow. Auntie Katie's going to make meatballs. Ooh, meatballs sound good, actually. I appreciate y'all hanging out. Thank you so much. Thank you for the super chats. Please, if you have not hit the like button yet, please do so on your way out. I appreciate it. It helps us so much. I didn't even withhold Lucy or Beach Cam from y'all today for it. I was well behaved. So, but night court tonight. Tomorrow we'll be back in the morning, and then tomorrow, episode 2 of the podcast. If you have not listened yet to Controversy in Canton or Conspiracy in Canton, the controversial case of Karen Reed, it's Conspiracy in Canton on 13th Juror podcast. If you have not listened to it yet, listen to episode 1 tonight, because episode 2 will be out tomorrow, and it's a doozy. So I appreciate it. Thank y'all so much. I love you all. I have the best time with y'all. I really do. So I appreciate y'all coming and hanging out with me all day. She hears me saying goodbye, and she knows she's about to get taken outside again. She's a smart dog, y'all. She's a smart dog. Maybe you'll go back on the screensaver because you're so smart. All right. Thank you for reporting to jury duty, and I will see y'all bright and early in the morning.